All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 9th, 2024. We have 15 bills on the docket and over 150 witnesses. So we are going to go in the proceeding order. We're going to start off with Senate Bill 585. Senator Simon Ayer, I see you're here. We will then go to Senate Bill 496, 501, 549, 555, 470, 554, 435, and 744, and we'll figure out the rest as we go on. Number 10 will be 741 or 471. All right, so with that, is Senator Simon Ayer here? Come on up at your leisure. Thanks. You can don't worry about the yeah. Do you have a panel that you'd like to bring up as well, or is it?
Yeah, Brian can go with Brian Slattery can go after me, and then whoever wants
okay,
to go.
if Mr. Slattery would like to come on up if he's here. Come on up.
Actually, I'm going to let him come after he.
Okay, understood.
You want to sit?
Okay, fair enough. All right, Senator, the floor is yours.
Well, my hat's off to you, Senator Brian Simon Ayer, for the record. 150 witnesses. That's pretty impressive. On a Friday as well. So I will try to be brief. Yeah. Given the exclusiveness of my bill is in the natural resources article, I went and got a majority of the EEE committee to co-sponsor it. Then I dropped it and found out it came over to JPR. So you all are welcome to co-sponsor. Just want to put that out there. So Senate Bill 585 is a simple, and I don't believe it has any opposition, so I'll be brief. The Natural Resources Article, Maryland State Voting Act, was enacted in 1960 and has been updated ever since. This bill adds language and penalties for hit and run that occurs on water into the Maryland State Voting Act that mirrors the penalties that we have in the transportation article and tailors it to the water. For a boat operator involved in an accident, currently there is a duty to render assistance and provide information. It should be noted, though, there is no specific penalty for not rendering assistance or, by extension, leaving the scene. So it falls under the Natural Resources Article catch-all penalty provision that provides a maximum penalty of just $500. Additionally, there is no penalty for hit and run as it pertains for a person knowing it might result in serious bodily injury or death, as in the transportation article for vehicles on our roadways, which rightly so carries much higher penalties. In the Natural Resources article, a hit and run that causes death receives a maximum of only $500 and no jail. In the transportation article, the same crime receives a maximum of $10,000 and up to 10 years in jail. This bill creates parity and equity with vehicles and vessels regarding hit and run by mirroring the transportation article for the Natural Resources article. We have been in discussions with DNR, and we support their amendment that deals with updating a reporting requirement and contacting law enforcement. In the spirit of brevity, I will close by saying my constituent will share how they personally experience the lack of meaningful penalties for hit and run incident on our waterways. While it will not affect them, it will be very meaningful to those in the future. This is common sense legislation, and I ask for your favorable consideration.
Thank you very much, Senator. Questions? Sure, go ahead, Senator Muse.
Simon and I, we came in together 18 years ago, and I came in actually 4 years before that and then left. And the glutton for punishment, I came back. I mean, because I really wanted to, I came back. And he's been my friend for over 20 years, and I just wanted to welcome him.
And we served 4 years.
He was on this committee with me.
God bless you.
back in 2004 and 6, something like
Seven.
that. Yeah. So he knows all about the committee.
Good talk. All right, Senator West.
Thank you, Mr. Chair. In my packet, there is an amendment, a proposed amendment. I'm assuming it came from the Department of Natural Resources, but I don't know.
Yes.
Have you seen the amendment? Is it
Yes, we're in
something-
agreement with that. We've been in discussion with them.
Okay, so friendly amendment.
Yes.
Great, thank you.
All right, seeing no further questions for the committee. Thank you very much, Senator.
Thank you.
Thank you. Have a good weekend. All right, we'll now hear from Mr. Slattery, Carolyn Gramis, Patrick Gilbert.
I'm Brian Slattery. I'm the reason this bill is being introduced. The guy ran over the back of us, fast enough to land on top of my boat, crushed my girl, and then he left. And he's serving very little time for this. And, you know, it should be, it's the same as on a car. You know, you can't just kill somebody and run and not get punished. So that's really all I gotta say. It's just, thank you.
My name is Carolyn Gramis. I am an assistant state's attorney. I am the prosecutor from the Slattery case. One of the investigating officers is behind me as well. This is a case where, as Mr. Slattery just said, a boat overrode his boat, killing his wife, fled the scene. It took us over a month to figure out who the operator of the boat was. We were able to find the vessel pretty quickly, but determining who was operating it, and it was a trial, but I could not get him for fleeing the scene, which is in a vehicle 10 years. But it's a loophole in the law that allows an operator of a vessel to flee the scene without making any attempts. And that's in fact what happened to the Slattery family because of this lapse in the law. I ask that you find favorably. This actually happens a lot more often than you believe. But the prosecutors cannot do anything because it doesn't mirror the traffic law, and it should. Just as catastrophic as vehicle upon vehicle collisions. And I ask that you find this bill favorable and that it will continue and change lives. It will not change anything for the Slattery family. He is serving 18 months for criminally negligent manslaughter. We were able to convict him of that. He waived his pretrial credit, but it does not equal what is lost by the Slattery family, the loss of a wife, a mother who suffers the consequences of this voter's actions. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair. My name is Patrick Gilbert. I'm a senior assistant state's attorney in Wycomico County, and I'm here this afternoon on behalf of the Maryland State's Attorneys Association to urge a favorable report on Senate Bill 585. I like to read the bills that go through this committee. As the chair observed during a little bit of a heated proceeding last week, we're all here to try and make life better for Marylanders. And although we may disagree on how best to do that, I think it's really inspiring to see all of the creative ideas that come through this committee. But when I read this bill, though, I had a little bit of a different reaction. I had to stop what I was doing and pull up a Westlaw tab to see for myself that fleeing the scene of an accident involving a boat was not a crime in Maryland. It's not. And as you've heard today, and as I've heard in conversations with my colleagues in other coastal jurisdictions, just before this hearing, I got an email from a colleague in Somerset County who described an incident very similar to the one you've just heard about, a vehicle collision that had resulted in one occupant losing consciousness and being ejected from the boat, the at-fault boat fleeing away, providing of enormous investigative resources to apprehend the person responsible, with the result being the equivalent of a traffic ticket, $500 fine. Requiring parties to remain at the scene of the collision serves important purposes such as identifying the who, what, and why of the accident, and making sure that people are safe, which is that much more important when you're on the water and you can't sort of get out of your car and wait for an ambulance to get there. There's not any getting out of the boat when you're on the water. Someone might be injured after a collision and their vessel rendered inoperable. And when the at-fault party speeds away, there's nothing that we can do. Right now, Natural Resources 8724 is a suggestion. It's not a law. And this bill changes that. And that's why we're urging a favorable report. I yield to the committee's questions. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all very much. Thank you. All right, that concludes the testimony for the proponents of the bill. We'll now switch over to favorable with amendments, and it's Michael Godek or Godek.
Good afternoon. I'm Sergeant Godak with Maryland Natural Resource Police. I supervise our criminal investigation section. This particular bill and the amendments help to protect boaters on Maryland's waterways by providing consistent reporting requirements for vehicle and vessel collisions, as well as consequences for violating those laws. Immediate reporting aids police emergency response to maritime incidents so that search and rescue, medical treatment, and police investigations can occur as soon as possible to preserve life, limb, as well as evidence and any navigational hazards to other boaters or commercial and international traffic. This aids in the investigation and prosecution of responsible individuals by stating consequences for failing to report, remain on the scene, or render any aid consistent with the traffic laws. All of these factors are compounded by the dangers on the water, such as underwater obstructions, currents, weather, and the fact that injured and incapacitated victims are in extreme danger when they enter the water without life jackets or other life-saving devices. This bill and the amendment aids our agency's ability to respond to collisions to save lives and holds at fault parties accountable, parties responsible for their actions. I thank you all for your time. Happy to answer any other questions or assistance needed.
Appreciate it. Thank you very much. Questions from the committee? Seeing none, thank you very much. Thank you. With that, that'll conclude the hearing for Senate Bill 585. Is Senator, we're looking for Gallion, is here. Senator Quarterman here? Not, we can go on to Senator McKay. Are you ready to go? All right, I'm gonna go to Senator McKay with Senate Bill 501.
Mr. Chair and committee, for the record, Senator Mike McKay, sponsoring Senate Bill 501. This is handguns, wear, carry, transportation laws, handbook publication. 501 requires the Secretary of State of Police to annual and publish a handbook summarizing the state laws relating to wearing, carrying, transporting handguns in the public. Also requires the Secretary to make copies of the handbook available to the members of the public. Handbook should begin publishing annually October 1st, 2024. This passage of this bill will ensure that materials, reading, and proper education of firearm ownership laws in Maryland are widely available to firearm owners and those looking to purchase a firearm. Bill would benefit public safety and regarding firearms by promoting education on the laws and regulations in the state. Education is the key. Repeat, education is the key for safe firearm usage in our state. It would keep the citizens up to date on the laws regarding our firearms, as well as foster public well-being. We have an amendment that we have drawn up that we would like to submit. And that's basically just clarifying the summarization, that type of stuff. There is another bill in the House, very similar. However, there are a couple little differences. And we believe that this bill really should be not necessarily in paper, but it just needs to have a link that can be shared with people so that they'll be able to get the most up-to-date. Answer any questions you may have, but ask for a favorable passage for Senate Bill 501.
Excellent. Thank you very much, Senator. Seeing no question. Do you want to wait until after your panel comes up, or do you want to questions now? Do you want to take questions now? Or do you want?
That's fun. Well, why don't we bring the panel up?
All right.
If that's okay.
So we have Mr. Pennick and then Mr. Jocelyn.
Chairman, Mark Pennick, President of Maryland Show Issue. I appear before you today in strong support of this bill. I'm an attorney. I'm an expert in Maryland gun laws and laws associated that are covered by this bill. Attached to my written testimony is a 70-page brochure that the Maryland State Police have already issued on this subject. This state already requires, as detailed in that written testimony, that every bill related to guns be distributed to wear and carry permit holders. This bill is last year in HB 824. This body commanded the state police to develop a curriculum for the wear and carry permit. I teach that. I have it. It's attached to the written testimony. It's a simple matter for the state police to do what this bill commands. It will simply be an edit of what they've already done. It is critically important. I can't tell you the number of questions I get every day as an attorney that reflects a fundamental misunderstanding of Maryland's extraordinarily complex laws. And there's no doubt about it that it is extremely complex. They're traps for the unwary. Education's the answer. MSI is devoted to that subject. We have links to our website where we list many of these laws and regulations. It's not even close to being good enough. I would urge the committee, this is a feel-good bill. It's a good government bill. There's no downside to this. The burden on the state police is minimal. They've already done it. So I would urge the committee to issue a favorable report.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is John Jocelyn, speaking for 2A Maryland. We support this bill. When House Bill 824 was passed, there was an amendment added in this body that compelled the Secretary of the State Police, in cooperation with the Attorney General and the mental health people, to compile a teaching curriculum. That they did. Unfortunately, from the time the amendment was requested to the final language, it put the entire responsibility on the Maryland State Police for the law section. And they are not subject matter experts. The Attorney General is. What this bill would do would be to place it in the Attorney General's purview that he could supply to the state police, and then they would compile it in the rest of the document. In order to teach properly, you have to be able to relate from the known to the unknown. And when it comes to matters of law, we need to be able to teach a document that the average citizen can understand. Reading the statute's one thing, understanding it is something else. This bill will address that issue and make it widely available. On my website, I have a compilation of Maryland's gun laws that I did first as a tool for myself and then realized it was useful for everyone else. It's one of the most popular links on any email I send. It's called Maryland Gun Laws 2023. It's updated annually. It is 283 pages long and weighs 3 pounds, but it is the total compilation of all the applicable laws in the state of Maryland. This bill would address those that are specific to wear and carry. So it'll be much more precise, much more concise, and easier to teach. As it is right now, it takes about 8 hours to teach the law section. I would also recommend that you consider removing certain sections of existing statute under the 501-306 under A1 items 5 through 10, because they are not germane to wear and carry, and they just create, more confusion and more clutter in the teaching process. We need to streamline it and make it user friendly. We ask for a favorable report. Thank you very much.
Yes, I did for the sponsor. In my packet, I've got two different amendments. And are you offering two amendments or has one been supplanted by the second? It looks like they're both prepared by Legislative Services on the same day, on February 8th. But they're different.
So I'll have to get clarification on that. I believe it's just the one amendment. I don't want to throw anybody under the bus from DLX, but there's been a lot of work going on.
Oh, I know.
So,
Exactly.
and the clarification may be in my office, but we'll get clarification for that and get that to you and the rest of the members of the committee.
Okay. And then I got a question, I guess, for Mr. Jocelyn.
Uh-oh.
You're done. You're off the hook. You better go back to the rostrum because we can't catch you on camera here. So I see this long attachment to your testimony. And it looks like it's prepared by the state police. Some state agency prepared this. It's many, many pages long. Is this the state, was this the product? of
There is
state
the
police?
501, 5-306. Is that the one you're referring to, Senator?
Well, I don't know. It's there's 71 pages long. It was attached to your testimony. Am I correct in that?
I don't think it was.
Maybe it's Mr. Pennick's testimony.
That would be mine, Senator.
Okay,
Yes,
why don't you-
that
why
would
don't
that
you-
would be the state police's training curriculum.
Okay,
Yes. And
Okay.
71 pages would be correct. That would be it.
so I haven't had a chance to read the 71 pages. Is there a legal section in here and is it written in plain English that ordinary people can understand? Or is it,
Yes,
does
there
it need
is.
to be rewritten in easily understandable language?
It is in there. It's 30 pages long. And essentially what it does is it covers case law, which is not statute. And that's difficult to explain to people when you're not an attorney. It then goes into the actual law, what the statutes are. And then it goes into what were called pattern of jury instructions, which are something that until this came up, this bill last year, I thought the jury instructions was something that were customized to every jury by the judge. I didn't realize there was a pattern to it. So this is an absolute new twist that I, as a non-attorney, had never even heard about. And as an instructor, I'm really not sure how I would explain this to a student if they asked me a specific question. And we need to be able to give them very honest, concise answers that they can understand.
All right, so what you're asking for is for this material to be translated into plain English
Yes.
that an ordinary person can understand.
Just as we've done on the state website where you have the hearing instructions, where you have it in the formal, and then you have an informal, and then you have a really simple with a lot of visuals to it. This would basically be an adaptation of that concept.
Okay, thank you very much.
Excellent. Further questions from the committee? Oh, yes, Senator McKay.
Follow up on his
Sure.
question on that.
Of course.
You want me to do that or is that?
Yeah,
just
go ahead.
fine?
You can do it on record. Go ahead.
The good book talks about knock and ye shall and answer and all that kind of stuff. If you actually open my file, the answer your question is in there. So yeah, we do have two amendments. One strikes the Secretary of the State Police and substitutes the Office of the Attorney General because that's actually where it resides in. It's they are the ones. Second of all, publish, we're inserting in print. And after that, again, Secretary of Police, we're inserting certain permit holders and in a certain manner. And then the other amendment just basically inserts the same and trying to do the clarification of the Secretary and the Attorney General. So it's very, very benign. All right, thank you, sir.
Excellent. Thank you. Thank you, Senator McKay. With that, that'll conclude the hearing for Senate Bill 501. We're now going to move on to Senator Gallion with Senate Bill 435. Senator Gallion, welcome. You want to bring up your panel as well at the same time? Or?
Good afternoon, Mr. Chair, Vice Chair, and committee members. For the record, Senator Jason Gallion, here to introduce Senate Bill 435, Criminal Law, Crimes of Arson, Prohibitions and Penalties. Simply put, this legislation would create a felony charge for intentionally committing arson that causes an injury to a firefighter during the response to the fire or efforts to suppress the fire. A violator is guilty of a felony and subject to imprisonment not exceeding 10 years. I have a forthcoming amendment that would add a sentence not exceeding 20 years for an arson violation that leads to the death of a firefighter. You all may recall the tragic events in Baltimore City on Stricker Street on January 24th, 2022, where 3 of our brave men and women lost their lives battling a vacant house fire that was later determined to be the result of arson and their deaths being ruled homicides. Lieutenant Paul Boutram started his career at the Joppa Magnolia Volunteer Fire Company. I attended that viewing. Acting Lieutenant Firefighter Paramedic Kelsey Sadler started her career at Falston Volunteer Fire and Ambulance Company, which happens to be in my District 35. And Firefighter Paramedic Kenny Lakaya started at Wheaton Rescue Squad. So not only were they Baltimore City firefighters, they had connections also in the volunteer fire service. The Maryland Fire and Rescue Services Memorial opened here in Annapolis in 2006, and it recognizes Maryland line of duty deaths, both of career and volunteer members. I encourage you all, if you haven't taken a stop there, if you know where Comptroller Goldstein's statue is, you look right across from it, and we have that beautiful memorial there that a lot of folks I talk to don't even realize is there. So I'd encourage you to take a look at that. Now, my background, why am I the one bringing this bill to you today? I'm not in JPR very often, as you know. I'm glad to be here today. I have a 30-year career in the volunteer fire service at level in Harford County, and I've served in various roles in that department. I've been on the board as a president where I made sure proper funds were allocated for things such as personal protective equipment, turnout gear, make sure if we needed fire trucks, stuff like that. I've been the engine driver. I've been the guy outside making sure the person inside has water for that fire to put that fire out at the right pressure and whatnot. I've also been the firefighter inside there on the nozzle, what they say, putting the wet stuff on the red stuff. Done that. But I also served as the chief of the department for 6 years. I know what it's like to be the incident commander, and I know what it's like to send a lot of times 18 and 19-year-old young men and women into to fight an interior attack on a fire. And that's the toughest part of my time in the fire service, is having to do that. So that's why this legislation is so important. If God forbid one of those people that is sent in to do that were to get injured or perish because of a fire that was started by arson, these would be, I feel, more appropriate penalties. Passage of this legislation will make it abundantly clear that when you decide to commit arson, you will be running the risk of a felony charge if a firefighter is injured or loses their life in the process of stopping that fire. I respectfully ask that the committee issue a favorable report with the forthcoming amendment to Senate Bill 435 to hold these arsonists accountable for their actions. Thank you.
Thank you very much, Senator. And we're going to hold for questions until after the panel. So we'll hear from our state's attorney, Mr. Gibson first, and then we'll move on to the panel.
Good afternoon. My pleasure to be here. Rich Gibson, state's attorney for Howard County, president of the Maryland State's Attorney Association, been a prosecutor for 20 years, here to ask for a favorable report for Senate Bill 435. Currently, there isn't a consistent mechanism by which we can hold individuals accountable when they set a fire and first responders, firefighters, respond and are injured and or killed in the process. The profession of firefighting is inherently dangerous, but the people who are in this profession are placing themselves in harm's way to protect property and lives of others. If someone intentionally sets a fire, there should logically be a consequence that accompanies that if the person who responds gets hurt, all right, and or dies. The laws as they exist right now do not adequately provide a legal mechanism to attach liability and criminality to that conduct. We have had 3 cases in Howard County where officers have been injured. One of my prosecutors, Colin Campbell, is here. He prosecuted one of those cases and can share his experience in handling that matter and why the laws that exist now are insufficient. We are asking for a favorable report as to Senate Bill 435. Thank you for your time.
Good afternoon, Mr. Chairman. My name is Jeff Buttle, President of the Professional Firefighters of Maryland, the state level affiliate of the International Association of Firefighters, representing more than 10,000 active and retired firefighters and emergency medical services personnel who proudly serve the citizens of Maryland. I'm here today in support of Senate Bill 435. No local affiliate leader ever wants to get the 2 a.m. phone call that something terrible has happened to one of our members. This is especially tragic when it involves the line of duty death of a firefighter. These events leave an unfillable void in the lives of the families of our fallen heroes and forever changes the lives of their brother and sister firefighters. Currently, under Maryland criminal law, there are no additional penalties that cover the injury or death of a firefighter responding to a fire or one that is determined to be arson related. It is important to remember that the arson related crimes as defined under Maryland criminal law are considered willful and malicious acts. This legislation with the sponsor's amendment would add additional criminal penalties for those willful and malicious criminal acts that result in the injury or death of a firefighter. On behalf of the members of the Professional Firefighters Maryland, we hope that this committee will give this important piece of legislation favorable consideration. Thank you, Mr. Chair.
Good afternoon. Thank you, Chair, Chairman Smith, Vice Chair Wallstrecker, and as well as Senators Gallion and Folden and the members of this committee. My name is Matthew Coster, and I'm the president of Baltimore Firefighters Local 734. Over the past 2 years, our department has suffered significant losses with the line of duty deaths of five of our members. Paul, Kelsey, Kenny, Dylan, and Rodney are the reasons why I'm here today. According to a study done by the Baltimore Sun, Baltimore vacant buildings burn more than twice the national average. Our members go into these buildings to save lives and property without hesitation, not knowing what may lie ahead. Arson plagues our city and is obviously a hard enough case to prove. However, the current law to hold those accountable for intentionally setting fires that result in the injury or death of firefighters is just simple. It is not enough. Supporting this bill to increase penalties for these heinous acts is a crucial step in getting justice for our members and their families. These higher penalties will send a clear message that this kind of crime will not be tolerated and these criminals will be held accountable for their actions. I wholeheartedly support a favorable report to Senate Bill 435 and look forward to continued conversations. Thank you.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and esteemed members of the Judicial Proceedings Committee. My name is Josh Fannin, and I am the president of the International Association of Firefighters Local 964, Baltimore Fire Officers. I am before you today to speak in favor of Senate Bill 435 while recommending consideration of the friendly amendment. The crime of arson is a particularly violent and malicious crime that is too oftentimes overlooked in public discourse. It destroys people's most treasured property, their homes, and in the worst cases, it takes their lives. Additionally, firefighters are called to extinguish arson fires with the zeal and dedication of any other. This requires them to put their own lives on the line in order to protect the lives and properties of another. Regrettably, this can and has resulted in firefighters being injured or killed in the course of their duties in suppressing an arson fire. As a firefighter and as a union president representing firefighters, I took some comfort knowing that the law had a deterrent effect to arsonists by holding them accountable for their injuries and deaths of firefighters that resulted due to their actions. Unfortunately, I was mistaken in this belief. No such protection currently exists. Passage of this legislation would correct that error by holding arsonists rightfully accountable for their actions when they injure the brave men and women of the fire department. I would respectfully encourage this committee to also consider what I believe to be the friendly amendment from Senator Gallion to include the penalty for death of a firefighter to the proposed bill. This would create the deterrent for arsonists from committing those heinous crimes that can foreseeably result in firefighter injury, as well as death, while justly holding those accountable who do not comply. On behalf of our firefighters throughout the state of Maryland, thank you for your consideration of this bill to protect these brave men and women. Thank you.
All right, thank you very much. We have a couple questions from committee members. I saw Senator Muse first and then go to Senator McKay.
Thank you very much, and thank you and for sponsoring this. Just a couple of question and comment. I think I'm for this bill as it is, and I get it. Every time a situation comes up like this, I think back as a pastor when I went to do a eulogy. I had 4 bodies lying in front of me in 4 different caskets in the church: mother, father, 2 children killed in a fire. It haunted me for a very, very long time. So that leads me to these questions. Number one, what is the existing law for anyone who is found guilty of arson? And would you'll be adding this on 10 years along onto that? What about if family members are killed? Is there a way that this can be amended? Just a thought, to include family. I mean, I don't know where you stop, but I don't want to give the impression, because firefighters, their lives are on the line every day. I don't want to give the impression that we don't care, because we do. But I also care about family members who 3 or 4 and no enhanced penalty for that. Is that an amendment that could be added on, or you just think, or just a thoughtful for another day? But already existing law, what if I'm found guilty of arson? What do I get? What's the maximum?
So it's 30 years for arson. However, there's a couple of things. I want to try to get all the different nuances to your question.
Sure.
So as it relates to victims of the crime of arson, so if someone set fire intentionally to a person's home,
Right.
and people were inside, that the law does adequately cover. So we have those protections in place.
Okay.
The issue is
I
that
got you.
different judges have interpreted the way that our laws are written to define that. The way you'd catch it typically would be reckless endangerment. If the person engaged in a reckless act and harm resulted. The problem is that because firefighters are responding to the crime,
There is no.
judges say that they're not part of the intended victims. And therefore, some judges, not all, that's why it's inconsistently applied. Some judges are saying this class of victims does not fall under what the law imagined, and therefore there's no remedy that exists to address the firefighters who respond. This bill would seek to cure that hole in the law.
Thank you very much. Got it. 100% agree. Thank you. Thank you.
Thank you, Mr. Chairman. I was just going to share with you as chairman of the Maryland Fire EMS Coalition that unites Republicans and Democrats in support of fire emergency services, about legislation that benefits all first responders. We did take a vote in approval of this, and it is in document within your committee testimony. So thank you to the sponsor of the bill for bringing this forward. The coalition appreciates you.
Yeah, thank you for pointing that out. Thank you. Further questions from committee?
Mr. Chair. if
Oh,
I
sorry.
may,
Yes, Senator.
I'd also like to thank Senator Folden for co-sponsoring and working with us on this. And also thank you for your indulgence today, because we had one of our panelists has to step out a moment early. So thank you for working around that with us. Greatly appreciate your team here on JPR. Thank you.
Yes. They're the best. Sandy's the best. All right. Thanks. Appreciate it. Thank you all very much. We still have to hear from is Tracy Verrata here, and then Colin Campbell.
Good afternoon. My name's Tracy Varda. I'm from the Baltimore City State's Attorney's Office. I'm here testifying in favor of this bill. I prosecuted a woman who found her boyfriend with another woman in his apartment. So she stood on an electrical box outside of his apartment, broke a window, and set the curtains on fire, which quickly spread through an entire apartment building that housed families and elderly residents. Lieutenant Jeffrey Novak was a firefighter. He was one of the first responding. He arrived and ran right into that burning building where he carried out an unconscious 85-year-old victim. He then ran back into that burning building to rescue more residents when he became trapped on the 3rd floor. He eventually fell out of the 3rd floor into the cellar stairways, falling 4 stories, suffering significant injuries that would take him over a year to recover from. The only charge available regarding Lieutenant Novak in that case was maybe reckless endangerment, and that carries a maximum penalty of 5 years, which is significantly disproportionate to the injuries that he suffered. In addition, the defendant also argued that the arson charge was inappropriate because the defendant's intent was only to smoke out her boyfriend, not to set that building on fire. This bill will give charging options to the state's attorney's office that are currently unavailable. With this bill, the state will only need to show that the defendant had a malicious intent when setting the fire, and it will negate any argument that this person did not mean for the fire to escalate and cause harm to the firefighters and therefore should not be culpable. We also expect this bill to be a deterrent to fire setting. Defendants charged with setting fires often either don't appreciate or just don't care how their actions endanger others. In my case, the defendant made numerous jail calls to her boyfriend, showing no concern at all for the injuries she caused many people. Instead, she was angry and just wanted her boyfriend to drop the charges. Also, in recognizing the seriousness of these offenses, in 2022, the Maryland State Sentencing Guidelines for first-degree arson were changed to reflect the harm to our firefighters. So this will allow us to protect our firefighters, and for all these reasons, we urge a favorable report. Thank you.
Good afternoon. I'm Colin Campbell, an Assistant State's Attorney with Howard County, and I am here in strong support of SB 435. Would like to express my gratitude to Senators Gallion and Folden for sponsoring this crucial bill. I've been in ASA since 2018. I've prosecuted various criminal crimes, including arson. In the past 2 years, I've had 3 separate arson cases in Howard County alone that resulted in the injury of a firefighter and the suppression of that arson. As State's Attorney Gibson spoke to, we are currently experiencing a situation where the law is being applied differently among cases. I have had a situation in which the named victim of a reckless endangerment charge was the firefighter who was injured, and I've had that charge dismissed based on a finding that reckless endangerment did not encompass or intend that individual to be a victim. The passage of this bill would allow a mechanism by which us to hold arsonists accountable for any injuries or death that they cause to firefighters in the suppression and response to of arsons. And I would ask you to make a favorable finding of this bill.
All right, questions from the committee? Senator Wallstreicher.
Thank you. I know we're busy today, Mr. Chairman. I just wanted a quick thank you. Senator Muse mentioned that he came in here the second time in 2007. That's also when I joined. And the tradition has always been to have the State's Attorneys Association testify and the government relations people from the Public Defender's Office testify. And there's a noticeable shift this year that I really appreciate. The line prosecutors who are involved in the cases that we're discussing here are joining us in Annapolis, and I found it very powerful. And the same has been true of our public defenders. The public defenders with specific subject matter expertise have been testifying on those bills. And so I just wanted to note for the record how much a difference that has made to our analysis here on the committee and mine in particular. So thank you.
Thank you.
Thank you.
It must be Friday. That was good. That was good. Actually, I echo the sentiments. It's actually true. It does make a difference. So thank you. Further questions from the committee? All right. Thank you all very much.
Thank you.
Thanks. All right. With that, that'll conclude the testimony for the proponents of the bill. We'll now hear from the opponents, the opposition, and is Jeremy Zacher from the Office of Public Defender here? Welcome.
Thank you and good morning, everyone. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. The Office of the Public Defender is asking for an unfavorable report. This bill is very broad in its language. It does not define what an injury is. An injury could be certainly the most substantial injury. It could be a splinter or a stub toe. It also could be interpreted as emotional injury. The injury defined does not need to be caused by any arson or fire. It could be caused by a third party, yet still the person who's committing the arson would be held accountable. The bill does not define a firefighter. Is it a professional firefighter, or is it simply somebody who responds to the fire? These words are not defined, which makes the bill overly broad. And the bill encompasses a lot of different types of behavior, not just what we typically think of arson, such as burning down a house or a structure. It includes malicious burning of property. It includes burning of a trash receptacle, and it could include negligent setting of a campfire. And the bill would impose a mandatory consecutive sentence instead of leaving that decision to judges. So let me paint a picture for you. If I negligently set a campfire and it gets a little bit out of control, I would call the fire department. And if the fire department is responding and a drunk driver hits them, I am now guilty of a felony because their injury was caused during the response to the fire that I caused. And a minor negligent fire setting, a campfire, has now turned into a 10-year felony. This type of overly broad, overly punitive bill is going to cause people to not call 911 when they need help, even when they start the fire, for fear that the responding firefighters will become injured. We're asking for an unfavorable.
One question. Sometimes when I listen to the opposition, and I'm with you all 99% of the time, when I hear it, and especially for something like this, I often ask myself, can you just do an amendment to fix, because everything that I've heard you say, it's nothing that would drastically change the bill without just an amendment and then just go on to the next bill. So is there an amendment that you can do again to fix it? It includes your concern and it wouldn't change the bill.
So the Office of the Public Defender is not going to propose amendments to this bill, but we just wanted to express that the language at least needs tightening up to avoid what we've expressed our concern about.
Maybe give us some language so we can look at it and we'll see. Okay, thank you.
Questions, further questions? Thank you very much. That was a good presentation, actually. All right, I think that's it. That'll conclude the hearing for Senate Bill 435. We'll now move on. Is Senator Kagan here? Welcome. We'll now move on to Senate Bill 496. Senator Kagan.
Thank you so much, Mr. Chair. I don't know if I'm supposed to do this. On Zoom. Okay. For the record, Cheryl Kagan, the Senator for Gaithersburg and Rockville, and relative to this, the 4-year chair of the Next Generation 911 Commission that has moved Maryland from behind the pack to nationally recognized in our progress towards Next Generation 911. You've heard this bill before. We have submitted there is a lot of favorable testimony. I only brought one witness so as to minimize the amount of time for this committee. But fundamentally, this is about attacks that can risk lives. These are attacks on our 911 center, either using a telephone or using digital tools. It is exploding in frequency. There has been an 807% increase in these attacks just between 2018 and 2022. Just this week, Pennsylvania's court system were shut down based on attacks. Baltimore City was shut down. Their 911 center was shut down. Sometimes these develop into ransomware attacks. So until you pay us, we're not going to let you answer literally life or death phone calls. And if, God forbid, your house is on fire, as we were hearing in these last bills, if your house is literally on fire, if grandma isn't breathing, if a bad guy is running away, you want to dial those 3 digits, 911, and be able to get through and have a 911 specialist send support. So the FBI has now stepped into this. I submitted with my testimony their alert, which is important and mentions how much these attacks are increasing. There were roughly 13 million digital incidents just in 2022. Last year, the vice chair and I brought a swatting bill. We had a swatting commission because of the spike and the national attention to phony calls to 911 that lead a SWAT team to come out against a local judge, against a local elected official or a celebrity. Maryland has now finally passed that law. This was the partner legislation that was unanimously endorsed by the Next Generation 911 Commission and by the Swatting and Attack Commission. And it's time. I'm just going to leave you with just one quick quote from the president of Mission Critical Partners, which has been our key consultant and does national work in 911. And he just talked about that these attacks are increasing in quantity, breadth, and sophistication. Some attacks have gone as far as demanding a ransom to terminate the attacks. And true emergency calls are not going to be answered if in a timely way, if they are dealing with a bunch of phony 911 calls that are on robodial and all that. This bill has passed the House unanimously, and I really hope the Senate moves it this year. Happy to take questions, but I'm grateful for the support of the Department of Information Technology and the Department of Emergency Management, both of which understand that this is critically important. And I'm delighted that Greg Rogers, our CISO, our Chief Information Security Officer, is with me to endorse this bill and answer our technical questions as well.
Thank you. So I'm Greg Rogers, the Acting State Chief Information Security Officer from the Maryland Department of Information Technology. DoIT supports Senate Bill 496. This bill aims to address and deter interference with public safety answering points. Public safety answering points play a critical role in ensuring the safety and well-being of our communities and handling emergency calls, dispatching appropriate response teams. The proposed amendments in Article 7-302 of the criminal law are essential in addressing intentional and unauthorized actions that may interrupt or impair the functioning of a public safety answering point. By explicitly prohibiting such activities and imposing significant penalties, the bill seeks to safeguard the integrity and effectiveness of these crucial communications hubs. The inclusion of specific provisions related to the possession of ransomware with malicious intent is particularly commendable. This demonstrates a forward-thinking approach to addressing evolving threats in the digital landscape and reinforces the importance of protecting our public infrastructure. Furthermore, the bill establishes appropriate penalties for violations, distinguishing between misdemeanors and felonies based on the severity of offense. These penalties send a clear message that interfering with public safety answering points is a serious offense that will be met with significant consequences. For these reasons, the Maryland Department of Information Technology respectfully requests favorable report on Senate Bill 496. Thank you.
I know we have Ms. Sample to come up and testify as well, and then we'll take questions at the end of the panel.
All right, thank you to the chair. Thank you to the members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here in support of this bill. So obviously the migration to Next Gen 911 has been happening over the last couple of years. There are some cyber vulnerabilities that come with that. And we know that local and state governments have been increasingly the targets of cyber attacks. And so when it comes to public safety in particular, an interference or a delay can be a really critical, serious situation. And so we think this is really important. It's going in the right direction. We would certainly urge a favorable report on this bill. Thank you.
Thank you very much, Ms. Sample. Questions from the committee? Seeing none, thank you very much, Senator. Thank you.
Have a good weekend, y'all.
Thanks. Have a good weekend. All right, with that, that'll conclude the hearing for Senate Bill 496. We'll now move on to Senator Sidner. Are you ready to go with Senate Bill 549? Awesome. Quarterman, is Senator Quarterman still here? There you go. Sorry, I didn't see you behind the podium. Let's do, we're going to call him first and then we'll come back. All right, Senator Quarterman with Senate Bill 554.
Alice, you couldn't see me, could you? Sorry about that. Thank you, Chair Smith, Vice Chair Wallstreicher, and members of the Judicial Proceedings Committee. Thank you today for the opportunity to present Senate Bill 554, criminal procedure not criminally responsible verdict, terms of confinement. For the record, Senator Paul Quarterman representing District 2 in Washington and Frederick counties. In June of 2022, the Washington County community suffered a tragic loss when Mark Allen Fry, Charles Edward Minnick, and Joshua Robert Wallace were gunned down and murdered at their workplace, the Columbia Machine, by a disgruntled employee. The shooter fled the scene only to be apprehended following a shootout with the Maryland State Police, where State Police Detective Sergeant Philip Martin was shot and wounded. Fast forward to April of 2023. The families of the 3 murder victims were informed that this killer would not receive any prison time for his confessed crimes. Instead, he was deemed not criminally responsible for his actions, and as such, committed to Clifton T. Perkins Psychiatric Hospital. The victim families were then advised that this murder was found to no longer be a threat or danger to himself or others. He could be eligible for release without any rehabilitation in a state correctional facility. Just 2 months later, in June of 2023, again, just 1 year after this horrific event, and again, just 2 months after the individual was committed to Perkins, the individual was given the option to be evaluated for potential release back into our community. He did not contest this commitment at the time. However, he can be reevaluated for release again in 1 year. Senate Bill 554, if passed, would require, after a verdict of not criminally responsible for murder in the first degree, to commit a defendant to a designated healthcare facility for life. Similarly, it would require, after a verdict of not criminally responsible for murder in the second degree, to commit a defendant to a designated healthcare facility for a term of up to 40 years. The intent here is if an individual has committed murder in either the first or second degree, that they would be held to the same standard that other murderers in our judicial system are held to, and not eligible for release in any manner that they currently are. The families of these victims deserve better, and it is agonizing for them to now be victimized and relive this horrific experience on an annual basis, knowing that the individual that murdered their loved ones could be released in as little as a year. Colleagues, if the way this bill is structured presents challenges, by all means, we are open to working with the committee to strike the necessary balance. We know this is a difficult situation. However, we also know when something is wrong. And it is wrong that somebody can commit murder and then have the possibility of returning to society just a year later, and again, have these families being victimized on an annual basis. We thank you for your consideration, and we respectfully ask for a favorable report on Senate Bill 554. Thank you. Whoever's up first.
Thank you, Senator. Good afternoon. Thank you for having me here today. My name is Angie Fry. I have just a few minutes today to make an impact on you and hopefully make a difference. On June 9th of 2022, my husband, Mark Fry, was murdered in cold blood, along with his co-workers, CJ Minnick and Josh Wallace, at Columbia Machine in Smithsburg, Maryland. During an afternoon break, the shooter, a 23-year-old Latino man from Texas, put 7 bullets in my husband. He proceeded to shoot CJ Minnick 3 times and Josh Wallace 9. Those shots resulted in the deaths of all 3 men. He went on to shoot Brandon Michael 4 times and later shot a police officer. They each survived. For his heinous crimes, the killer was given a plea deal from Judge Brian Wilson in the Washington County Circuit Court and was found to not be criminally responsible for his actions at the exact moment that he pulled the trigger multiple times. He did not stand trial. His crimes were not heard by a jury of 12 of his peers. We were not permitted to appeal the decision. We were not permitted to request another opinion. The Maryland law was completely geared toward the benefit of the criminal. He was not sentenced to a period of incarceration for murdering 3 people. Instead, he was placed in a hospital until he is deemed to no longer be a threat to himself or others. When that day comes, he will not go to prison or any other facility. He will be free, free to kill again, free to live among innocent, unsuspecting citizens. He is schizophrenic, and there is no cure for his mental illness, and he cannot be rehabilitated. The first review for his release came just 30 days after his initial placement. We were not informed that this would happen, and we, the families of the victims, were all quite shocked. When I inquired, I was told by Valerie Grimes at Clifton Perkins that Mr. Esquivel is entitled to be reviewed for release because his civil liberties were taken from him. I ask you, what kind of world do we live in where that's an appropriate response to the wife of a murder victim? The killer stalked my husband as early as March of 2022. He talked about him on the dark web. He had photos of my husband's truck. Police are unable to tell me just how much information he had or shared about our family due to the anonymity of
Ms.
those
Fry.
types of sites.
Ms.
Even
Fry,
with the substantial,
I'm sorry, the time is concluded. If you could briefly conclude, please.
I do.
Just
Senate bill, as I understand, allows the mentally ill to get to the treatment that they need while eliminating the annual review for release. For the charge of murder in the first degree, the criminal is committed to a facility for life.
Ms. Fry, I'm sorry, if you could just, the time's up and I'm just out of fairness for the rest of the witnesses, I have to cut you off there.
I just ask for a favorable review from the committee. This is something I have to live with forever and will never be free.
Appreciate it. Thank you. Thanks.
Good afternoon. Thank you for the opportunity to speak here today. 2 minutes doesn't seem like a lot of time to make a difference, but I can tell you on a day in June in 2022, my life changed in less than 30 seconds. In the afternoon of Thursday, June 9th, 2022, as I was starting a long-awaited vacation with my grandchildren, I received a call that changed my life. My son, Joshua Robert Wallace, and 2 of his co-workers had been murdered in cold blood earlier that day. My son was shot 9 times. We were also shot, Brandon Michael and a police officer who did survive their injuries. We were not only left to deal with the senseless deaths of our loved ones, we needed to make sure that their killer was going to be held accountable. I had faith in our legal system that surely someone who committed a crime such as this would be locked away forever, and we could get on with our grieving. My misplaced faith in the Maryland justice system was wiped away on November 17th, 2022, when we were informed by the prosecution that Mr. Esquivel would be entering a plea of not criminally responsible. He would be sent to a mental facility where, when he was determined by a mental health evaluation not to be I'm sorry. When he was determined not to be a threat to himself or others, he could be released. We were given chance to make victim impact statements when he entered his plea in the courthouse. Our pleas fell on deaf ears. We were told to contact our state lawmakers if we were upset with this decision. So I really would like to thank Angie Fry for contacting everyone with a maryland.gov email address she could find. And I thank Senator Quarterman for bringing this bill to you. We've already been given a life sentence that we now have to live without our loved ones. But to have to revisit this every year is simply unimaginable to me. We have suffered enough. I ask you to please work with Senator Quarterman and vote on this bill favorably. Thank you.
Look, a lot of times people come to petition this committee for change because of something, you know, happened in their life, and usually it's a terrible thing and it's the worst moment in their life, and it takes a lot of courage to come up and to do that. So I want to thank you both. I also understand the constraints of 2 minutes is hardly fair to the witnesses, and I'm sorry for that. So I just appreciate you all coming down here, participating in the process, and turning, you know, something negative into something potentially positive for the rest of the state. So I appreciate that. With that, we're going to go with Senator Folden.
Thank you, Mr. Chairman. ladies, I would really like to thank you personally for being here and advocating for this on behalf of your family members, but not just on behalf of them. This is broader reaching, and I want you to understand. So this Sunday is a 2-year anniversary for me and my friends, where 2 of my coworkers were shot on a scene that I was at as a police officer. And thankfully, they both were able to survive. But I will tell you that their suspect also was given a non-criminal responsible plea. And it does not allow any type of closure. It does not allow, it reopens the wound every time they come up. And there's no punishment associated with it that's sufficient. And I can tell you that this Sunday I'll be with them, and we will be discussing this, and we will be having our thoughts and prayers with you. And I'm really thank you for being here.
No, thank you, Senator Fulton, for that observation. Thank you. Further questions from the committee? All right. Seeing none, thank you very much, Senator. Thank you both. That'll conclude the testimony for the proponents of the bill. We'll now hear from the opposition. Is Lucien Parsley here? And then also is Ms. Cass here? Nashona Cass, there you go. Welcome.
Thank you. Yes, sure. Mr. Chairman, Senators, thank you for the opportunity to testify today. I'm Lucienne Parsley from Disability Rights Maryland. We're the Protection and Advocacy Center for Persons with Disabilities for the state of Maryland. We're the state designated federally mandated center. With respect to really to the very, very difficult situations that you've heard from today from the victims, I want to acknowledge that and also to acknowledge that Maryland law reflects the determination that treatment of those that are found NCR is not intended to be punitive, but rather to protect public safety and treat the individual's mental illness. And this is because what we've decided as a society and the legislature has decided, but also because courts have determined that an individual's illness was a substantial factor and the person lacked the ability to conform their conduct to the law. And the US Supreme Court agrees. There's a number of cases, Jones versus United States, for example, the court said very long time ago that the nature and duration of an NCR acquittee must be reasonably related to the purpose of the commitment. So I just do want to mention how difficult it is to get out of the hospital when you are NCR. There are myriad challenges to people that are there. They often stay for much longer than they would have stayed if they had actually been convicted of a crime. There are people often, because they're institutionalized, they don't know their rights to ask for changes. The treatment that they receive is often not as robust as perhaps we would expect it to be. There's also a very robust conditional release process and monitoring for 5 years, at least, with the ability to extend that. So there are many, many processes in place to protect public safety. Thank you. And we ask for an unfavorable report on the bill.
Thank you.
Good afternoon, Chair, members of the committee. My name is Nashona Kess. I am the Executive Director of the Maryland State NAACP. And while we certainly sympathize with all the victims, we simply don't believe this bill is the answer. This bill penalizes an individual who was found not criminally responsible for committing specific crimes and giving absolutely no chance of rehabilitation. This bill does not allow for context or other factors used to determine sentencing. What happens when their mental health disorder or defect has been cured? Do those members of our community not deserve rehabilitation like others who commit the same crime or a fair process to consider the context of the crime? It does not consider the often complex nature of a vulnerable person with a disability at the time the crime was committed. This is not the same standard as others. If you would like to see a criminal code 2-203, which at least provides for a separate hearing when the state is seeking life without the possibility of parole. This bill, in effect, provides for life without the possibility of parole. This bill treats those with mental illnesses worse than those who do not have a mental defect when committing the same crime. Committing a person to a healthcare facility ought to be for the purpose of treatment and public safety evaluations. A judge should have the opportunity to consider all the factors of the case before determining that a person shall be committed to life or required a 40-year minimum as the bill suggests. For those reasons, we ask for unfavorable review from the committee. Thank you.
Thank you very much, Ms. Kess. All right, a couple questions from the committee. We'll start with Senator Fulton and then Senator McKay.
Ma'am, I would like to ask you a question. I'm sorry, could you step to the podium?
Yes.
So I thank you all for coming in and your thoughts. I just wanted to ask, you brought up the reasonableness in one of your discussion and one of your points. And I want to know, is it reasonable that 20 days after the NCR is handed down that the family gets notification that there is a hearing on behalf of the subject that just murdered their family?
Well, given that the crime may have taken place many, many years prior, 5-10 years prior, maybe not in your case, but in many cases.
In two cases, ma'am.
Typically, someone is found incompetent to stand trial first, and those charges may stay for 5 years or more before the charges, before the person is restored to competency. Then there may be a trial. So in many, many cases, it's much longer than that. So it's just reasonable to think that after the person is found NCR and they're sent to a hospital, that there's a determination if that person is dangerous.
So you're saying that by what you're saying is, if I'm hearing you correctly, is contrary to what the witness from the NAACP said, which is, should they be held accountable after they're healed or rehabilitated? You're saying that that once they're rehabilitated or that they're found competent, that then you can go and have the trial?
Well,
up to 5 years?
So often if the person is restored to competency, there is a trial. If they're not restorable to competency, then they proceed typically to an NCR evaluation to find that. So oftentimes when you have someone who's been very sick, they're originally found NCR, and then there's a period of time during which they receive medication and restoration treatment. And then if they're found not restorable to competency, then they pursue an NCR evaluation, which looks specifically at the time the crime was committed. Was the person able to appreciate the criminality of their actions or conform their conduct?
So what would your opinion be then if they were found after a period of rehabilitative time to be found competent, even though at the time, by what I'm hearing the witnesses say, that at the time of the incident, he was not criminally responsible, but then he's rehabilitated within 3 to 5 years. And you're saying, what do you say then? We should be able to have a trial then?
No, I'm saying if someone was so ill, mentally ill at the time they committed the crime, that they could not understand the criminality of their actions or conform their conduct, that they should not be.
So we should just
held accountable. If they're dangerous, they should be.
And what's the average incarceration, if you will, of these mental health facilities for a person to be in there that's NCR?
Well, Clifton T. Perkins is where people who've committed violent felonies go. And typically people are there for decades if they've committed a violent felony.
Okay. All right. Thank you.
You're welcome.
Thank you, Mr. Chairman. So are you familiar with the details of this particular case?
No, I'm sorry, Senator, I'm not.
Yeah, I recommend that you probably really dig in to the details of this case because you use reasonable. We've talked about period of time. And we talk about treatment to the perpetrator's mental illness. What about the victim's mental illness that is going to occur now because the period of time has been so short and is just an absolute insult to the victim's family? And please, at least for some sense, please look at that particular case and really educate yourself that the period of time has been such an insult. Look, I understand that we have people that will have mental illness. And I'm somebody who's big on second chances and rehabilitation. But we, as this body and as the judicial system, have to, at some point, take in consideration the victims. Because of this period of time, there hasn't been time for them to heal. And this gentleman, allegedly, I'll say he did it. I'm going to say that he didn't because he's not criminally responsible, but he did. It took 3 lives. So I just suggest that in the future, it may be a good idea to research the particular case that may have brought. And so just so that it could be articulated that there would be some form of compassion, because in both of your testimonies, you have not been. I understand we started that way, but using words like reasonable and period of time, when this particular case, there is no reasonable particular time. And thank you.
And what I'd like to say to that is this is not about a specific case, one case, right? This bill would apply to all and would paint everybody with the same broad brush. And so what my argument is we need to consider some factors surrounding some of these cases, right? And we should allow the court to do so. This bill is not allowing that. So sometimes one story and another story is completely different. And we're saying that everyone should be committed to the health facility for life without considering anything else.
Okay, well, factors include facts. And you've just got testimony from this senator over here for his situation. And you got testimony from this senator on 2 situations. And it speaks to being compassionate and understanding. Do you either one of you have an amendment or something, or do you have a solution that would help with this in this particular case?
What I'm suggesting is that we need to look again at the entire bill and possibly consider that cases are different from one another. And yes, we've heard about 1 or 2 cases, but that still does not give an entire view to all the incidences that may occur that where a person may be considered
Do you
incompetent.
have a suggestion, an amendment to make this better that would address the concerns that you have and take into consideration, as you have said, these 2 individual cases that are of many? Do you have?
Well, I did submit my suggestions, which was that there should be similar factors, similar to I believe it was 2-203, where a judge, there's a sentencing hearing and a judge looks at all the factors of the case to determine whether a person should have life without the possibility of parole or even be sentenced to life in general.
Okay, well,
right.
That may be something.
And this
we
is
can
not
consider.
given that.
But that may be that, but goes back to my statement that I tend to believe that we should have been a little bit more investigative about these incidents that actually brought this up. Because one of the issues is the notice that the family gets 20 days after. That is just so inhumane and really does not, in my mind, look well upon those who are advocating on the other side. Together we can solve this. And I think that's more important, that together we solve it, but we have to look at both sides.
I absolutely agree. I just don't think that the bill even looks at some of the things that you brought up.
Thank you very much.
Thank you.
I did want to say.
Actually, let's just, I'd like to just conclude the colloquy there. If that's good. Miss, you did the fantastic job. Good explanations, offered solutions, suggestions, pathway forward. So I appreciate it. Thank you. If there are no further questions from any other senators, I'd like to conclude this bill hearing and move on to the next. Thank you very much. So with that, that'll conclude the bill hearing for Senate Bill 554. We'll now move on to Senator Sidnor with Senate Bill 549. Is that okay with you, Senator? Excellent.
Charles Sidnor for Senate Bill 549. A few years ago, through a lot of work, Maryland, we were the first state to regulate and put some framework around how genetic genealogy or forensic genetic genealogy was performed here in the state of Maryland. I believe the legislation that was passed was the first of its nation and has now been looked upon by a variety of states who have enacted similar legislation. During the focus of that legislation was with regards to ensuring that when genetic genealogy was being used, that there were certain parameters around how DNA was collected, how it was then discarded and the like, to ensure that people who were related to the putative perpetrator, their DNA wasn't caught in some state system forever. One of the things that we did not do, and we had conversations, and I'm talking about a group of team that we had put together, which included state's attorneys, defense attorneys, law enforcement officers, professors, geneticists, and many others. When we had discussions about this, we had talked about the use of this technology for missing and deceased children. We left that portion alone because we thought that the law was pretty clear that this was focused on crime fighting. And generally speaking, when legislation is silent on things, law enforcement tends to feel like if it's silent, it can be done. I had a conversation when I was asked about introducing this legislation. The National Center for Missing and Exploited Children had asked for an express use of forensic genetic genealogy for deceased and missing children. And my initial thought was, why do we need that? That wasn't the intent. This is focused on what I just mentioned. During that discussion, what was mentioned was there are times when law enforcement has been hesitant because what we rightfully did, we put some penalties in if this technology or this application was misused. So the National Center for Missing and Exploited Children, their hope was that we express the ability for this technology or this particular function to be used in finding deceased and missing children. And I will note one other question that had come up when I had that discussion with them. There was a missing deceased woman, called her Woodlawn Jane Doe, who was actually identified because of forensic genetic genealogy. So my question to them, because this was just a few years ago, was, okay, well, it was used in that case. Why wasn't anyone stopped? And what happened was, he said the use of genetic genealogy and identifying Woodlawn Jane Doe happened just before the law went into effect. So this bill is just to exclaim that when we passed the law dealing with forensic genetic genealogy, we were in no way looking to prohibit its use to identify missing and deceased children. With that, I rest and ask for a favorable.
Excellent. You do have two panelists, one, Ms. King, Joyce King, and you have one joining us virtually, Mr. Dayton Lynch. So
Right,
let's have Ms. King come up first, and then we'll open it for questions.
Good afternoon, Mr. Chair, committee members. My name is Joyce King. I'm here on behalf of the Maryland States Attorneys Association and the Frederick County State's Attorney's Office, as well as I serve on the Law Enforcement Advisory Board for NCMEC. I didn't know that Mr. Lynch was also going to be testifying, so in avoidance of being redundant, the MSAA does support this clarifying legislation. We do believe that it is beneficial for law enforcement to have this explicitly stated in the statute. This aligns our statute with NCMEC's recommended practices for forensic investigations by providing this exception for non-criminal identification of missing or deceased children. In Maryland, NCMEC estimated in 2001, there were 27,733 missing children here in Maryland. This is an important piece of legislation to ensure that families can unite with deceased missing children, unidentified children. We believe that this will allow law enforcement to more quickly identify, with the help of NCMEC, these remains. And this is, I think, straightforward legislation. We ask for a favorable report.
Is Mr. Lynch there? Mr. Lynch, before you come off of mute, if you're watching us, if you're streaming it on the YouTube channel, if you could close that or mute that portion of your browser first before you come off of mute. Excellent.
All right, Mr. Chairman, members of the committee, can't really say it any better than Senator Sidnor and Joyce King. We think this legislation is necessary to provide clarity for law enforcement. We had 81 cases nationwide between 2018 and 2023, where we were able to work with our partners and forensic labs to help identify unidentified children. And we also had three cases during that time period dealing with infant abductions where forensic genealogy was used for that purpose. And what we've heard in speaking to a lot of our partners and people in the field and law enforcement, Baltimore County in particular, is that there is hesitancy about using forensic genealogy for that purpose because of the perceived limitation in the current law. So we'd urge a favorable report. It'll allow a lot of families who are, who have children that are missing or in fear dead. It would give them another resource. It's non-criminal in use, and the other parts of the forensic genealogy provision statute are preserved and untouched. So it just provides an exception to provide clarity that law enforcement can use FGGS for this purpose. So with that, I ask for a favorable report, and I thank you for your time.
Excellent. Thank you very much. We have a couple questions from the committee. We could start off with Senator West, then Senator Folden.
Thank you, Mr. Chair. So obviously this bill is a great bill. It's hard to imagine not voting for this bill, but I've got a hypothetical I want to posit.
So that question be for me or for
you?
Okay,
for the sponsor. So the police discovered two decomposed bodies side by side. One of them they determine is the body of a 17-year-old, and the other is the body of a 19-year-old. As I read this bill, they can use forensic genetic DNA analysis to try to identify the 17-year-old, but would legally be prohibited from doing that to identify the 19-year-old. Why do we have this arbitrary line drawn at the age of 18 years so that unidentified bodies of people older than 18 years cannot be figured out by using this sort of cutting edge analysis?
The best way that I can answer that question is because it was the National Center for Missing and Exploited Children who brought forth this question. If you have an amendment, certainly put it in. I will talk with Delegate Bartlett. I think that sounds like something that's reasonable.
Okay, thank you.
Mhm.
Thank you, Mr. Chair. Actually,
Same question?
my question was the same thing about why we had an arbitrary line. Just make it for all unidentified, remains at that point, because that would be inclusive regardless of age. But I do want to tell you, because I don't get to say it very often, I love this bill. And I'm proud to call you my friend. So this is a good bill.
No,
so thank you.
And again, I think, and I don't want to jump ahead of Delegate Bartlett because it was her that the National Center came to. I'll talk with her, but it sounds like that would make sense to me. Isn't that so?
Yes.
People coming together, JPR love. This is good. Must be Friday. We'll see how long this lasts, but hopefully keep it going. Yeah. Let's keep it on. When we get to Senate Bill 744, let's keep that in there. All right. All right. Seeing no further questions, thank you all very much. Thank you, Mr. Lynch.
Great, thank you.
All right. So that'll conclude the hearing and the testimony for, what was that? Senate Bill 549. We'll now move on to Senator Wallstreicher, Senate Bill 555.
Thank you, Mr. Chairman, members of the committee. Excuse me. We've heard this bill before, but I think it was last term. And so some of you weren't part of that discussion. In Maryland, under current law, it is illegal to surreptitiously visually surveil a place where privacy is expected if that surveillance is done for the purposes of sexual gratification. But in the statute, instead of just saying that this applies wherever there is an expectation of privacy, we specifically lay out the places where an expectation of privacy is held. So, for example, in a hotel room or in a pool house. And so that creates difficulty because it means we have to keep coming back and adding places to the list where it should be illegal for someone to surreptitiously place a camera to record someone for purposes of sexual gratification. And so this bill simply adds a particular place, which is a residence, to that list of places where there is an expectation of privacy. This comes out of a specific case, which you will hear about in a moment. We've actually heard a lot of bills today that come out of specific cases where we have to come in and kind of remedy what a court may have said because they don't have the tools necessary that we are required to provide them. But let me just give a hypothetical so you understand what I'm talking about. A husband and wife share a private home. The wife invites her friend from college to stay with them for a weekend. The husband is interested in the friend and in the guest room surreptitiously hides a camera for the purposes of his own sexual gratification. The guest who is coming undresses in the guest room. That is not illegal under current law. Had the woman stayed at a hotel and the man placed a camera there, that would be criminal. But because it was a private residence, the surreptitious taping for the purpose of sexual gratification is not illegal, and that person could not be charged in those circumstances. So that's the hypothetical. You'll hear a more specific case involved here. With that, Mr. Chairman, I ask for a favorable report on Senate Bill 555.
Good afternoon. Scott Schellenberger, State's Attorney for Baltimore County. In keeping with this feeling in this room, I'm in favor of Senate Bill 555. To take it from a hypothetical to a real case, in 2018, in Bickford versus State, the then Court of Special Appeals held that a father secretly recording his daughter in the family bathroom did not constitute a crime under this statute. And that was an appellate decision. Thankfully, the father was convicted of other charges, or else he would have completely walked. And what this does is, in the statute, it names the places what are private places. So an office, a rec facility, a restaurant, a tavern, a hotel, motel, a school, but suddenly not the bathroom in your own home. But what the court ruled was because there was a list, it was limited to the type of residence, type of locations that were listed there. So this is merely a simple fix to add the term residence to change the injustice that took place in the Bickford case. The second thing that it does is it changes the sentencing to mirror the legislation in other areas of sexual offense. So for instance, if the victim is 26 and the defendant is 27, this statute would make that a misdemeanor. If the victim is 13 and the defendant is 20, that means 4 or more years older, then this potential sentence would be 5 years. And it would still be a misdemeanor. And then if it's the victim is 15 and the defendant is 18, again, we're back down to 1 year. So it fixes a hole in the statute by requiring a residence to be included. And it also makes a scheme of the sentencing scheme to make it more sensible, particularly when you prey on a minor or someone under the age. So we'd urge a favorable report.
Good afternoon again. Joyce King, Chief Counsel of the Frederick County State's Attorney's Office. I asked for a favorable report of SB 555. I'm also here on behalf of Lisa Jordan, who was unable to stay on behalf of the Maryland Coalition Against Sexual Assault, who also asked for a favorable report. I'd like to highlight another case that we're all familiar with. This bill was prompted by the disturbing case of Jonathan Newell, the judge in Circuit Court of Caroline County, when a 15-year-old boy discovered that there was a camera pointed at the shower and reported it to his parents. That investigation ensued, and what we found with law enforcement officials as well as our federal partners is that there were issues concerning the qualification of whether that would qualify as production of child pornography. I have been prosecuting child pornography cases for 11 years. I've had numerous cases of mothers' boyfriends and examples such as Mr. Schellenberger stated of parents surreptitiously placing cameras in bathrooms, in bedrooms to record their children in various stages of undress for sexual purposes. I can unequivocally say there's a correlation between this type of conduct and the collection, production of child pornography and even hands-on abuse. This is serious conduct, and that's why we really support the categorization and clarification that this should absolutely include one's residence, and additionally, the clarification that this should be above a 1-year penalty when you are recording a minor in this type of fashion. I also wanted to bring to the attention of the committee, the DC Circuit, United States versus Hilly, which also had a similar ruling where the lascivious, the recording of the naked children in bathrooms and bedrooms were not considered production of child pornography. So I believe that this is a much necessary clarification in our law here in Maryland. We'd ask for a favorable report.
All right, thank you very much. Questions from the group? We've got Senator Sidnor.
So do I, which is why I'm about to ask the question, because I can remember Senator Watson when he was on this committee asking a similar, probably having the same concern that I'm about to ask you to address. Currently, you have a lot of people who put Ring doorbell or systems in their home cameras. Under this bill, the way that it's written, I would read that you would no longer be allowed to put those indoor cameras in your home. Am I reading that correctly?
So I appreciate the question, and it's an important conversation. I'm going to find the language here, but here it is on line 19 through 20 on page 2 of the bill. So under your hypothetical, the Ring camera would remain completely legal and would not be subsumed by the language in front of you. The reason is visual surveillance under the definition means the deliberate surreptitious observation of an individual by any means. A Ring camera would not be surreptitious. We all knock doors every 4 years. Some of us do it more frequently, and we see these Ring cameras everywhere, and you notice it because you're like, oh man, I better be on my game when I knock this door because they see that, you see the camera. And so it's only a hidden camera that is eligible under current law, and this bill does not change that.
So it has to be hidden.
Correct.
Okay, so these kind of cameras that we have around the room would still, if they're in my residence, I'm not gonna be convicted under the statute.
That's correct. And of course, the additional element here that would have to be proved beyond a reasonable doubt is the sexual gratification. Yep.
Thank you.
I'll sign something that you're not convicted if you want me to. Correct.
Thank you, Mr. Chair. So I have a question similar to my one in the last bill. I'm going to give you a hypothetical. There are 3 houses on a street, a residential street, let's call it Peyton Place. In house number 1, a 17-year-old girl is undressing, and there's a 22-year-old guy who's standing outside with a camera, taking pictures through the window, peeping Tom, of the 17-year-old who's undressing. And house number 2, there's another 17-year-old who's undressing, and there's a 20-year-old guy standing outside with a camera taking pictures. And in house number 3, there's an 18-year-old girl who's undressing, and there's a guy, any guy, standing outside taking pictures of her while she's undressing. As I understand this bill, in the first case, the fellow who's taking the pictures could go to jail for 5 years because she's a minor and he's less than 4 years older than her. In the second case, the guy only goes to jail for 1 year because she's a minor and he's more than 4 years older than her. I may have gotten that backwards. Oh, no, I got it right. And in the third case, she's not a minor. And so whoever takes pictures of her only goes to jail for 1 year. Does that make sense?
So, first of all, I feel like I need my blue book.
Sorry.
Pencils down in a few minutes.
But
So I'm going to defer to
we're
Ms.
sort of
King.
splitting hairs is what I'm saying.
So I apologize. I mean this with all good intent. I think it was your bill last year for camp counselors, and where we were attempting to draw this line. The drawing lines is inherently an arbitrary activity, but you need to draw them somewhere. And we did so with your bill last year with regards to camp counselors, and we are porting that same scheme over to this legislation. So
Well, why can't we just say that any peeping Tom who takes pictures, seeing it is one thing, and under law you get a year in jail. But taking pictures, which then can be put online and marketed and made profitable, that's something else again. And if you take pictures of anybody without their permission for sexual gratification, it's 5 years in jail.
So let me bring Ms. King up, but I guess the short answer is I'm happy to work with you on it. We took the same structure that you created for the camp counselor hypo that we dealt with last year to use here.
Okay, thanks.
I was actually going to just say the same sentiments. We're just mimicking the same age schemes that are reflected in other statutes of sexual conduct. Obviously, for any minor, as in my work, that is more egregious behavior, and we wanted that enhanced penalty.
All right, seeing no further questions from the committee, thank you very much. That'll conclude the bill hearing for Senate Bill 555. We'll now move on to Senate Bill 470.
Stand up, sit down. Stand up. All right. Good afternoon, Chairman Smith, Vice Chair Wallstriker, members of the Judicial Proceedings Committee. Thank you for having me today. My name is Miles Hicks. I serve as Deputy Legislative Officer for Governor Wes Moore. Keeping our community safe is the governor's top priority. And today I'm here to urge a favorable report on SB 470,
House Bill 597, the Growing Apprenticeships and the Public Safety Workforce Act, also known as the GAPS Act. It's a pleasure to be here, Secretary Wu, Secretary Scruggs, President Boatwright, all of which are doing great work in their communities, and we're all working together to try to address this workforce shortage that we're seeing in the public safety field. Over the interim, our office had the opportunity to meet with many folks like the FOP, firefighters, EMS, and one thing that we heard back consistently from all of those folks was they're experiencing a workforce shortage. So the GAPS Act is focused on making sure that Maryland is training and supporting highly qualified public safety professionals and ensuring that we have a drove of qualified officers within this state. We recognize that we need to focus on short-term and long-term solutions to address this. We need stronger pipelines to make sure that we are filling these roles and making sure that those roles are even open to folks who don't have 4-year degrees. Making adjustments to our apprenticeship program, establishing officer wellness policies, and determining the best ways to do outreach to market to folks in this field is going to make sure that we're making sure that we're keeping our community safe. And to close, our administration looks forward to continuing to work in partnership with members of this committee, members in the House, and many of the other folks that we've talked to, and we anticipate to have some amendments to this bill. And again, I urge a favorable report on Senate Bill 470, House Bill 597, the GAPS Act. Thank you.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the committee. Thank you for the opportunity to testify today. For the record, I am Portia Wu, Secretary of the Maryland Department of Labor. Governor Moore has charged us to prioritize making Maryland safer, and a key part of protecting our communities is a skilled public safety workforce, which the GAPS Act would advance. With thousands of new public safety job openings anticipated in the coming years, we must act now to ensure we can attract the best and brightest to these roles. The GAPS Act would address these needs through a proven strategy, registered apprenticeship. Across Maryland, we are expanding apprenticeship to more occupations, more jurisdictions, and more people from historically underrepresented groups, including women and individuals of color. Maryland needs public safety professionals who reflect the diversity of our great state and who come from the communities they serve. These jobs are family supporting jobs with good pay and benefits, so it's critical that doors to these opportunities are accessible to people from all backgrounds. We know the learn and earn strategy of apprenticeship is effective for filling workforce vacancies and retaining talent, including in the public sector, and the GAPS Act will put that strategy to work. Specifically, the legislation will unlock existing resources, providing additional incentives and greater flexibility. It does that through expanding grants to a broader set of covered occupations in public safety jobs, easing eligibility requirements for participants, and increasing the per apprenticeship grant to $5,000 to encourage adoption of this model. I urge a favorable report on Senate Bill 470 to ensure the safety of all Marylanders, and I'm happy to answer any questions.
Good afternoon, Chair Smith, members of the Judicial Proceedings Committee. For the record, my name is Carolyn J. Scruggs, and I am the Secretary for the Maryland Department of Public Safety and Correctional Services. Nationwide, the decline in hiring and retention of public safety personnel has affected every level of law enforcement, and corrections has been especially affected. In Maryland, we have a system that we can be proud of, which serves as an attractive career for current employees as state employees in all fields. As one of the largest state agencies, we have a diverse organization that offers opportunities beyond just uniform service for aspiring social workers, clinicians, data analysts, lawyers, policy analysts, administrative specialists, and many more competitive careers. Over the past year, we have made great strides in fulfilling a number of these vacancies, and this bill will allow us to leverage our successes by engaging a wider variety of apprenticeships earlier on in the career so that they can continue to grow into their greatest potential within DPSCS. Our average age at hire for correctional officers is currently 39. We have to take average an opportunity to ensure that the careers in public safety are within reach for younger people who do not always have the roads to state service that are available to them. No one can speak of the power of this promise more than I can. I began my career as a uniformed correctional officer in Baltimore City and now sit before you as Secretary of the Department. Along the way, the mentorship I've witnessed and personally cultivated has helped develop new generations of leadership within this department. In order for our workforce to grow back strong and resilient, we must encourage the next generation of students to bring their talents to the communities around them and work alongside us in public safety. In closing, I urge a favorable committee report for Senate Bill 470.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order Police. We represent over 21,000 police officers throughout the state. We're excited about this piece of legislation because it allows us to start to replenish our ranks. I know we are at a crisis as it relates to hiring and retention of law enforcement officers, and this gives us an opportunity to get younger people excited about the career field. I want to draw the parallel. It's almost the equivalent of having like the ROTC program, but like for policing. If young people are exposed to things other than just sports, and they can see a good career pathway, such as the pathway that Secretary Scruggs just mentioned. I myself wish I had this opportunity 24 years ago when I was in West Baltimore as a barber in the Sandtown Winchester community. I wish I could have started my career a little earlier and been able to have time to work with our communities. But this gives our young people a good opportunity. And lastly, some of the amendments that Miles talks about when we're talking about officer wellness. Again, I said I've been in this career field for 24 years. It's nothing like being able to talk to someone when you have a critical incident. I mean, I'm just passing the anniversary of a critical incident that I had. And I just remember that day being able to talk to another police officer and be able to express what I was feeling and having them understand what I was dealing with internally. So the amendment that the FOP is going to offer is that similar to what our friends at in the fire service have, that those conversations are confidential. And if we can just work together to try to get that piece added to this piece of legislation, we think this is a good start and a roadmap for us to be successful in building trust with communities and building back our police forces. And I'll stand for any questions. So we urge a favorable report for Senate Bill 470. Thank you.
Excellent. Thank you very much. A couple questions from the committee. We'll start off with Senator Sidnor, then Senator West.
Oh, thank you very much. Mr. Boatwright, do you mind coming?
Good seeing you, Senator.
Always good to see you as well. The question I have is with regards to the wellness program on page 53-207, because I guess in my mind, I'm thinking we've already passed something like this. How is this different from what may currently be in law?
So it's going to force police departments to develop policies. Everyone doesn't have a robust policy as it relates to peer support. It's going to, make everyone develop policies to make sure your officers' wellness. Well, the officer wellness is a top priority for the police department.
We didn't already do that?
It's not confidential and it's not mandatory.
All right. I think my vice chair, I think he had a response to my question.
So, and we spoke about this online. We did do it. You might be familiar with it because we did it for firefighters who were here earlier today. And when we did it for firefighters, and tell me if I'm right, Mr. President, we made that peer support confidential.
Correct.
But I think as an oversight, we didn't include the police officers in that bill. And
That's
so this
correct.
would be a fix to what we did with the firefighters. Is that so?
Yes, sir. That is absolutely correct.
Thank you, Mr. Chair. This is a great bill, and I believe it was the case when I first saw it up on the second floor of the State House and that's why I'm a co-sponsor. But now that I've had a chance to read it more carefully, it's interesting. The second half of the bill is very similar to a bill I presented before this committee on February 1st to do a study of policing in Maryland and why we're suffering such vacancies in the police departments. And my bill has certain differences with this one. For example, my bill covers included on this commission where the work group on growing engagement in law enforcement workforce would include people nominated by the Maryland Association of Counties, people nominated by the Maryland Municipal League, a delegate, a state senator, and also the matters to be studied in my bill were somewhat more expansive than the ones in this bill. Would you have a problem? I guess Secretary Scruggs, my question is to you. Would you have a problem if we added some amendments to this bill to try to merge the two together? If we can do that, I'll withdraw my bill and just remain a co-sponsor of the governor's bill.
We are happy to review that to add amendments, sir.
Great, thanks.
All right, seeing no further questions, thank you all very much. Good to see you all. We do have a couple of people left to testify on behalf of the bills, as Sarah Sample and then Grayson Wiggins.
Hello, thank you to the chair. Thank you to the members of the committee for having me today. Again, I'm Sarah Sample from the Maryland Association of Counties, and we are supporting with amendment Senate Bill 470. So we really appreciate the expansion of the resources that are part of the apprenticeship to include the wider public safety ecosystem. And we think that's a really, really great step in the right direction. The only thing that we're really looking for in terms of our amendments are just expanding that a little bit further. So when it does come to the commission and the work group, we were hoping to get local corrections officers also included in the work that those two entities are going to be doing. When it comes to corrections officers, even though they're not as visible, they're definitely taking comparable risks to law enforcement when it comes to severe injury, when it comes to long-term adverse health effects, trauma, and things along those lines. For corrections officers, the average life expectancy is 16 years less than the average adult. And so these are definitely things that are causing more, like compounding the issue with workforce challenges that we're having. So we would just like to see them included in the commission and the work group. But with those amendments, we would urge a favorable report on Senate Bill 470. Thanks.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here today on behalf of my client, employee Prince George's. They are the organization that manages workforce development in Prince George's County. They've been working on a police apprenticeship program and been communicating a lot with local police departments. And one of the consistent refrains that comes up in these meetings is the minimum age it takes to be a police officer in the state of Maryland. And so we have a minor amendment, I think, that just would ask that that issue be delineated as one of the topics to study by the work group established in the bill. Just we think it's an issue that's worth studying given the consistency of it coming up in the meetings. Be happy to take any questions.
Seeing no questions from the committee, that'll conclude the hearing for Senate Bill 470. We'll now move on to Senator Muse with Senate Bill 449. Would you like to bring up your panel?
Yes.
So is that Troy Turner and Tracy? Is Tracy Varda here? She's still here?
I saw her early in Troy Turner. They met in the hall and coming in as I speak. Okay. Thank you very much, Mr. Chairman and Vice Chairman, members of the committee. For the record, I'm C. Anthony Muse, 26th Legislative District, Prince George's County. We'll get right into what this bill does. Because last session, this bill passed, SB 507, passed this committee with absolutely no opposition, even though there was no opposition here, although we had some opposition from some other outside, and we do have it now. But I read the opposition to this bill, and there is nothing that cannot be fixed with a small amendment so that we can move on. It passed the House, it passed the Senate, but it did not make it out of conference committee in time to beat the clock. So here we are again, getting this done. SB 449 is the amended version of last year's bill, and it would extend the amount of time for which the court can dismiss the charge of a defendant who is incompetent to stand trial and who is charged with first-degree murder or sexual assault. It changes it from 5 years to 10 years. This legislation would also allow the actual victim or victim's representative to petition the court to extend the time for dismissal of certain charges against a defendant who was found incompetent to stand trial. I also have one amendment to include allowing incompetent defendants charged with certain sex crimes against children and vulnerable persons to be held for 10 years as well, because often the victims of incompetent defendants who commit sex offense crimes are vulnerable persons such as children and individuals with disabilities. So let me say it again, because I listened to some, or I read some of the opposition. This is not a shall. It is left up to the discretion of the courts and others. So it doesn't just mean automatically this will occur. So 449 attempts to fix an issue in the statute, and it helps to give the victim of a crime, the victim, a voice. Instead of the state's attorney being the only person allowed to request an extension. This legislation is very important because of the victims like my panelist, and you'll hear from Troy Turner, who I believe absolutely must have a voice. So SB 449 is important because the crime was committed against Mr. Turner's family and not the court system. And many of you, with the exception of my colleagues, with the exception of Senator Charles, you all heard this bill last year. In addition, our state's attorneys across the state overall work to do their best, but sometimes when cases are 5 years old, they are off the list of importance or off the radar. However, it will never leave the hearts of the minds of victims, their loved ones, the loved ones of victims, never leaves their mind. And so I'm going to ask for all of these reasons. And again, I'll repeat, I did see some of the opposition, I think judiciary and one other, but there is nothing that I read that I would not be able to sit and fix, and it would not gut the bill, change the bill, have any real except to meet their concerns, and I'm willing to do that. Having said that, I'll turn it over to Tracy. I'm going to go next, and so for this. So thank you, and I urge, as you did last year, for another favorable report.
Good afternoon, Tracy Varder with Baltimore City. I've been handling our mental health court for the past 12 plus years, so I see the practical effects of these competency laws. This bill is necessary to protect public safety, especially our vulnerable citizens, children, and individuals with disabilities. In 2006, the Criminal Procedure Title VII was amended to protect the rights with individuals with disabilities, as well as protecting public safety interests. At that time, incompetent defendants charged with murder were to have their charges dismissed after 10 years, but then after the repeal of the death penalty, it was inadvertently, with no discussion, reduced to 5 years, resulting in unintended consequences. Reverting back to the 10 years will allow more time for defendants to receive services and to become competent. Cases that kind of illustrate this. I had a defendant with a mental illness broke into his neighbor's house, attempted to rape her. He was eventually found incompetent, not restorable, and civilly committed. 159 days after he was civilly committed to the hospital, they released him back to the same street where he lived with the woman who he attempted to rape. I had another case where a defendant murdered his intellectually disabled girlfriend. He brutally tortured her over 2 days until she died. He confessed, was charged with murder. He was incompetent for 5 years, but he was living in a community program where he had to have 1-to-1, 24/7 supervision because he was aggressive and threatening to their vulnerable disabled clients. His charges were dismissed and he's now free in the community. And I believe he would have become competent had we had more time. I currently have a defendant who raped a 6-year-old girl over months. He is currently charged with rape, but he's incompetent. He's living in the community, receiving residential services, more services than he's ever had. Passing this bill will not violate the constitutional rights of defendants with disabilities. Every 6 months, competency is reassessed. And if a judge finds a defendant is not restorable to competency, those charges will be dismissed. That will not change. Defendants will only be committed if there's a likelihood they will become competent. And just real quick, this only applies to dangerous defendants. It's not mandatory. Judges can dismiss these charges at any time. So for all these reasons, to protect our vulnerable citizens, we ask that you we urge a favorable report. Thank you.
I'm Troy Turner. I'm the father of Sarah and Jacob. I'm here to ask you to move forward with 449, please. This is, I believe, my 4th time here. Some of you I recognize. If I saw you in the mall, I could come up and say hi. A lot of the kind of technical stuff my attorney wrote out for me, she's already covered, so I can just kind of get to just how I feel and why this is important. My job is to protect my family. My job has become to try to protect the community, quite frankly, because whenever you're given something, then you have something required. The community has given my kids a lot of support, searching, a lot. And so that's why I'm here. I'm here to protect my kids, your kids, not just kids, but as we spoke about, people with disabilities. The gentle lady back here was speaking earlier of for disabilities. I want to make sure we're having the right conversation. You cannot get an NCR when you are incompetent, and you don't go from NCR to incompetency. That's not how it works. My kid's biological mother isn't even NCR. She has no charges pressed. My oldest son, their older brother, is at home, and we're afraid that she is now going to get out because she's on a step-down program in Perkins being civilly committed. I think it's important that you know she was civilly committed before she killed my 2 kids. She came out, I had her committed. She came out, we had a family plan in place. She murdered my 2 children, was coming back for the 3rd. And had we not done things that we have done, I was actually told by attorneys that she may have even gotten a visitation or something whenever she got off, because there's no charges even. 5 years is just simply not enough. I think if I asked anyone to take a vote in here, you know, if you believe someone should have the same bar set for them, if they steal a TV that's worth $1,000, or if they kill 2 children, I don't think anybody would raise their hand. That's where we are right now. It's the same bar, 5 years for any felony. All we're asking for is that it get fixed. What was a mistake? It just was never talked about. It wasn't thought about. So when the death penalty got taken out, so did those statutes. And now that's where we're at. So we're just begging you to fix this so that now we can move forward. And families like the ones that you heard from earlier, who I spoke to out there, God bless those women. We're just asking that we can move forward and that you help us and help protect your state. Thank you very much. Testimony, and as always, as I said last year and before that, prayers are with you, and we hope to get this bill passed. And thank you all for giving me the privilege to be able to sponsor this bill. Thank you, and we're going to do all that we can. Thank you.
Thank you, Senator Muse, and Mr. Turner. Thank you for coming up again and again and staying engaged. So appreciate it.
You're gonna get to throw me back next year, son.
I know you will.
Yeah,
That's right. All right, we do have some additional witnesses signed up. We have Kirk Wolfgang, who's here. Is he still here? Sign up favorable with amendments. What about Michael Bronstein? Or is Michael Bronstein still here? If not, we're going to switch to the opposition panel. Lucine Parsley and Kimberly Watts.
And Mr. Chair, I think Ms. Parsley just stepped out. We thought it was the sponsor only testimony. So I'm happy to start if you'd like me to. Thank you. Court's indulgence. Well, I guess I'm not in court. So we certainly understand the position of Mr. Taylor. And if this bill were limited to murder, perhaps we would have a different position. But it certainly seeks to expand beyond what the original fix says it would. When you look at my written testimony incorporates the data of how long people stay at various facilities. And I would say that as it's written, the bill goes further than perhaps it needs to in order to address the problem that it seeks to solve. There are procedures in place for intellectually disabled people to get the services they need. Whether the Developmental Disabilities Administration is doing a good job of that is a separate question and an important question to ask, I think. But the reality is that the Constitution says that once somebody is no longer competent, they need to move on to trial. And so for those reasons, we are opposed to this bill.
Thank you very much, and thank you for sharing. And as I said earlier, I understand. I think the original intent is more important than some of the concerns that are being raised. To the extent that we're willing to sit down, work out amendments so that this is something that all of us can agree.
We are happy to talk. I think you
Great.
probably know where to find Ms. Hilliard from our
Yes,
office.
absolutely.
Thank
I
you,
do.
sir.
Thank you very much.
All right, further questions from the committee? All right, with that, that'll conclude the hearing for Senate Bill 449. We'll now move on to Senator James. Are you ready or? Or not?
Okay. Oh, just kidding.
Excellent. All right, we will then move on to Senator James with Senate Bill 424.
It's okay for my witnesses to come up, maybe. No, come on. Yeah, I sat it first. Good afternoon. For the record, Senator Mary Delaney James representing Harford County, and here testifying on Senate Bill 424. Before I get into my official formal remarks, I just want to remind the committee that I've been working with the state's attorney's special victims unit. This is one of the 3 bills I'm doing with them, and it's a top priority, and they do limit their priorities each session to bring what they think are the most urgent bills needed in any given year. And while our bill is driven by domestic violent abusers not being properly brought to justice, the logic and justification for this bill is broader than that. I'm going to discuss the sort of boring but in technical aspects of the bill, because for those that are not lawyers, or for all of us that try to forget all we learned in law school about hearsay, confrontation, and exceptions, I'm going to just give a little background on the bill. The prosecutors are here really to give you the real stories they deal with every single day in court, the injustice that's happening for victims of domestic abuse, and make this bill real to you. So Senate Bill 424 adds second-degree assault to the statute that allows prosecutors to introduce statements in a criminal trial when a witness is unavailable and when that unavailability was caused by the wrongdoing of the criminal defendant. The statute to be amended is called the unavailability of declarant statement due to wrongdoing. And it is substantially the same as the Federal Rule of Evidence 8-4B6. Both codify the doctrine of forfeiture against wrongdoing, which stands for the proposition that although an accused defendant in general has the right to confront a witness against them, a court will not suffer a party to profit by his own wrongdoing. This has been upheld by the Supreme Court repeatedly.
And while forfeiture by wrongdoing is recognized either by statute, rule, or common law in every state, the bill's sponsor could find no other federal or state jurisdiction that limits its use, as Maryland does, to only felonies. Rather, everywhere else but Maryland invokes the doctrine in any criminal case where a criminal defendant uses force, threats, persuasion, control, wrongful disclosure of information, collusion, or any other behavior that creates a nexus between the defendant's acts and the unavailability of the witness. While Senate Bill 424 does not seek to eliminate the seemingly inexplicable difference in treatment of defendants charged with felonies and those with misdemeanors, when both defendants engage in this wrongdoing that keeps a witness from testifying, it does seek recognition and equal treatment for the serious and violent charge of second-degree assault, for which by its definition is a crime of violence and involving non-minor injuries and up to 10 years in prison. During the hearing, my colleague, Senator West, brought a bill, SB 209, extending deadlines for the task force to study criminal classifications that the committee, I'm dry mouth. The committee was provided with a December 29th, 2023 letter that gave the task force work so far, but salient to this bill, the letter highlighted that the two preeminent scholars repeatedly highlighted Maryland's second-degree assault statute as being an outlier because of the harm to victims and the high penalty do not match it being called a misdemeanor. Rather, in substance, it's analogous to a felony. This mislabeling is allowing a miscarriage of justice under the forfeiture by wrongdoing statute because it's depriving prosecutors of the opportunity to go after domestic abusers, as they are most often charged with second-degree assault. They can speak to that. And their frequent modus operandi is to intimidate and coerce and manipulate their victims into backing out of appearing in court to testify. So you have a brave and battered woman. She finally calls the police for protection. She gives them a recorded statement, but it takes months for that trial, even with speedy trial, to get to court. And during that interceding period, the abuser coerces, scares, intimidates, promises, whatever they do to keep her from coming into court. Under this bill, we would add that situation and allow prosecutors to put into evidence her previously recorded statement, and we would prevent another abuser from walking free. So with a favorable report, Maryland can stop being an outlier. We can get behind our efforts to protect victims of domestic violence. We can hold abusers accountable. Thank you, Mr. Chairman.
Good afternoon, Debbie Feinstein, Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm here today to testify on behalf of the Maryland State's Attorneys Association, as well as my office, the Montgomery County State's Attorney's Office. I want to thank Senator James for bringing this forward. This came to my attention when one of my team members came to my office with a very serious second-degree assault case. The facts included a significant beating, but the outcome did not necessarily mean that it was going to rise to the level of a first-degree assault. She came to me because there were a ton of jail calls that demonstrated that the perpetrator had been reaching out to the victim to convince her not to come to court and to threaten her, to cajole her, to coerce her not to come to court. But what we realized in looking at the forfeiture by wrongdoing statute in its current iteration, the forfeiture by wrongdoing does not apply in the way that is laid out now. That's actually it's different than what Crawford, which was the initial case that really limited the testimony, hearsay testimony, I think intended, given what Senator James was saying about how other states handle this exact same scenario. So what we're asking the legislature to do is to really close a gap. And as Senator James indicated, the second degree assault is certainly a significant, and it's considered a crime of violence under the public safety article. And we see that in practice every day in our domestic violence cases. What I talk to my colleagues about and my team members about is when we see a victim of domestic violence not come to court, which we see quite frequently, unfortunately, I actually have encouraged them to say the victim, it's not that the victim's not cooperating in the prosecution, it's that the victim is not participating in the prosecution. And that can come for so many reasons. When that reason is wrongdoing, we should have a clear path to be able to use their prior testimony. It's not, or not prior testimony, their prior statements. And it's not just any statements. The statements have to be taken under oath, subjected to cross-examination, or contemporaneously recorded, body-worn camera, 911s, et cetera. May I point out one last thing, please? Very quickly, I would also point out that this is not limited to use just by the state. It actually, the statute as it is currently written says that it can be used by any party. So I wanted to be clear about that as well. Thank you. And I urge this committee's favorable report for Senate Bill 424. Thank you.
Good afternoon, Chair Smith and Vice Chair Waldstreicher and esteemed members of this committee. My name is Katie Kern O'Malley, and I am the Executive Director of the Women's Law Center. A point that I think was just brought up is a really important point about this this bill, that this change will allow either party in a criminal case to use the forfeiture by wrongdoing exception to hearsay, which is important, but as it applies to victims that we serve in the Women's Law Center, many of the victims that we represent in civil cases also have corresponding criminal cases. And I know from 20 years of sitting on the bench and dealing with domestic violence cases, oftentimes, as we just heard, the victims don't show up, and we don't necessarily know why they're not showing up. There could be a variety of different reasons. But in a situation where there's wrongdoing, it should be available to any party, whether it's the state or the defense, but in a state case where we were talking about domestic violence, if the state is able to show that there was some sort of coercion, intimidation, or something even more serious, there should be an allowance for this exception, because it's allowed in felony cases. And in second-degree assault cases, we see things as a push or a shove, but then as just talked about, some very, very serious injuries that don't rise to a first-degree assault, but are significant. And we know that with domestic violence cases, the injuries sort of ramp up. So things do start oftentimes in a very subtle way, in a coercive way. And as the relationship continues, things tend to get worse and worse and worse. So for those reasons, the Women's Law Center urges that you give a favorable report on this Bill 424. And thank you, Senator James, for your sensitivity to this issue. Thank you.
Good afternoon, Mr. Chairman and committee members. My name is JC Smith. I'm an assistant state's attorney in Baltimore County, and I'm presenting to you in support of Senate Bill 424. In contemplation of this bill, I would like you to consider the following set of facts that Assistant State's Attorney Madison Frank, who's to my right, and I were confronted with last year. We were assigned a second-degree assault domestic violence case in which the defendant was on probation for assaulting the same victim when he picked up his new case. He had a long and violent record, extensive history of domestic violence. In our new case, he was charged with beating the victim while she was pregnant with his child, leaving extensive injury to her face and her body. Collectively, between the time he was facing in our case and the time he was facing on his case for which he was on probation, it was about 16 years he was looking at. Pending trial, the state collected jail calls between the defendant and the victim, who he is ordered to have no contact with. In these jail calls, he instructed her to avoid service and that her noncompliance with service would result in his acquittal. The state spent weeks trying to get her to come out of her house to be served, to no avail. The state even was able to secure a body attachment for the victim through the presiding judge, and she still refused to leave her house. The defendant and his family went through such measures to facilitate the shipment of groceries to her house, and even had his family walk her children to school so she couldn't leave the house to be served. She failed to appear for trial, and we were unable to get her statement that she made to police, in which she identified the defendant as the individual who beat her. It was recorded on body-worn camera because of the current forfeiture by wrongdoing statute. It's codified in Courts and Judicial Proceedings 10901, and it applies to felonies only. If this violent defendant is able to procure her unavailability by wrongful means, why does he thereby get to benefit from the hearsay rule designed to protect him just because it happens to be a misdemeanor? If a second degree assault would have been included in the statute, he would not have the opportunity to benefit from his unlawful conduct in trial, and therefore I urge a favorable report. Thank you.
Thank you very much.
Mr. Chairman and committee members, thank you so much for this opportunity to speak before you today. My name is Madison Frank, and I'm an assistant state's attorney for Baltimore County. In today's world, individuals charged with committing crimes dedicate an enormous amount of energy and time attempting to hijack the justice system. They do this by intimidating the victims and witnesses that the state has vowed to protect. They do this by soliciting friends and family members to encourage those victims and witnesses to not participate in the process of prosecution. That is exactly what happened to Ms. Smith and I's case. I wish I could say that our case was an outlier, but unfortunately, it is not, and it is particularly prevalent in cases of domestic violence. While we believe that this law will apply to many of our cases, it will especially impact DV cases. As a DV prosecutor, I am constantly faced with reality that either through threats or manipulation, offenders continue to pull the strings, even when they are incarcerated pending trial. Many of our cases are charged with misdemeanor assault, and as the law currently stands, defendants benefit from procuring a victim's absence simply because they are not charged with a felony. Victims of DV are faced with many challenges when a case is brought for prosecution, often relying on the offender for financial support. They share children in a home with them and are otherwise entangled in the cycle of abuse. It is challenging enough to convince a DV victim to hold their abuser accountable. But when that abuser is able to use threats and manipulation as a means to escape prosecution, it becomes an almost impossible feat for the state to overcome. It defies logic to allow a defendant to benefit from his meddling in the justice system. Why should we limit this law to only apply to felonies when thousands of domestic violence victims or violence cases are charged with misdemeanor assault? I ask y'all to please consider how we not only protect victims who do come to court and testify, but also how we protect those who are too frightened and too entangled in the cycle to do so. This law will allow the state to forge ahead and protect those who struggle to protect themselves and tamp down on those who attempt to dismantle our justice system. I urge you to consider a favorable report for Senate Bill 424. Thank you all so much.
Thank you very much. Questions from the committee? All right, Senator Sidor.
Thank you very much. Just out of curiosity, are there any other states or federal court that whose exception is similar to what is being proposed here?
Senator, in my own testimony, I indicated that I had surveyed it as far as I could go. I could find no state that does what Maryland does, which is to exempt out this crime of violence. But that is because really Senator West's bill and that task force shows that Maryland has just a very, very antiquated criminal code. We have misdemeanors and felonies in categories that defy logic to any other state. That's what I told you, the legal scholars in my testimony used second degree assault as probably the poster child for how out of step our criminal code is. It shouldn't be a misdemeanor. It's 10 years in prison. It's serious, it's beyond minor injuries. So this in any other state would be a felony. But more importantly, there aren't any states I could find. Now look, I did as many surveys as I could where Maryland's the only one that doesn't allow for this kind of testimony to be used, these recordings, because of this odd categorization of second degree assault. We're the only one I could find. Most states in the federal government, for which our rules are based on, right? Rules of evidence, they don't limit it at all. The rule is, I have the rule, I have a copy of it, but I referenced it in my testimony, 804 B6 or 6B. That federal rule, which was held up by the Supreme Court in Crawford and Davis, 2004 and 6, that was held up, says you can use these out of court statements if you've caused the witness not to be in court for any case. It's just, that's the rule. So Maryland is an oddity in every sense of the word, and certainly inconsistent with the federal rules and every other state I could look at.
For the assistant state's attorneys from Baltimore County, I'm curious, how did you end up resolving the issue with the person being prosecuted and his attempt to stop his, I'm assuming ex-girlfriend is from testifying?
We resolved it with great difficulty. We were able, through a hearsay exception, the identification exception, to have her pointing at the defendant walking upon scene, to use that as to identify him as the perpetrator. He also testified, and based on some of the statements that he said, we were able to put on a rebuttal case in which we had jail calls. The victim explain what had happened on that day based on his own testimony. But as you know, it was his choice to testify, and in most cases they choose not to. So it was a very rare circumstance in which we were able to be successful. It was an uphill battle the entire time because of her avoidance of service.
For the sponsor, I have another question for you. And the reason for this question, I mean, I guess as I'm listening, if you're attempting to procure the unavailability of someone that might speak out against you and you've committed some kind of crime, I'm just curious why. All right, the state has limited it to felonies. You want to limit it to felonies and assault in the second degree. My question is, why should there be any limitation?
Well, I'm not going to disagree with you on that, but I do think just
asking.
because we have a major commission looking at cleaning up our criminal code, almost like a revision of the annotated code from soup to nuts, because this isn't our only problem. But fortunately for me, when Senator West brought that bill forward, I read their report and I saw that they were just pounding on second degree assault. So I said, yeah. So I'm not against that idea, and it would put us in line with most other states and federal jurisdictions. But this is the most pressing issue we have, which is second degree assault, which very clearly is a crime of violence with a very severe penalty. My worry would be there could be, depending on the policy, the state of Maryland, there may be policy considerations for not including all misdemeanors or using in all circumstances. I think I would sort of support that, but I think that's a bigger policy decision. This, I think, is really low-hanging fruit. It's clearly an odd, strange way we treat a violent crime and just label it a misdemeanor. And for that technical reason, it's not covered by a statute that should cover it. That would be my answer.
Excellent. Thank you very much, Senator Sidnor. All right. With that, that'll conclude the testimony for this panel. Is Christine Reichert here?
Oh, she had an emergency and was unable to be here.
I'm sorry. I hope everything's okay.
Yep. Thank you.
I'm assuming that Ms. Rafter is Andrea Rafter here? She was with the Women's Law Center. I'm assuming that's.
Oh,
that was
there's Andrea actually submitted the testimony, but I'm here on behalf of the Women's Law Center.
excellent.
Thank
Of course,
you.
that's what I assumed. All right. Thank you. Sir, yes, Senator West has one last question.
And it's for Judge O'Malley. You were on the bench for a lot of years. What would you think of an amendment to the statute which would allow these statements? If someone procures the absence of another witness by threats, force, whatever.
Wrongdoing.
Why shouldn't we allow out-of-court statements by that person to come in under an exception to the hearsay rule? Why are we limiting it to felonies and assaults?
I don't know. That's why I'm supporting this bill. These are difficult cases, even when you have a situation where you have a felony and you want to use forfeiture by wrongdoing. They're not easy. They're tough for either side. And that's why this bill also allows both parties in a criminal cause, so the defense as well as the state, to use this exception. I do not know when that law determined, that evidentiary rule was determined to only allow it for felonies and not for misdemeanors. I'm not sure what the rationale behind that was. But this, again, would be a great step in, certainly the clients that we serve and the criminal causes that they have. But also, again, it's, just for all parties in a criminal cause, they can use this.
Thank you very much.
All right. Thank you very much. Thank you, Senator James. With that, that'll conclude the hearing for Senate Bill 424. We'll now move on to Senate Bill 744.
For Senate Bill 744, Mr. Chairman, Mr. President, please come on up, and anyone whom you would like on your first panel. Whenever you're ready.
All right, Mr. Vice Chair, members of the Judicial Proceedings Committee, it is a pleasure to be here with you all this Friday afternoon. Thank you so much for all of the hard work and hours you put in this week. I know it's been a long week already. It was a long week last week. So just thank you for your ongoing dedication. Look, this is a really important issue, and I want to sort of set the context. Many of you all will remember sort of the tragic news in July about news reports of something that had happened in Brooklyn. For me, that was a call at about 4:30 in the morning in which the mayor of Baltimore called and said, "I'm really sorry to tell you this, but we've had a mass shooting." There weren't any details at the time, and it was a horrific situation that next day, being down there with families. And I will never forget the one thing being there for several hours that next morning was how quiet it was, just how quiet. Because something had been shaken in Brooklyn homes. And lo and behold, with the unfolding of multiple investigations, it was ultimately an event that got out of hand in which there were too many firearms. One shot was fired, and all of a sudden it became much more severe. And through the investigation, we found that there were several young people involved, potentially as shooters, but most certainly as victims. And it put a highlight on what was already a very real concern about this challenge that young people are facing that is historic. A situation of post-pandemic times where we know that social and emotional health has been challenged more so than probably almost any time in human history. Secondly, the amount of firearms that are available, whether or not one is for or against firearms. I think you all hear it every single day. There are more firearms bought and sold in the United States and in Maryland right now in this past year than ever in the history of this country. It's why for the first time in human history, the number one cause of young people between the ages of 0 to 18 is firearms. The first time in human history. And three, with the advent of social media and the impact of what can happen in just a moment, we have young people who are facing something that no set of young people have ever had to face before. And so we have done important work. And I want to commend members of this committee who have worked incredibly hard to try to set up a system that deals with these historic confluence of impulses and stimuli. And several years ago, when we did our juvenile justice reform, that was a thoughtful panel that worked for several years. And thank you to Senator Carter for serving on that commission to work through the various parts of this complex juvenile justice system to try to provide a better way forward so that we can rehabilitate, because that's the fundamental purpose of what that system is built around. After the Brooklyn Homes event, and with several other events that happened, I'm sure that many of you all will remember this interim, the calls for a special session, an emergency. We have to do something emergency right now. Well, there was no question that in those moments of real tragedy and of real pain and frustration and sorrow, there is an impulse to just do something. But when it comes to the juvenile justice system, it's too important. We can't just do something. It has to be thoughtful. And I had a conversation with a number of the members of this panel, of this committee, and with Chairman Smith, saying we need to dive into the details. We need to see what's working, and we also need to see what's not working. We can't just jump at a solution. We have to do the study and work so that when we come into session, we have a panel of options that we can pursue that can improve outcomes for kids and for communities. Because what we know is that in the targeted areas where there are severe and objective challenges, young people too often being involved in carjacking and auto thefts, and too many young people being the victims and perpetrators of gun crimes. In those two objective areas, we have got to improve our system, and we've got to give better outcomes for kids and the communities that are feeling like they are under attack from situations where they don't feel like there is a system responding to their needs. I've said this before, and I believe it to be the case. Juvenile crimes involving young people is less than 10% of all violent crime in the state. However, what we know is that when it involves young people, there is an outsized impact on the perception. People don't want to believe that young people are involved in these violent incidences. They don't want to believe that our system can allow such things to happen. The sad reality is, because of the forces that we're experiencing here in the state of Maryland, but also across our entire country, young people are suffering and communities are suffering as a result. We can and must do better in this targeted area. And the bill that you see before you, I want to thank this committee and the conversations that you've had, the work that the chairman has done to lay out a set of options for us to respond to a very important moment for the state of Maryland. So thank you for your consideration. I'll hand over to the chairman on the details, but appreciate this committee's dedicated work ahead.
So thank you very much, Mr. President, for those words. And Mr. Vice Chair, members of the committee, Senator Smith here to introduce Senate Bill 744. Now, before I get into the details and walk you through kind of page by page and section by section, I do want to reiterate that something that I said when we first had a press conference surrounding this issue, and that is that the juvenile justice system is premised on, yes, accountability, but also rehabilitation, with a heavy emphasis on rehabilitation. And the work that this committee and that this General Assembly has done over the last few years, specifically with regard to JJRA, has put us on a path toward a more equitable juvenile justice system and will ultimately make us a safer state. And so the legislation that we offer today, the options that we offer today, are really focused in on sharpening those intentions and holding our entire system accountable. This legislation seeks to address the points of failure that have left too many of our youths without the proper supports and that have ultimately made our communities less safe. Now, I will say something about stakeholder engagement. Now, there's been sharp rhetoric that has fallen on the fringes on both sides of this issue. But the good thing is that we all want our system to work. We all want better outcomes for our youth, and we all want our safer community. Now, this legislation marks the start of that dialogue, and we've already been hard at work. I've met with the Office of the Public Defender and gone line by line over this bill. I've met with the state's attorneys and gone line by line through this bill. I've met with the Department of Juvenile Services and have gone line by line through this bill. All of those opinions will be incorporated into the work that this committee will engage in the next couple of weeks. And all those opinions have been and will continue to be valued. Now, there's been a heavy emphasis on the data-driven process of JJRA, and rightfully so. And as the Senate President mentioned, less than 10% of violent crime in Maryland was committed by juveniles. But we have seen a noticeable increase in weapons-related offenses, auto thefts, and carjackings. You'll hear a lot of specific data from jurisdictions in the panel behind me. It is important to note, however, that when there's no paper trail to validate a risk assessment tool, when it's taking far too long to get into services, when the quality of services aren't always evidence-based, when people simply do not participate in the services that they need, we don't always have the best granular data, and that information doesn't always fit into a spreadsheet that we can evaluate. But we all agree that those are significant points of failure. The state's attorneys agree that that's a point of failure. Those are points of failures. The Office of the Public Defender agree that we're failing in that regard. And yes, the Department of Juvenile Services agrees that we are failing in that regard. I also want to emphasize that this session, we are taking a holistic approach. We've put $43 million into creating the Governor's Office of Children to ensure that there's a single entity responsible for tracking youth across these agencies. We've expanded the commission, which we'll hear a little bit later, on juvenile justice reform to include representation from all organizations responsible for a child's well-being in the system. So we are taking a holistic approach. Now to the components of the bill, which you can walk through together. The bill is essentially broken into two pieces. The first piece has the substantive changes to the law, and the second piece really regards the commission and the juvenile justice monitoring unit. The demarcation line there is page 13. So I'll go through. First, the bill expands the Department of Juvenile Services jurisdiction to initiate delinquency proceedings against youths aged 10 to 12 for the following offenses: all firearm-related offenses, third-degree sex offenses, crimes involving animal abuse, and theft of a motor vehicle. It is important to note here that this is discretionary. There is no mandatory detention, no mandatory extensions of probation, and no mandatory in-community supervision. Second, the bill seeks to lengthen the potential length for probation for both felonies and misdemeanors, and it extends that. So in the current law, for a misdemeanor, you can have probation extended for up to 3-month increments up to a year. This bill seeks to extend those increments up to 4 months, up to 2 years for those misdemeanors. Again, discretionary. This is just the potential amount of time that you could be placed on probation under these circumstances. For felonies, again, current law says you can go to 3-month increments up to 2 years. Up to 2 years, we're extending that to 4-month increments up to 4 years. Again, discretionary. It's the maximum amount of time that you can be extended for probation. The bill also shortens the length of time in which DJS has to make a decision as to whether the court should be involved in the judicial action that's in the best interest of the child or to the public. It does this by shortening that time from 25 days to 15 business days. Fourth, there's a mandatory forwarding of complaints for certain offenses to the state's attorneys for delinquent acts. That's all felonies or anything that occurred while the child was already under supervision. There's also a mandatory filing requirement for acts committed by the child under the age of 13 that result in the death of a victim. It's a mandatory sins petition. That's an idea that we garnered from Senator Carter's bill, and that Senator Carter's bill is forthcoming. We will consider and we will pass that again as we did last year. The police must also file a written report or a citation for every arrest of a child. This is to create that paper trail. Again, in working in concert with all of the stakeholders, the Office of Public Defender has offered amendments which are reasonable here. The chiefs and sheriffs have offered amendments which are reasonable here. We're going to take those into consideration as we go through this process and incorporate them into this bill. A child may be detained by DJS for an alleged misdemeanor if the child was already under DJS supervision and the alleged offense would carry a potential sentence of more than 90 days if that offense were committed by an adult, or you would have been adjudicated delinquent 2 times. The current demarcation line in the law now is 2 times within a year. We've extended that for 2 times within the lifetime. The bill also seeks to streamline the hearing process. So if a child is in DJS detention, the law says that you have to have a hearing to reevaluate whether detention is necessary every 14 days. We have created an option that can be waived once if all parties agree, if the state's attorneys agree, if the child's attorney agrees, and if the court agrees. Missing treatment no longer constitutes a technical violation. Under JJRA, if you were ordered to have treatment and you missed, that would be a technical violation. You couldn't have your probation extended. You couldn't be supervised or detained. There has been a lot of discussion about the future options for this particular aspect of the bill. Some of them are reasonable. The Office of Public Defender has offered some very good solutions. So too have the state's attorneys. So we'll take those amendments. They're in your bill file and under consideration in our work ahead. And then finally, there was a lot of discussion about the Child Interrogation Protection Act over the interim. We have not touched that. That is a good piece of legislation into law. It is functioning and it will work. It does not hamstring law enforcement. We've attached budget language to ensure that law enforcement agencies across the state will receive the necessary and proper training to properly enforce the law under the Child Interrogation Protection Act. Now, the second part of the bill, as I mentioned, deals with the Juvenile Justice Monitoring Unit, which is currently nested under the Office of the Attorney General. The bill here seeks to give that office the ability not only to report upon the incidents that happen within the Department of Juvenile Services Correctional Facilities, but also to evaluate programming and to identify gaps in programming and to offer solutions. Now, we've had a discussion with the ombudsman bill, the correctional ombudsman bill, and those discussions talked about maybe potentially removing that, creating an independent entity. We're going to have discussions I've had with almost every member of this committee about potentially moving the Juvenile Justice Monitoring Unit from under the Office of the Attorney General and creating something that makes sense and arming that unit with, yes, subpoena power as well. We've also, as I mentioned before, there was a commission on juvenile justice reform and emerging and best practices. We've added new members. You can see that. That's on page 20 to 22. We've added new members to that and given them new responsibilities and reporting requirements to go to the governor, the General Assembly, both houses of the General Assemblies. They'll have an oversight role and they'll be responsible for promulgating recommendations on a continual basis as to how we can improve our juvenile justice system. And with that, Mr. Vice Chair, and Mr. President, thank you both very much. That's the sum and substance of the bill. And I'm going to invite the next panel up to start off the discussions for the evening. If you'd like to call the panel.
Thank you, Mr. Chairman. Thank you, Mr. President. I do have those signed up here, but perhaps you have a particular order of the panel that you'd like them to come up. Okay, so let's get our elected state's attorneys up here while the chairman's returning. Ms. Braveboy, Mr. McCarthy, Mr. Schellenberger.
And Mr. Gibson.
Okay, good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the Judicial Proceedings Committee. For the record, I'm State's Attorney Aisha Braveboy from Prince George's County. I'm here today to speak in support of this very important piece of legislation. We know it's just a start. We know that there will likely be amendments, lots of discussions, and we are very open to those discussions. But I just want to give you some information on why I think it's so important that we address this issue today. Last year, we had about a little over 1,000 petitions referred to us from the Department of Juvenile Services. And that does not represent all of the young people who were arrested in our community. This really represents those who are arrested and charged with felony offenses. And I want to point out that specifically, we had 199 charged with armed robbery, 314 with motor vehicle theft and those related offenses, and 89 charged with armed carjacking, which represented about 60% of all carjacking arrests. So clearly there are some issues that our young people are facing. We want to ensure that there is a system that has transparency, accountability, and real services that the kids are getting and that they are required to get. And so this bill, I think, establishes a framework for not only holding young people accountable, but also for holding those of us who are responsible to provide the services for these young people accountable as well. So we look forward to the conversations, questions, and we hope that we can bring these numbers down next year. Thank you.
Thank you, Madam State's Attorney. And just generally speaking, we don't have limits placed on elected officials, but this is a unique circumstance just because of the sheer volume of witnesses. So we're going to ask that for every side, everyone's held to 2 minutes for the elected officials.
Good afternoon. My name is John McCarthy, State's Attorney for Montgomery County. First of all, I want to thank the sponsors, particularly the two chairs of this committee, worked so hard on this literally for months. I think this bill is actually balanced. It is not a giveaway to the state's attorneys around the state. I will tell you what's in the bill. Each and every provision is something that was uniformly identified as an issue in every one of our 24 jurisdictions. I don't speak here just for Montgomery County. I think I speak for everyone. Now, whether you're talking about the length of probation, the shortage of resources to get kids into treatment, whether you were talking about how we're going to deal with technical violations where kids were literally blowing off probation, whether we were going to give the state's attorneys the power to go back and to review felonies. There are a number of different aspects to this bill, and it has addressed many of the consensus issues that have been brought up in our conversations over about the last 9 months, really. We are not just here. Look, DJS does lack adequate resources to deal with the problem in terms of providing services to children. There are 793 total beds that DJS has to provide services in this state, yet 1,600 kids basically referred to those 793 beds last year. State's attorneys see about 30% of all the cases come into DJS. Only about 30% go to the prosecutor's offices here. My county is no different than any of the other counties. We've seen gun crimes go up for kids over 220%. Auto thefts up over 200%, robberies up over 200%. Last year, 40 young people in my community were shot, and 96 people were seriously injured. This is a time for action. I will say, I did hear what the president said a couple of minutes ago about how juvenile crime is a small part of crime overall. But I will tell you, when it comes to carjacking, in the instances where we've made arrests for carjacking in my jurisdiction, 70% of the arrests in the cases that have been closed, the offender has been a juvenile. I urge favorable vote on this bill. Thank you.
Good afternoon again, Rich Gibson, State's Attorney for Howard County, President of the Maryland State Attorneys Association. Today, I'm here to ask on behalf of the prosecutors of the state for a favorable report for SB 744. Is the bill perfect? No, but it's a substantial step in the right direction in ensuring fairness in the treatment of juveniles involved in crimes and protecting the safety of the public. In particular, the prosecutors of the state are pleased the bill expands juvenile jurisdiction to categories of crimes, including weapons offenses, third-degree sex offenses, and motor vehicles when the children committing these crimes are up to the age of 10. We are pleased that it will require more rapid communication between DJS and state attorney's offices from 25 days currently to 15 days. Additionally, requiring that all felonies and handgun offenses are forwarded to us for review. Just because we review something doesn't mean we'll prosecute it, but at least we'll be aware of what's going on, because right now we're not. Moreover, we're pleased that it's changing the definition of non-technical violations for probation for children that are found fact sustained involved in criminal involvement. One area of concern that we hope will be addressed, but we understand it's a challenging issue, is the area of the Child Interrogation Protection Act. We hope that will be revisited at a future point in time. However, the perfect should not be the enemy of the good, and the prosecutors of this state believe that SB 744 is good and will promote a safer Maryland. Thank you.
Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. So since we're down to 2 minutes, I won't have the time to read all these news articles to you about all the juveniles who have committed violent crimes. I only had to Google it once, and they kept coming up and coming up and coming up. But yesterday, when I went home after testifying on the House bill that's exactly like this, I just thought I'd Google one more time, and here it is. Juvenile taken to the hospital amid shooting investigation in Lansdowne. That's in my county, all counties. It happens all the time. So juvenile court is designed to help the juvenile and the family and his family so that we don't see them again. Why would we ever want to limit the length of time they're on probation if we're trying to help them? I want them to be helped so that when they commit the crime as a juvenile, I don't have to see them as an adult. So one of the great fixes, I think, in this one is lengthening the amount of time that you can be on probation in a misdemeanor up to a year, in a felony up to 4 years. I think that's really 2 years automatic, and then you can ask for it to go farther. I think that's a real sensible approach. The other thing that doesn't make any sense, one of the articles that I did pull is the 12-year-old who walks into an Anne Arundel County school with a loaded gun. And all of a sudden we look at the law and we're like, oh, we can't do anything. What, you mean you walk into a school with a gun and you can't do anything? And remember, we're not talking about charging him as an adult. We're not even talking about necessarily putting him in detention. We're talking about getting that person the help that they need, that their family needs, so that 4 years from now, when they're 16, 17, or 18, I'm not sitting in a room with a family because they lost a loved one who died as a result of that person not getting the help they needed. I urge a favorable report.
So thank you very much. Questions from the committee? Senator Sidnor.
Good number of questions. First of all, to my state's attorney.
Yes, sir.
I know you served on the Juvenile Justice Reform Council, correct?
Yes.
And when you served on that council, did you represent Baltimore County or did you represent the State's Attorneys Association?
My recollection is I represented the State's Attorneys Association.
And you voted with the rest of the council to move forward with the legislation and the recommendations?
I think if you go back and look at the hearings, I very often was the only one to vote against things. Chris West was there. Senator West was there. There were a lot of times where the vote was something to 3. I can't remember who our third friend was. But yes, I voted against a lot of things. However, you are correct. At the end of the day, I supported the group because I felt like I had to do that because I got outvoted. But that doesn't mean it was wrong when we did it then. And we're not rolling back everything in Senate Bill 744.
but we're taking a look at some of the things we did and say, hey, this wasn't such a good idea. And I come to the issue of the length of probation as the most obvious choice.
For most of this, I guess the bulk of this legislation, when you talk about the change that's being noted in, yes, beginning on page 3, lines 3 through 12. Who are we talking about that would now be essentially prosecuted under these new additional crimes?
Prosecuted in juvenile court would be an individual who is over 10 and creates a crime of violence. We recently had a case in Baltimore County where a 14-year-old was driving the carjacked car and there were 2 other 12-year-olds in the car who participated. So that individual needs to be in juvenile court to get the kind of treatment that they need to get. B, a crime involving a weapon. That 12-year-old who walked into that Anne Arundel County school needs to be in court in front of a judicial officer. And even in that courtroom, there may be questions about to mom and dad, you know, how did this child get the gun? And we need to get to the bottom of that. And that's why we have expanded those crimes on page 3.
So we're talking 10, 11, and 12-year-olds.
Correct.
All right. So the question that I would then have is, do we have disaggregated data to help us to understand how many 10, 11, and 12-year-olds are engaged in these offenses that we're trying to fold into current law?
I don't count those numbers like that. Maybe one of the other state's attorneys can. I do recall seeing one of my articles where yes, I do have something. According to information provided by the Public Safety Committee in Montgomery County, my friend John McCarthy, juvenile carjackings in the state jumped 85%. Handgun violations were up 220% between 2021 and 2023. So those are just 2 of the big examples, which is why we think it's so important to add those age groups in here.
And I noticed you said juveniles. So, but what I'm asking, because juveniles are anyone under the age of 18. So I'm asking about the 10, 11, and 12-year-olds because that's what I'm asking about.
Okay, Mr. Gibson has that.
Thank you.
Good job.
No problem. Senator Sidnor, I have some data that might go to the question you're posing. So in Howard County, this is Howard County centric data. I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases over the last year. At age 11, a harassment with weapons violation, sending threatening text, showing a replica Glock handgun, threatening to shoot a female.
So let's do it just so that it'll be easier for everybody to understand. Section B is a crime involving weapons under Title 4 of the Criminal Article Act. How many 10, 11, and 12-year-olds are we talking about?
Everyone I list fits that category in one way or another. So the first one is age 11, took out a gun.
Just how many?
10. I have 10 over the last year.
Do we have an idea of how many 10, 11, or 12-year-olds are doing this statewide? Because this is a statewide bill.
No, I can only speak to Howard County.
All right.
In Howard County in the last year, Howard County is one of the safest communities in the country. And in one of the safest communities in the country, we had 10 cases in the last year involving 10-year-olds to the oldest person I have is a 12-year-old.
So 10 under for this crimes involving weapons under Title 4. How about crimes involving firearms under Title 5?
No, I'm sorry. I want to make sure I misspoke, Senator Sidnor. The cases I'm referencing are cases of any underage person who would be captured under this particular element of the statute. So if you want me to disaggregate further, I can do that. So
that's what I'm asking.
I'm sorry. Okay, so I have an 11-year-old, first case that was involving a gun. I have another one.
Well, let me do this instead, because again, I'm more interested in, since it's statewide legislation, I'm interested in how many 10, 11, and 12-year-olds, and I'm hoping maybe your organization can provide this data, have committed crimes involving weapons under Title IV. I'm interested in 10, 11, and 12-year-olds who have committed the crimes involving firearms under Title V of the Public Safety article. I'm interested in 10, 11, and 12-year-olds who have committed a crime involving animals under Title 10 of Subtitle 6 of the Criminal Law article. I'm interested in 10, 11, and 12-year-olds who have committed sexual offenses in the third degree under Section 3-307 of the Criminal Law article. And I am interested in 10, 11, and 12-year-olds who have committed theft of motor vehicle under Section 7-105 of the Criminal Law article. And I will say that the reason that I'm asking and I'm being as specific as I can is because I want to make certain that if we're changing these laws, that we're getting to the intended target, the 10, 11, and 12-year-olds. Because I understand that juveniles are committing these. I get that. But I want to make certain that we're doing this right, because when the Juvenile Justice Reform Council sat down to look at this stuff, they had data. And that was one of the reasons why I was supportive of that legislation, because I knew it was data driven. I will tell you that honestly, again, watching the news over this past summer, keep hearing the anecdote after anecdote. I don't want media driving my agenda and my vote on this legislation. I love to be able to say that it was a data-driven vote that I made.
Before you all get a chance, I think, and I thank the senator for bringing this up, because this elucidates some of the problems with. So, for instance, if you were to file a SINS, but not every jurisdiction does a SINS, which is a whole nother problem. So there's no way to track it. But because these are not, right under current law, eligible for delinquency, it's hard to track something you can't do. And so that's going to be a problem with your analysis here. But I just think that the question is elucidates some of the systemic problems. But I just wanted to lay that before you all respond.
May I just I actually heard the same question yesterday. The same question was asked in the House before Delegate Clippinger's bill over there. And may I say, he cited some numbers. First of all, in the last year, the answer would probably be zero in terms of children charged, because the bill went into effect. Could not charge them. So the answer for the last year is zero.
But I wasn't talking about charge.
However, he did mention in his testimony when he was testifying yesterday, I referred to it, and there was a give and take in the hearing between Delegate Clippinger and myself, because he mentioned data that predated the changes, that there were, this is for all crimes, and there are hundreds of different crimes. There were a grand total of 1,100 kids that were 12, 11, or 10 that were charged in previous years prior to the change. Now, I would suggest if you go by Montgomery County data, most of them probably get possession of drugs, maybe shopliftings and things like that. The vast majority of them. Because he had that number, and I said this yesterday in front of him, I think that those numbers are probably obtainable, probably from DJS, from prior years. But they were never, I think that'd be the only reliable person that you could get them from. But I think I do understand your question. I think it's a legitimate question. I think it's probably information you want to have. But I think DJS has those numbers, because, again, the delegate was talking about that yesterday, and that was a large part of our hearing yesterday afternoon. Exact same question.
And since you're up, Mr. McCarthy, if you wouldn't mind, you had mentioned 70% of auto thefts were committed by juveniles.
We begin with the proposition that not all individuals who commit an auto theft, actually, I was talking about carjacking. My 70% number was uniquely related to carjacking. And of the individuals who were arrested and charged, that's the only time you can definitively say who's responsible for the crime. Of those who were arrested for the carjackings that occurred in my county last year, those arrests, and the total was like 41 and it was 20, it's 70% kids under the age of 18. 70% of the carjackers that were arrested. I can't tell you about the cohort that were not arrested, but of those arrested, it was 70%.
And is there, and just for, because I know you know this better than I do, I understand as unauthorized use of a motor vehicle theft is carjacking distinct from those two?
Absolutely.
Very good,
Absolutely.
thank you. And anyone on this panel, please feel free to answer this question. I know DJS has data that shows that when it diverts cases, 92% of the time a youth does not have a new arrest. What data do you all have that show that diversion is not working?
So there are a couple, you want to?
Well, I was gonna say, like, they don't, so DJ.
Would you mind coming up to the?
Oh. And then I'll let you.
Yeah, I'll respond.
Yeah, I was gonna say, so DJS does not divert felonies. So when you're talking about diversion, and I've worked in diversion for a very long time, prior to being state's attorney, even prior to being a delegate. Those cases are misdemeanor cases. And so what is referred to us are really felonies, not the misdemeanors, but the felony cases. So that would be a different subset of that.
I also want to add to that answer. So when you state a number like 90% don't recidivate that are diverted, you have to remember that you're only looking at the people that want to participate. If the DJS reach out to someone and they fail to connect with DJS, DJS doesn't connect to them, it's just the case is closed. It's not counted as whether they recidivated or not because nothing was done. Right. So you're talking about a population that's willing to do something about the criminal behavior in the first place. So of course that number is high because those people are invested in the change. The issue that we have is that we need the tools to attach the requirement that you get on the right path. That's what's missing in that analysis. And that's why that number is sort of a loaded number. As it relates to the disaggregated crimes that you listed before, in Howard County over the last year, the underage people, 10 and under, I was able to look at it while everyone was talking, 4 thefts, 1 sex offense, 1 handgun, 2 motor vehicle thefts, 2 assaults. That's the way the numbers disaggregate in Howard County. Can't speak for the entire state, but in our space, and those are just what we're aware of. Those are the numbers that we're aware of. Remember, one of the problems that this bill does cure is that we weren't getting referred everything. So there's stuff that I am not aware of because it never made its way to our office that hopefully this bill will fix.
Do you have any data on the number of nonviolent felonies that you have not been able to petition because DJS has done an informational adjustment or wasn't successful or not? You weren't forwarded the cases?
This is not going to be a number the way I think you want the number, but it's an anecdote that I think is repeated around the state. A case came into my office about 2 weeks ago. It was a young man who had committed a car theft, which is not a crime of violence. It's a felony, and we don't know about it. That's why we're asking to be notified of felonies. But the young man came in, he was arrested for a 7th car theft. 6 had been held at intake. When it came to our office to prosecute car number 7, we learned about car number 1, 2, 3, 4, 5, 6. They had been held at intake. We never knew about the first 6 cars. They were adjusted informally at intake and no information flowed to my office. So I will say to you, as I've talked about what happened in my county, that's probably the worst example I could give you from my county. But everybody, I think, had similar situations where they become aware of a case after someone has come in. And again, auto theft is not a violent crime. It's not a crime of violence. No reporting requirement. And sometimes they can stack up and you get somebody on round 7.
And let me just be clear while I'm asking the questions that I'm asking.
Well, can I just, I did get some numbers from Chief McCullough for Baltimore County.
Sure.
And again, we will try to get you all statewide numbers to make sure that we're supplying the information that you've asked. But in 2021, children under the age of 13, we had 503 arrests. 2022, under the age of 13, 708 arrests. And 2023, under the age of 13, 747 arrests. So you can see the trend is going up. So that would be some of the numbers, but we will try to find statewide numbers to answer your question.
Thank you. And my point is, again, when you watch the news, and I remember I was in a meeting with the chief. My understanding is juvenile crime, while it's happening, it's a minor portion of overall crime. Adults are committing most of the crimes, correct? So I just want to make certain that within these conversations that we're not making the minor major and the major minor. So
Well,
and that was just a comment. That wasn't anything. That was just a statement, because I did have just a couple more questions, and then I'll be done. And it's me trying to understand the language. So page 6, lines 28 through 32, page 7, lines 1 through 5. I'm trying to understand why the notification is necessary for the state's attorney's office. Number one, and what will the state's attorney be able to do with that information? I believe Mr. Gibson, from your testimony, I heard something about discretion, which leads me to believe that if you're notified, you all may actually prosecute.
So, yeah, to answer that question, Senator Sidnor, just because we are made aware of the criminal actions of a juvenile doesn't mean that we necessarily prosecute that case. We also have diversionary programs that we can recommend an informal result that doesn't involve the actual justice system, right? So the fact of the matter is that right now, what 630 McCarthy's
so why
referring
do we
to.
notify you?
Say again?
So why would we know? Why would you want the language to notify the state's attorney?
So in the example that Secretary McCarthy just gave, right? We're trying to fabricate an appropriate solution to the problem that's being expressed in society, right? And if I think that this is your first offense, your first car theft, I'm going to treat that person differently than I would treat the young person that's committed their 5th car theft.
Why isn't DJS the most appropriate, since they're about rehabilitation of children versus what a state's attorney's mission is?
I'm not saying, so we're not anti each other. I think that you have a dichotomy in your head that you're describing us to say that doesn't seem to be true. We're trying to work together as a team.
No, but I'm listening to what you all are saying, and I feel like there is a dichotomy going on. So I'm wondering, why not leave it with the DJS that has the expertise in rehabilitating children? It's my understanding that generally state's attorneys aren't necessarily about rehabilitation. You all are about met justice.
So I disagree with you.
You say you met justice, right?
So I disagree with that premise.
Okay.
Right. We are driven to try. We're problem solvers. Our mission is to find the right and appropriate solution to the problem before us. If the problem before us isn't accurately displayed, we can't craft the right solution. The right solution might be a light touch or a more significant touch based upon all the facts.
So
but if
why
you're hiding
you
the
all-
facts from us, we can't discern the right outcome.
So why you and I'm not talking about you personally, but
Sure.
state's attorneys versus DJS?
So
why do you all
Just
need to know?
Before I just want to slow things down a little bit. Just hold on, Madam, just hold on. So when does juvenile jurisdiction end? How old?
18.
21, right?
21 if they're.
So,
if
yeah,
they're
so
in custody.
where are these youths going? Which agency are they interfacing with? If they're under probation, if they're detained, if they're monitored, which agency is responsible?
If they are processed through the Department of Juvenile Services.
Department of Juvenile
then
Services.
DJS.
That's right.
And just to understand, there is a process in which we all make recommendations on what we think the appropriate outcome should be. So our offices make recommendations, the Department of Juvenile Services will make recommendations and will provide information about what services they have available for that child. Obviously, Defense Counsel will make recommendations, and any experts that have evaluated the child will provide reports on what the child needs. So all of us are looking at this information and making recommendations on what we believe is appropriate to rehabilitate the child, and ultimately a judge makes the decision. So it's really, for the most part, not an adversarial relationship. Most kids are handled like most adults are handled. There's oftentimes a plea agreement that is reached, and the recommendations from everyone are taken into consideration by the judge, and ultimately the judge determines what the appropriate treatment plan will be. All we're asking is that once a treatment plan is developed, that the child must follow it like any other court-ordered program or treatment, whether it's an adult or a child. They should be held accountable to following those recommendations, the guidance of the court, because that is the plan that everyone has agreed upon that will best impact that child. And so this bill does provide that level of accountability, not just on the child, but also on the adults to ensure that those treatment programs are available for the child. It also gives the opportunity for this legislature to look at the resources that has been invested in the Department of Juvenile Services to provide these programs. And if additional resources are needed, those recommendations will be made.
What will the notification allow the state's attorneys to do? What are you all going to do with that information?
We have a responsibility. We have a role in this process. Our role is to make recommendations. We make detention, pre-merits detention recommendations. We look at whether or not we want to plea out cases and what the appropriate plans should be.
So what happens if you all disagree with DJS?
Again, a judge ultimately makes the determination, and the Department of Juvenile Services will make recommendations on what is appropriate and what programs they have for those children.
Okay.
So, I mean, we all have a role to play. And let me just add that there are.
And I know others have questions. So I have two more questions and I'll be done.
Senator, take your time. Take your time. It's important.
Thank you. So on page 10, we're talking about the removing of that language around the preceding 12 months. Why is that important?
Say that again. What?
All right, so we're talking on page 10, lines 1 and 2.
Yeah, because the child violated multiple times.
And this is when we're talking about is this where we're talking about those technical violations or whatever?
So yes. So
Okay.
Senator Sidnor, if a kid comes before, a youth comes before the court and the youth is found fact sustained, which is the equivalent of being found involved with the crime, fact sustained related to drug use, anger management, he beat somebody up, and he took a car and damaged the car, right? And the judge finds that this child is fact sustained and involved in those events. And the judge, after hearing it from all the parties, deems that this youth needs anger management, drug treatment. They should do some community service, 100 hours community service, and they should pay restitution to the victim whose car they destroyed when they stole it, right? The kid, in that instance, the youth decides to, under the current system, the youth doesn't pay restitution. The youth attends anger management and then decides not to stop. The youth doesn't participate in drug treatment and is testing dirty on drugs constantly. And there's been no change in behavior, despite the court saying, young person, we need to get you on the right path. We're trying to help you get on the right path. These are the things that will, if you complete these and you continue in this direction, you will be a positive member of society. If you fail to participate in your own positive growth and you're committed to the wrong path, we need to give the courts and the state the ability to intervene in a way that says, no, course correct, right? Right now, we don't have that.
Just real quick, I'm sorry, real quick. You asked a question about the violations. So within the last 12 months, two within the last 12 months, take that's bracketed out. You're asking if the technical violations qualify. That's no. The answer is no to that. A delinquent act means you committed a new crime.
Right. It would be a non-technical violation, and that definition has been expanded through 744.
So
it
then
require two offenses. So you'd have to blow off two different crimes.
No, I think just real quick. We're talking about different sections here. Yeah.
Oh,
so he's talking about the hearing detention, which is on page 10, lines 1 and 2. We've bracketed out 12 months and just said 2 of those infractions. He's asking if technical violations count.
Oh,
and the answer is no.
No, they do not. I'm sorry.
What is a delinquent act? It's a new
Yes, it'd be a new
So it
crime
means
or
you
not
have
a-
to have committed two new offenses.
Yes,
That's the question.
yes, yes,
Thank
yes.
you. So this, and since you talked about the technical violations, where is that in the legislation?
So.
Down the bottom of that same page.
Two more unexcused
26 and
failures.
27.
Thank you.
Section 5.
I appreciate that. And to that point, so just for, it says two or more unexcused failures to appear at a treatment program ordered by the court. So I'm just wondering, discretion. You do that, I guess the court has no discretion, because maybe Johnny missed the bus or Johnny couldn't afford to catch a bus and he missed the treatment program.
No, Senator Sid, no, the court, just to correct you, the court always has discretion, so does the state. And the defense can always ask for leniency from the judge and can explain as to why they were absent. Let's say the person was absent and there was something legitimate that drove the absenteeism. That certainly would not trigger a violation. And we see that, in adult court currently, right? It's like, it's not, at no point in time did the prosecutors, the court, or any of the entities involved not have discretion to exercise. This is just saying, this is authorizing the ability to do something that we're currently not authorized to do.
Why do you all believe that the issue that we're dealing with is an issue for the legislative branch to address rather than an issue for the executive branch to fix?
Well, there are a series of rules that were created by the legislative branch in an effort to create a more just environment. And some of those had unintended consequences that we're seeing play out. We see problems that exist in the way that the current structure, the current legal paradigm is. And this is a legislative fix for a legislative problem. We're trying to use legislative tools to fix problems that were created legislatively that we're seeing play out in society.
And these legislative fixes, I guess, have been determined that these fixes work with you all talking with the other executive agencies. And I'm looking at the state's attorney as part of the executive branch. So again, from my understanding, you all, DJS, law enforcement, everybody's acting in all these silos, which is why, again, I viewed this as more of an executive branch issue than I have a legislative issue.
So sorry, John. So one of the things this bill does, which we are in support of, is it should improve communication between DJS and State's Attorney's Office. It does so in several ways. One, it mandates communication when there are certain types of crimes, certain categories of crimes that occur. It also encourages DJS to forward stuff to us faster. So right now, I think it's a 25-day limit. We're going to go to a 15-day limit for referring cases to us. And so this bill has baked into it as part of a solution to the problem we're facing of a lack of proper communication.
And I appreciate you bringing that up because I had an opportunity to look at DJS's testimony, and I will tell you, in all the years that I've been on this committee and on judiciary when I was in the House, it was probably the most milquetoast testimony that I've ever read from a state agency, where I couldn't really tell whether or not they supported these recommendations or not in this. So I'm not certain whose solutions there are in dealing with these. Well, the last question that I have, and actually this, I don't know if this would be maybe for the chairman.
The first one is obviously you are not, the entity responsible for responding to that question. So
no,
yeah, no, it wasn't a question to respond to. It's an observation. I noticed I was looking to see whether or not there was a racial impact study performed for this legislation.
So I think you'll notice that we always get a fiscal note, and that impact statement should accompany that analysis. So if it's not in there now, it'll be forthcoming.
All right. Thank you very much.
Thank you very much, Senator Sidnor. Senator Charles, and then Senator Carter.
Okay, thank you, Mr. Chair. I was going back and forth trying to get some answers. It's something that was said earlier in terms of the felony cases not being diverted to Department of Juvenile Services. And so I'm just trying to get a better understanding as to what happens with that information. And any one of the state's attorneys can get it, because my colleague asked a pretty good question that I was trying to get some of that information as well. And I did hear some of the arrest offenses based off of ages, but who's tracking that data, you know, for all of these felony things that it's weapons crime, firearms crimes, animal cruelty, third-degree sex offenses, theft of a vehicle. If the felony cases are not diverted to DJS,
Well,
then who is
They are in
actually?
DJS.
So they,
The matters go to, these matters are with DJS. And what happens, let's say it's an auto theft. That's a felony. It goes to DJS and they have to determine whether or not they're going to informally adjust that case in-house. And if they informally adjust it because it is not a crime of violence, we will never know about it. We're not involved in it. That's really what we're trying to do here, is to make sure that they are obligated to share information with us. And if they share that information with us, we might make a determination that we may want to charge a case that this is an authority we had before.
so is this 10, 11, and 12-year-olds or 13 and above?
Well, these are two different parts of the bill. There's one section of the bill that deals with potentially allowing and expanding the jurisdiction of the juvenile court to allow individuals under the age of 12 for selected categories of crimes to now be potentially charged, not necessarily charged, but potentially charged. They then would become arrestable. Second-degree assault, I think which is in the bill because a lot of us have had reports from our local school jurisdictions about very violent assaults that are occurring within our schools. And the schools are calling us, the parents in the schools are calling us, asking us to take steps to try to make the environment in which their children are going to school safe. So that we have potentially going to see that case.
So short and skinny, you guys don't have the data. DJS has that.
DJS, that's correct.
And Mr. Chair, I know it's a little early. I don't know if DJS will actually, are they here today to be able to talk to this?
DJS is not participating in person, but they have submitted written testimony.
All right, because I think that information that's requested is going to make a huge determination. This is a statewide bill, obviously.
Believe me, I've made the data request.
Yeah.
The under 12 aspect of the case and looking at felonies are two completely different aspects of the bill. It does two completely distinct things for different reasons.
Okay. Yeah. Just looking for data. That's it. Thank you, sir.
Thank you, Mr. Chair. Thank you, everyone that's here after 4:07 on a Friday afternoon. We are charged with the very important responsibility to ensure our future as a people, our future as a state, when we talk about how we treat our young people. And so to the extent that young people are on everyone's radar, I applaud everyone that cares. I want to echo the questions asked by Senator Sidnor regarding the data, as well as Senator Charles, because that's been my number one question, or one of them, throughout the whole process. And so I think it's important that the facts and the truth are highlighted, and that they are not buried in an abundance of rhetoric. And so I would like any one person to answer any question that I have, but please don't all answer the same question once it's been answered, in the interest of time and respect to everyone here. What Senator Sidnor was getting at, and I heard several times that carjackings are up with an exponential increase. I heard different percentages, but we all know that that is up. So carjackings are up. Under current law, is it not true that any child over the age of 9 can be charged with carjacking? Yeah. So the point is, what Senator Sidnor was getting at, and I don't think it's really clear, is he's asking if 10-year-olds and up can all be charged And the only group that can't be are the 9 and unders. Number one, how many of them are accused of these things? Number two, why are you not using the mechanisms available for that category? Or if you are, what is the shortcoming there? And how can we fix that process?
So
Finally, no, I'm
Oh,
not,
sorry.
and then I want to get to the point. So I just talked about the under 10s, but now we're asking back to the 10-year-olds and up. They can already under current law be charged, absolutely, prosecuted in the Department of Juvenile Services. The question is,
with crimes of violence.
well, that's what everyone just agreed that carjacking, that's the number one thing that's been talked about.
And so my
that's
question
I'm
is,
talking
what
about
do
too.
you do with the 12-year-old who walks into a school with a loaded handgun? The answer is you cannot charge them in juvenile court right now. You
Have
walk
you-
into a school with a handgun, it's loaded, you don't know what they're going to do with it. You cannot charge a 12-year-old as even as a juvenile.
I understand that that's what the law is on that one charge. However, we all know that if a 12-year-old walked into a school with a gun, that there would be a much greater charges than just possession of a handgun.
That's
But-
not
but-
what happened in
but-
Anne Arundel
but
County.
let
I have
me-
the article.
I want to get to this. I want to get to the point of this though. Even if that is your belief, even if your belief is that that child can't be charged with anything, because we all know that there's never an overcharging in any situation. If that's your belief, are you using the other processes available, such as the child in need of supervision? If you have used that, in what percentage of those cases have you used it? What are the outcomes? Why does it work or why does it not work? Why do you use it or not use it?
Well, the SINS process, child in need of assistance, is very hard to actually get people to comply. They don't have to.
Have you tried to use it?
Oh, yes. Every
In
jurisdiction
what
has
percentage
tried.
of the cases that you're talking about?
Unfortunately, we don't keep those numbers. I mean, I know every time I come down to the legislature, everybody thinks I have this big computer that has all these numbers in it. And it's just, we don't collect information that way. But I can tell you in our jurisdiction, we have tried Senate cases, and there's just.
SINA or SINs, because they are two different processes.
We've done both situations. Maybe someone else has had, Ms. Braveboy?
Yeah.
Well, I did ask that not everybody try to answer the question.
I understand, but let me just say this. There are cases that we never get. So if we don't get those cases, we wouldn't know whether or not the Department of Juvenile Services has handled it informally, what their recommendations were, how they treated that child. We wouldn't know. And so what we're saying is that there are certain categories of crimes, and we're not talking about all crimes, right? We're talking about, gun offenses. We've had very severe second-degree assault cases where people were jumped in schools or on their way home from school, that we would not get referred. In fact, one of the biggest ones, which is not addressed here.
So I don't want to cut you off, but
my point
the
is,
interest
we
of
wouldn't have
time.
that information, and I think the Department of Juvenile Services might be able to provide you with that information. But to ask us for information for cases.
But
that
you're
we don't get
asking to
referred
change a
to.
law based on this problem.
We're asking to change the law based on the requests we get from our community, with people very concerned about how their children, the dangers that they believe that their children are facing, the dangers that they believe their communities are facing, and the dangers that they believe that their school is facing. This legislation, this whole conversation really grew out of concerns from every single community across the state of Maryland. That's
Thank
why
you.
we're here.
I don't want to belabor this. I know I recognize more than anyone else that it's a long end to a long week. But it really perturbs me a little bit that we hear consistently about the concerns of our constituents, concerns that every single person here is worried about. But when we already had information through other hearings this session that 64% of violent crime in this state, that is crime that is reported to law enforcement, goes unresolved, no arrest made. That's 64% of violent crime in the state. 64% of violent crime in the state. Add to that the fact that data also has indicated that less than 10% is committed by children, by juveniles. Now, taking that number even further, we already know that any child 10 years old and over in the state of Maryland can be arrested and charged, prosecuted, and potentially convicted of any felony crime of violence. We know that. So the real question here is, of the group of people that your hands are tied from prosecuting, how many of them are actually under 9? And if they are, what mechanisms were taken to try to get resolution in those cases? Because you're saying that we need to close holes in the law where your hands are tied.
All right.
Is it not a misnomer then to say that you need to add misdemeanor offenses when you're not able to produce any data that you need that?
Okay. All right. Thank you.
The only, may I say, I think I will only say that I don't think there's anything in the bill that would suggest that anyone is asking for the authority to charge anyone under the age of 9. That's not in the bill. Your question suggests that it is. It's not.
No, well, I don't want to go back and forth. No, maybe I wasn't clear, but what I'm saying is that you can currently charge anyone 10 and over. So why is, what is the hole in the 10-year-olds, 11-year-olds, and 12-year-olds that is stopping you from being able to deal with them in your system?
Well, you can do crimes of violence, but there are other crimes.
But you said
and it's a
carjacking
No, carjacking is
is the biggest deal.
No, carjacking is a crime of violence. I think there are 3 crimes, maybe there's 4. It's a very finite number of crimes that were listed by the drafters of the bill after a lot of input from individuals about what kinds of things are happening in your community where people who are under the age of 12 are committing offenses, where you don't have the ability to come in and deal with the fighting that's going on and disrupting our schools, the car thefts that are going up, and explosive numbers that are happening in our communities. They're very finite numbers where we're going down to 10, and I think it's 3.
So that's the whole point. But again, I want to move on. So that's the part of the bill that is causing a lot of consternation, that there's an effort to expand the jurisdiction of the juvenile court for categories of kids where there's no evidence that's even a necessary thing to do. And there's also, even worse than that, there's no evidence that you're utilizing the process that's already available, such as the SINS process. I want to move on though to the other part, because I think this is important, because if we're going to make changes, we need to make them in the right direction and not in the wrong direction. And so another part of the bill that has been discussed is this idea of extending probation. And I did ask Mr. Gibson this earlier in session, and I wasn't really satisfied with the answer. And the question is, how many cases do your offices have where there's been a need for a probation extension, but all the time is used up? Meaning there's a violation of probation hearing, and your office is arguing to the magistrate or the judge, we need more time on probation. And the judge says, I'm sorry, my hands are tied. The law says there is no way I can possibly extend this probation.
We are routinely, in nearly every case where we're attempting to get a placement from DJS. In my county, Montgomery County, we have 3 to 4 month delays in getting placement. It's because of a lack of individual. So are there delays? Yes. There's nowhere to put those children. There are no services available. And then when they go in to the programs, they are cycled out in about 4.5 months. I don't believe that anybody, with the constellation of issues that we're trying to deal with some of these kids, does anybody really think that we can fix an issue in 4.5 months with the profound issues of whether it's drug addiction, mental health issues? We are confined to a period of time because the resources are not there. This really goes to an issue we talked about widely yesterday as well. The reform of juvenile justice should have started at the Department of Juvenile Services, where we built services. We don't have the services that are adequately set up for us to service the children the way this thing is now being argued.
I don't think anybody would argue with that, but that we need more services, more resources. But I think that it is important that so Mr. Gibson, you said legislative fix to a legislative problem. It's important that we talk about how it's a necessity that we extend probation, that we actually have specific empirical data on the percentage of time that probation is necessary to be extended, but you're denied that because of a restriction in the law. I think that it's important that we do it based on actual need and not just something that we think might look appealing to appease the public or a perception that this is somehow a fix to a problem that we don't have.
So
So
to respond to that, a few things. One, I think everyone would agree that we need more robust services for our youth and that crime is happening.
But could you answer the question? Could you answer the question about the time that you've needed
But
to?
if you don't want to hear the answer, I can.
It's just it's a roundabout.
All right, hold on. We're giving everyone, this is an important issue. We're giving everyone enough time to develop their responses and their questions. Senators getting a lot of latitude in asking the questions. We got to allow our witnesses to furnish their responses in a complete manner.
Thank you, Senator Smith, Chair Smith. So as I was saying, we all agree that we need more services and we need to have access to getting those services attached to our youth as quickly as possible. The juvenile justice system is driven around rehabilitation. That is our focus. All right. One of the issues that we're discussing, you talk about timelines and data, is that we don't have the ability to put the youth into a judge has found this person is committed an offense. They found them fact sustained, involved. Right. And it takes a long period of time to get them into a program, to get them on the right path. But the probationary clock is ticking, right? The time starts from the time of the finding, it's ticking. And if they can't put them in a program for months at a time, what State Attorney McCarthy was alluding to a second ago, then the clock runs down without really fixing the underlying root cause of why the kid was behaving in a criminal way in the first place. As a result, you end up not addressing the underlying problem. Society is no safer. That's where we are.
If that's an issue, then why not put pressure or mandates on the Department of Juvenile Services to expedite the necessary services rather than put the onus on the back of the child that didn't receive the services through no fault of their own? Why not mandate the services begin immediately as opposed to hold a child on a punitive probation because the system was too slow providing the services? Would that not be a better solution? You get the services to the child more quickly.
Some of the services are not available at the level that they need to be available in order to service the kids in our community. So there is a delay because they don't have enough space in the current programs. And what I think is that in addition to, the mandates of this bill, one of the important aspects of it is the commission that is going to look at and evaluate the programs and services that DJS has to offer so that they can, and I'm assuming that members of this body will be able to make recommendations on how to grow resources for DJS so that they can provide the services timely. But I don't want you to believe that it's only those kids that cannot be placed in services that have not taken advantage of services. There are kids who absolutely have been placed in services have been made available, and they just don't go. We want to be able to hold those kids and their parents and everyone else accountable and responsible for complying with the orders of the court. I think that's very important that when you are ordered to do something by a court, just like an adult, that you comply with that. And so when those services are available, there is space that you have to attend, you have to go. So I just want to make sure that we don't believe that it's only in those cases where the services aren't
But
made
Senator
available.
Carter's point is well taken. I mean, and I think all of you agree with what she said, which is that the ultimate solution would be to have the availability of services appropriately fitted, evidence-based, ready to go. I think every aspect of the system wants that. The problem is we are far from that mountaintop. And so while we're dealing in the world of reality, what do we do to ensure that we kind of right sizing this solution. And that's what this discussion's about. Because if you're having judges having to go to the Department of Health for beds, if you're having to send people out of state for mental health or substance abuse treatment, if you're having 3-month wait times for services, we're not creating a situation for optimal results. And I think that's what this discussion results in. And I think anyone denies what Senator Carter says. I wish I had the magic wand to do that.
I'm almost finished, Mr. Chair. I think to what the chairman said as well, I think it would really help your case for what you're asking for, if you could show that you actually have had this desperate need for these extensions, but the law has prohibited them. When you go to change the law, it's important that you're actually, as Mr. Gibson said, creating a legislative fix to a legislative problem. Maybe they need to be extended or maybe they don't. But I think the first suggestion is to work more vigilantly at making sure these resources and these services are available at the front end, rather than put the onus on the back of a child who has had no power or control over it. I'm gonna stop my questioning here, but I think that from what I've heard both today and as well as every day leading up to this has been difficult because while there are suggestions in this bill, there's no nexus that is ascertainable between the existence of a serious problem that's really, really bottlenecking our system and the solutions proposed in the bill. And so I would suggest that before you move forward with some of the changes that are not based on any type of empirical data, and they are somewhat anecdotal, and they are confusing to the public who doesn't really understand who you currently can have control over in the system. I think that the commission that you propose is something that should be put together to make the decisions now, rather than a one-sided view that consistently can't produce any foundation, any data-driven foundation for the proposals. So that would be my suggestion, that as we go through this process and we're told that there is open season for amendments, that you be amenable to that, because it's important that we take a system that has never had difficulty incarcerating or over incarcerating our children, and we really put our focus on a front end intervention, diversion, lack of putting children into a system where we know that once that happens, and the earlier it happens, that child is more likely to be in the system for a longer period of time, and even the adult system. Thank you.
I don't think anyone disagrees with you on that. Hope we get there sooner rather than later. All right, Senator Charles, you're up.
Thank you, Mr. Chair. You know, I'm sitting over here and listening to a lot of the testimony back and forth. And one of the consistent things that constantly comes up is no services are available, resources are not there, more robust services, we need more services. Services is the key word that I'm constantly hearing in this. And as we're looking to tackle this problem that's impacting all of our jurisdictions, it circles back to the services. But what I have not heard about services is how much money are we truly looking for? To what do we need? What are some of the things to make you guys more successful? And before you get to answering, you know, what are those robust services that we're needing? You know, I know the chair had mentioned some mental health beds. We may need additional beds. How much are the beds now for every bed that we currently have? And then based off of the data points that we have for all of the, and you may not have this, but this is something collectively we all probably need to come up with, based off of the amount of beds, because we don't have enough time to, you know, enough, make folks have to wait a long period of time to get to these beds based off of the availability. What do we need to do to increase it? Number one, for you guys to be successful, for all of us to be successful, but so I'm just looking for that, like, can we get a list of services, one? And I know everything isn't mental health, you know, some kids or adults even, they break the law and it's not necessarily a mental health issue. So there are other things. What are those services? How much money is it going to cost? You know, we're running into a budget issue, but we're also dealing with a crime issue right now. So understanding from a fiscal standpoint, what we're looking for will, I think, help all of us really tackle this juvenile problem. So if you could help me, one, lay out services that we're looking for, and then resources that are needed to help us get there.
Sure. So Senator Charles, let me start by saying the best entity to pose this question to is the Department of Juvenile Services, right? I can tell you on our end from the Attorney's Office, when we look at these, the issues that we see on a regular basis, in Maryland right now, there's no inpatient drug treatment program for youth. None, zero, has to be outsourced. Really would be beneficial to have something here in the state of Maryland, because we all agree that drugs and substance abuse is a challenge for everyone, including our youth. All right. We need wraparound services for families. So if a lot of the people that we see that are youth committing crime come from homes that are not, not your prototypical mom, dad, or two-parent household, invested in the kid every day. How was your homework today? They come from challenged home environments, mental health challenges in the home, financial challenges in the home, abuse, physical abuse challenges in the home, violence challenges in the home. In some instances, it's kids being raised by grandma, and she's, doing her best. It's not an attack on anyone in those situations, but those environments create a more fertile space for criminal behavior for our youth, right? They need help, right? And our job would be to try to get them wraparound services, guidance there, guidance in our schools. We have a, what is it called for the children when the kids are, there's an alert system. I can't remember the term for it right now, but when our kids are exposed to violence, either in the home or have some challenge, we have a notification in our school systems that say, hey, handle with care. It's called handle with care. A handle with care program that's more robust. It exists statewide, but make it more robust. So that if we know a kid is struggling and has had a problem at home, let's get more services to that kid. Let's focus intensely on that child who may be at a breaking point because of a crisis that just occurred. We need psychiatric treatment for our kids. We need anger management programs for our kids. And in terms of the cost, again, that's a DJS question, but undoubtedly we all agree getting our system for juveniles is not about punitiveness. We're not trying to incarcerate these kids. That's not the goal. The goal is to attach services, mandate them. So the kid can't just say, I don't feel like doing it. Attach it in a way that says, you are doing wrong and you will complete this path. And this path, if you complete it, will set you on the right trajectory for a positive future. That's the goal. That's the mission that we all share, right? And so having more robust services really would make a huge difference. And that's, job training, job treatment, things of that nature. ROTC programs, because not everyone's going to go to school. The list is long, right? But we need a holistic, and aggressive, with a sense of urgency, programs that are available for our youth.
And I know one of the things, it's been in this committee in these last, 2 months. I've heard a lot of different bills and things that address, like we just had something about creating programs for bringing folks into law enforcement, and kind of like a ROTC component inside the high schools almost, but for law enforcement. And I've heard a bunch of different things when I was over on the House side in terms of just different dollars that we're investing with the blueprint. The amount of things that's why that's so important for us right now. Do you think we can take pieces from all of these and that's going to answer the question or help solve the problem? Because I know we're not working in silos necessarily in the House and the Senate and as a General Assembly. We're working together. All of those nuances are being addressed, I think, with some of these comprehensive bills that we've passed over the last couple of years. You don't think those things have been of any assistance or help to you all?
I do want to, this is a good line of questioning, but I do want to stay on the bill, but let's answer.
But what I was going to say in terms of the services that are needed, I do think, because this is, you all deal with the judiciary, but a lot of what we're talking about are things that may also require the input of the health committees, the committees that deal with health, because in terms of the expansion of health related services in our state, we absolutely need that. And when it comes to the blueprint, one of the things I automatically think of when you ask, well, what do you need? I would love a free aftercare program for middle schoolers. Because oftentimes what happens is when a child reaches the magic age where they can be at home on their own, because of the cost of childcare, parents opt to allow them to go home and be at home unsupervised for a period of time at a critical time in their life. Their brains are still developing, they're still forming, and they're taking more risk because they're young. So the 12, the 13-year-olds, a lot of them, that's when they start along, unfortunately, some bad paths. But if we had a way to capture them, their minds, their spirits, because a lot of these kids are absolutely brilliant. They could absolutely be anything they want to be, but they have to be in an environment that's nurturing that. So if within the blueprint, we're providing for free aftercare programs, in particular for our middle schoolers, I think that would go a long way, because these kids, many of them are not ready to be home alone, but they are, because the cost of childcare is just astronomical. So we understand why parents do it, but it's at a critical turning point in their lives when they really do need more guidance and intervention.
I'm just saying this, like, so look, I mean, that's what we had those briefings at the beginning of the session to kind of break down some of those silos between our committees. One of the things that, you know, you said blueprint, and I think you're talking about the blueprint that we funded, that part of that, anyway, just looking at this comes out $120 million in funding, $380 million in requests across the state for services, just like what you're talking about. So I'll send you that information. MDH has a slide deck for the RFPs for those things. So I'll send it along to the committee, but let's stay on the bill and redirect. So Senator Muse and then Senator West.
Thank you very much and welcome. I'm sitting here as someone who at 12 years old, the kids you're talking about was me, right? And I'm somewhat disappointed at all of us, be it legislators, though the budget folks, all these agencies that we have. I'm disappointed in us that with all of these minds and all of this money, we cannot find a solution to deal with a bunch of 10 and 12, not even a bunch, 10 and 12-year-olds, particularly when these 10 and 12-year-olds, we're not talking about more than and you can correct me if I'm wrong, carjackings, the worst violent things that we mentioned. We're not talking about more than 100 kids a year. We're not talking about that. Not even 100 kids. And we, with all of our minds put together, cannot come up with a solution to deal with this except for what's in this bill. We can find 500 million for a casino or a stadium, but not to deal with 100 kids a year. We keep saying more programs, more money. Well, when do we get together and say, these are the programs, this is what it costs, and this is what we're going to do to get it done? We keep saying what we need, what we need. We know what we need, but I'll tell you what we don't need. It's a bunch of kids in an adult system, and we not know what we can do for the more programs, for the more money that needs to be spent here. And until we are able to come together and deal with the fact that while we say we're treating them as though these kids are the engine to bringing of crime and what we have to do to bring it down, I'd rather talk about what are we going to do about the 90% of adults who are committing crimes. What do we do about the fact that 65% of those committing crimes, there are no arrests, nothing happens to these folks? I want to talk about that first, and then I want us to get together and come up with a solution, because my fear is if we do this, then there's no need to focus on the programs and the solution.
Just recenter things. I know you're going to respond. This is purely a discussion within the realm of the juvenile system.
That's what I'm talking about.
Yeah. So
I understand that.
Just no adult court.
Trust me, I understand that.
Yeah. So,
and however you want to phrase it, to me, it's the same thing. It's the same thing for many reasons. And so we have not run out. We have not come up with solutions. We've not come up with the money. And what are the programs that we talk about when we say we don't have enough of them? What are they? Not only what are the programs, how much does it cost? What do we do first? That's what I want.
Yeah, I honestly, Senator, I don't think that we can tell you how much it's gonna cost. I mean, that is
well
outside of our area of expertise. I think what we've said was we need, drug treatment, yes.
And why don't we
mental
have
health
those right
for,
now?
because the state and local jurisdictions have not invested in it.
And I'm disappointed in that. And that's what we should be addressing first.
And we definitely want that. And I think, and I don't want to speak for Mr. Chair, it's his bill and the president's bill, but from what I understand in the bill, there will be a mechanism to evaluate what is needed in order to improve the service delivery for our kids. That's my understanding through that commission. So I do believe there's a mechanism for that. Now, do we need to move quicker than what maybe the bill would anticipate? Absolutely. And if we had money today and we had $1 billion, we'd figure out what services we need and we could tell you. But I think absolutely drug treatment, mental health treatment. I think we need services for families. Some families actually need permanent housing. I have a program on Saturdays where we deal with families, not just the kids, but the families too. And let me tell you, they've got housing needs. Parents have mental health needs. There's a lot of issues going on. I think we probably need someone to work with us, just to help us evaluate the services that are available, the services that are needed, and then cost it out.
I got you. And Mr. Chairman, I understand exactly what you're saying, but I want you to understand that I do know the difference between adult and juvenile. I do understand where most of this is. And when we say we need programs, we don't know how much it costs. I guarantee you, we can find the money to do something differently than what we're doing now, which I believe will not help, but could make the problem worse. So I hear what you're saying. I want to know, what are the programs? What is it? And why haven't we figured it out yet? Why haven't we figured it out yet before we go this route?
But I will
This is
say
something
this,
that we
but I will
should take
say
out.
this, one of the reasons why it's very important for us to be able to have at least some level of accountability in the system is that if children are not receiving the services and they're not showing up, then how will we know how
Hold their
many?
parents responsible and deal with them if they're
Well,
not
if
showing
you all
up.
can give us that authority
will do
too,
that
that would be
first before I do
wonderful. Because I'm often asked, well, arrest the parents too. This child's been arrested multiple times. And I'm like, I don't have the legal ability or authority to do that. So that part, and then looking at it also, a lot of times parents are.
All right, excuse me, I just want to just for this up, just for the folks in the audience, look, sir, it's hard to stand up here. And I assume if you're here to participate, which we treasure and value your participation in this process. But I assume if you're here, you're probably going to stand up on that podium yourself. Listen, we cannot have the commentary behind. It's hard to stand up here and testify, and you wouldn't want someone doing the same thing when you're up here. So I just want to make sure we have a level of decorum. No, just 1 second. Hold on. We have to have a level of just civility and decorum here. I know, I appreciate and understand. I value your contributions you're going to make in your presence, but.
Thank you, Mr. Chairman. And I'll close with this. We haven't exhausted all the measures in my mind before coming to this. This as is, I couldn't support, but if we can find some other avenue, talk about it, but not knowing where we are now and what we're doing with resources, what we're not doing with resources. I just think this is a drastic measure. So thank you.
And I think a missing component here at this meeting is the Department of Juvenile Services that would be able to provide that information to you.
I agree. Okay.
All right.
Thank you. Thank you.
Thank you very much. Senator West.
Thank you, Mr. Chair. I have a really simple question. I want to ask the state's attorneys whether they think a possible amendment would help the bill. So the bill right now creates a Commission on Juvenile Justice Reform and Emerging in Best Practices. It's a large commission comprised of lots of people. It's supposed to meet 6 times a year. Its charge is to consider a whole lot of things. It looks like a Chinese menu, including data relating to arrests, coordination between DJS and local law enforcement, interpreting for the public the objectives of juvenile services in the state, et cetera, et cetera, et cetera. And then it's required at the end of each year to report its findings, whatever they might be, to the General Assembly. So I have a bill, we're going to hear it on February 22nd, to create a task force which focus like a laser on DJS and the services it's providing to juveniles in the state, whether they're sufficient, whether they're insufficient, what's working, what's not working, what new programs we need, and how much it's going to cost. And come back to us at the end of the year with a specifically report detailing recommendations. Do you think it would be helpful to amend this bill? I don't have no pride of authorship in my bill. And we don't need a task force. There's nothing magic about a task force. We could assign that responsibility to this commission. Shouldn't we amend this bill to specifically direct this commission this year to focus on those things and come back to us at the end of the year with concrete recommendations of what we should do in order to get adequate social services provided to juveniles in Maryland?
Well, I certainly agree that the bill that you're talking about, your bill, is vitally important. And that is part of how this conversation has devolved away from the statute into what can we do to make their situation better. So you either pass your bill or stick it in this one. But at any rate, what you're mentioning and talking about are definitely important and vital, because we don't always have the answers to all these things. Again, if DJS doesn't have to send something to us, then how are we supposed to know how many of them there are? And so, yes, I think that either your bill or putting it in here would be a great idea.
Thank you.
All right. Seeing no further questions from the committee on this panel, thank you all very much. We'll hear from, is Joyce King still here? Understood. God bless you. Let's see. All right. What about Anthony Barksdale? Anthony Barksdale? Hey, let's do, is Russell Hamill? Russell Hamill? Hey. And then do we have Robert McCullough? David Messersmith? All right, we'll start with that. Mr. Kroll, were you here to testify, or are you?
I'm here to testify, but the next panel I'll be 2 minutes max.
Okay, perfect. Why don't you come on up in this panel, actually? Sure, whoever's ready to go.
Very quickly.
Sure.
They have more to say. Mr. Chairman, members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator, the Executive Director of the Maryland State's Attorneys Association, and I have one small amendment to just talk about. On page 6, number C, it says that if somebody is got 25 days, they've amended it to 15 days, but if you don't do it within 15 days, what's the penalty? That's the problem that I see. It has to be amended. So I just pose that short subject of that needs an amendment, and I have nothing else to say. And I give you this fine panel to take over from there. Thank you all very much.
Hello, Mr. Vice Chair, members of the committee. I'm Anthony Barksdale, Deputy Mayor of Public Safety, under the leadership of Brandon Scott, Mayor of Baltimore. In Baltimore City, we're doing our part to drive down violence. We saw in 2023 a 20% reduction in homicides, a 6% reduction in non-fatal shootings. That's the largest single drop in Baltimore's history. The first homicide of 2024 unfortunately, was a 16-year-old kid who had been engaged by police and arrested multiple times prior to his untimely death. Ensuring that our young people have both the resources they need and the accountability when they do wrong is about saving their lives. SB 744 acknowledges the complexities of the issue at hand and aims to provide effective solutions that prioritize the safety and well-being of our young people. Let's wrap it up. This discussion should always be grounded in our goal to save these young people's lives and provide them the pathways they need to make the right choices in life, as well as guiding them back to the right path when they stray. It is for the above reasons I request a favorable report on SB 744. Thank you, sir.
Whomever would like to go next.
All right, good afternoon. Russ Hamill, representing the Maryland Chiefs and Sheriff Associations. We extend our appreciation to the President of the Senate, Chairman Smith, Speaker of the House, and Chair Clippinger for their efforts on this bill, and to this committee today for your time. Very quickly, I know we support this bill as addresses concerns we hear from our communities. We would only respectfully request your consideration on two amendments, one to address, and I believe Chairman Smith mentioned this already, one to address the need to maintain our many positive diversion programs throughout the state that the bill seemed to be problematic in those continuing. And secondly, we respectfully request consideration that the Maryland Chiefs and Maryland Sheriffs each be assigned a seat on the commission as mentioned in the bill, as we represent many different communities throughout the state, and sheriffs and chiefs do have some different duties. So we do support Senate Bill 744 with amendments, request a favorable report. Thank you for your consideration and time today. We appreciate it.
Mr. Chair and members of the committee, I'm Chief Robert McCullough of the Baltimore County Police Department. I've submitted my testimony. I would just highlight the fact that I'm asking for a couple additional specific offenses be added. They are arson in the second degree and malicious burning, along with threats of mass violence. I would like to just share some statistics with you. Since we're talking about numbers, in 2023, juveniles under the age of 13, Baltimore County sent 58 SINS referrals to DJS. 24 of those 58 SINS reports were for delinquency. However, the police department doesn't get any information back when we send these SINS referrals back from DJS. Just in closing, as the law is currently constructed, in 2022, specifically for auto thefts for kids under the age of 13, we saw six suspects and 113 for 13 through 17. And in 2023, that went to 24 and 475.
Thank you.
Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Scott Messersmith. I'm the Deputy State's Attorney from Wycomico County on the Eastern Shore. I thank the committee for the opportunity to speak here today, and we would, in support of the bill, and we would ask for a favorable review. I can tell the committee to echo the sentiments of the state's attorneys who have testified previously. We are experiencing a problem in Wycomico County, a significant uptake in juvenile crimes involving guns and violence, fueled, in my experience, by drugs and social media and gang involvement and the easy availability of guns. And we appreciate the tools this bill gives us to help us deal with that. After all, the obligation and duty of the state's attorney's office is to protect public safety by prosecuting crimes. I've been asked to say a word about SINS and how that fits in. SINS is an important program, should be fully funded, should be robust. It's targeted at a different problem, not juvenile delinquency. Doesn't provide for victims' rights or restitution. It's part of the puzzle, but not
the replacement for juvenile court.
Thank you very much.
Thank you.
All right, questions for the panel? Senator Sidnor.
Thank you very much. And I thought I would, given that you all represent law enforcement, I thought I was going to hear something about a request to ensure that juveniles could be diverted to you all. Because I know at least in Baltimore County, there's a diversion program. Would you mind speaking to that, Chief?
Senator, in Baltimore County, we have the Juvenile Offenders in Need of Supervision program. That program's existed since 1997. It's been highly successful. We've received numerous national awards for that program. Typically, that program involved kids ages 8 through 17 years of age. And we've been very successful at basically diverting kids away from DJS with that program. Also, it's been very successful in terms of being able to channel kids to services. Of course, in Baltimore County, we have a youth and community resources section, which we have counselors there. And those counselors work with our community outreach units, with our joins officers, with all of our resources in the police department to divert those kids, in addition to working in the school with the school resource officers. With that program, we've also been able to assign officers in our department who work patrol even, who actually they're assigned these kids to mentor, and they interact with these kids in the community, and they go to the schools and check on these kids. Many of these young men especially don't have fathers in the home. So it's a positive impact to have male role models to be involved in their lives. And we've done things like summer camps, and we take these kids to ball games, and we become holistically involved in these young people's lives. And I'm proud to say that we even have members of our agency that are police officers now that were Joins kids. And myself personally, I was involved with the Joins program and managing that early on in 1998 and through 2006.
And I know I don't know the Sawyer program with in Baltimore County, an organization which is manned by one of our SROs. Has been
that's
pretty important. So my question is, I would assume that law would you would still want to be able to do that sort of thing, right?
That's the first thing that we want to do. We want to divert these kids away from, we want to get involved in their lives early and often so that they don't graduate to other crimes, so that we don't see them become fatalities in our community.
Okay, thank you very much.
Thank you, sir.
You guys have an amendment to that. The Chiefs and Sheriffs Association has put an amendment to that effect, so that, there's one of those requirements. You can actually still have the option of diversion when you have to follow those random reports. Go ahead. Yes, Senator Sidnor. Yes.
That's making you stand back up. But I think during your testimony, you were about to speak to page 8, lines 26 through 30. Within your written testimony, you were asking for a modification. I guess it deals with some, what is it? And I'm not quite clear what the modification is asking. That's why I'm asking you to stand up.
Is the additional offenses that I spoke to?
Right. If a child taken into custody under the subtitle by a law enforcement officer pursuant to the law of arrest, the law enforcement officer shall complete and forward a written complaint or citation to DJS for processing under certain subtitles.
So what I can speak to, Senator, on that is that we want to make sure that the way it reads, it's almost like every report has to be forwarded to DJS. But you have circumstances where kids are, that it's verified that they didn't commit an offense. So if they didn't commit an offense, why would we send that report to DJS or forward that information? Or if we have a kid that we want to divert, currently with our Joins program, what we do is we take those reports, our Joins officers contact the victim in the case, and they also contact the juvenile suspect and their parents. And that's how we do an intake into the joins program. So we try to divert those cases away from DJS to lighten their load.
So under your under the modification, it says you would, I guess, forward a written complaint to DJS and or forward a written notification to DJS that police action occurred. Again, could you help me to understand?
Yeah, I mean, we could come up with a way we could work it out uniformly somewhere in law enforcement where we can make a notification somehow to DJS that we had contact with this kid, but we diverted them and they were put in a diversionary program. So it's almost like they know that it happened. So just to give you an example with joins, when it first started, we had the joins officer and we also had a member of DJS that was a part of that team. A few years into the program, DJS took that DJS support worker out of our offices. Okay. So they just left the joins office. But when we had a DJS officer in there with them, that DJS worker working with that joins officer took care of all of those things. They were right there for the immediate notification and they were able to give us guidance and kind of worked with us. But when they took away those DJS workers, it kind of changed things.
Thank you. Appreciate it.
Yeah, of course. Senator Charles.
Thank you, Mr. Chair. I had two questions for you, Chief. One, the first question, you mentioned adding threats of mass violence as and I'm all in agreement to it, but I want to get some data at least that you have. How often has that happened? How many kids between 10, 11, 12 and up have you actually heard threats of mass violence to want to add this to this particular?
In testimony, I cited one incident where it was 12.
Yes.
I apologize. I cited one incident in my testimony where we had a 12-year-old who was in a middle school who came to school and threatened to shoot up the entire school. And of course, the other students heard that. Anybody from law enforcement here will tell you that on a daily basis in schools across this entire state, we field numerous incidents where kids make all types of threats in the school. And we need to be able to act upon that. And we're seeing it at younger ages. You've seen stories in the news where kids, post things to social media and, they have, firearms and things like, and some of these kids are in middle school.
But you have real numbers though, too. Not
I'm sure we can, we keep, in Baltimore County, we keep a very detailed report on all of our activity with our schools. So I'm sure that I can have my analysts pull something together for you.
Okay. And then my last question, in terms of your diversion program, do you have a breakdown by race and age, like how you're diverting a lot of these children?
Yes.
Could you share that with the committee as well?
We could share that. Good work.
Thank you, sir.
That's not a problem. Thank you.
Excellent. Thank you very much. All right. Seeing no more questions from the committee, thank you all very much. All right. We'll now go into Leaf Powers. Yeah,
I think you like two. It's all to you.
Yeah. And we could go to Miss Bevan Dangle and Patty Crenshaw Quimby. Miss Quimby.
First, so.
Is that it?
Yes.
All right.
Any other names before we proceed? All right. Members of the committee, I'm Leaf Powers. I'm testifying on my personal behalf today. Appreciate your time. So the experience I want to speak to today is regarding one of my friends and coworkers in Baltimore, as it turns out. He's a great guy. Got a couple problems though. Problem number one is he drives a Kia. And problem number two is the kids keep stealing his car. So you all know, we have choices to make about what we're going to do about offenders, right? Diversion, all the other things, right? But we don't want impunity, right? There needs to be something that we do to take care of that. And the reason why I'm recommending that you advance, move forward, keep working on SB 744 is because it represents an opportunity for us to get closer to being able to address this problem in a holistic way. And that way my friend can have a car to drive to work. Thank you very much.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the State Director for the Humane Society of the United States here in Maryland. We want to thank the sponsors of this bill for including animals in this really important conversation. And I do want to be clear, our engagement and expertise on this bill is narrowed to one line in the bill. As grateful as we are to have this statute sort of part of this conversation, we are urging this committee to narrow it considerably. As drafted, the language captures all animal crimes, and there's only one section of the code where it's really applicable in this case, and that's 10-606. Those are your aggravated cruelty to animals crimes. This is malicious torture, mutilation, sexual assault, cruel beating, cruel death. Those are the only crimes that really should be part of the conversation when we're talking about these 10 to 12-year-olds. These crimes are incredibly rare to the request for data, maybe one a year. But when they occur, our animal control officers are left in a limbo because there's no means for them to intervene, to provide services, to pull animals out of the home that might be in danger. So we're asking for that very narrow segment to remain included. Thank you.
Good afternoon, Chairman and members of the committee. Thank you for having me. My name is Patty Crankshaw Quimby. I'm representing Professional Animal Workers of Maryland. To echo my colleague, we are supporting this with the amendment to narrow it to 10-606, specifically those intentional acts of cruelty to animals. We know children who harm animals are often victims themselves, and they need as much attention and help as the animals they abuse. Services that are available through the juvenile justice system. While rare when these cases occur, it is essential for our officers to have the tools to ensure the safety of animals and the people, including the children. Animals in Maryland are in a legal dilemma. They're property, but also living beings, which are often severely injured or killed in these cases and warrant the inclusion as violent in this bill when we're referring to violent crimes. Thank you very much.
So thank you very much. Questions from the committee? Yes, Senator James.
And thank you all for testifying, because I was a little unsure of why the animal section was in there, but confirm, if you will, if I'm correct about this, why this is important. As rare as those cases are, they are one of the most accurate sort of predictors, are accurate in telling you where a child is at the moment, and which is a bad and troubled spot, and unfortunately a pretty good predictor that other serious worse situations and problems may arise. And I think I've read that, right? I mean, nothing's 100, but it's it's a real red flag. It's a real indicator that something deeply troubling is happening with the child now, and without our knowledge, intervention, wrap around all that, could really escalate to other places. Am I right about what I read? That's research is still good.
The data certainly shows that children who abuse animals are very likely abused themselves. And to the extent that the services and the interventions that this committee is creating are still frequently found within the juvenile justice system, it is so important for our ACOs to be able to tap into those systems for these youth, because we do know that these are intentional acts of violence if we narrow it to 10-606, which is
right, the
really
narrowing, because
Yeah.
children could accidentally, I remember, stay with me, I accidentally hurt a little animal myself in child. That was not, you want to narrow it because that's very intentional, very extreme.
That's correct.
All
That
right,
is
thank
correct.
you. Thank you.
Further questions from the committee? All right, thank you all very much. Thanks for hanging in there with us. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And how about we just take we'll take our public defender and any of the other public defenders here. I think there are 8 here to testify in opposition. Aaron Seegers. Sarah Wendell. Kimberly Watts. Jeremy Zacher. Keith Lottridge. Lucy Portiera
And
and Alicia Capizella. I guess you just populate the back and then we'll just rotate up and we'll start with our illustrious public defender, Mr. Artigue. Welcome.
Good afternoon, Mr. Chair, distinguished members of the committee. I am Natasha Dartigue, Maryland State Public Defender. OPD opposes Senate Bill 244. It dismantles the Juvenile Justice Reform Act of 2022 and will result in the disproportionate incarceration of Black children. Proponents of the bill repeatedly state that the intent is to improve public safety. This bill does not do that. The impact will increase the number of Black children that enter the criminal legal system, especially those ages 10 to 12. Laws must be based on facts, data, and evidence-based science, not on emotion and fear. Laws must address the underlying issues that lead to criminal behavior, must hold adults responsible for providing support and services, not go backwards to a tough on crime stance that we've heard back in our policies of 1994 crime bill, which we know contributed to the problems of mass incarceration. For fiscal year 2022, 86% of the children detained pretrial in Maryland were Black. We must look to diversion and preventions that address the underlying issues of crimes. We can work together towards a more just and equitable system that prioritizes public safety without perpetuating injustice. We all want safe communities, but we do not need to sacrifice our Black children to achieve it. For these reasons and others, as my colleagues will articulate, the Office of the Public Defender opposes Senate Bill 744 and urges that you return an unfavorable report. Thank you.
Excellent. Thank you very much. We're going to take questions at the end of the panel.
Good afternoon, Mr. Chair, Mr. Vice Chair, actually he's not here, and Senators. I am Keith Lottridge. I am the Deputy Public Defender for the state of Maryland. This omnibus bill includes many problematic proposals. Some are addressed by the Public Defender, Natasha Dartigue, and members of our team will address others. But I'm here to highlight the cost of this bill for the Public Defender's Office. Please understand that our due diligence in calculating and explaining the financial impact on the Office of the Public Defender is in no way an endorsement of this bill. We believe this bill will do much more harm than good and will set us back on a path that harms children and families. Fiscally, the bottom line is that we project this bill will require us to have another 29 to 30 positions and cost $2.6 million. This bill, and remember, this is an agency which is already stretched beyond capacity. We simply do not have the ability to take on more cases. Yet, this bill, and I'll go just 2 more seconds, this bill will require us to take on more because it expands the juvenile jurisdiction and it expands it in a way that includes cases that are the most resource intensive. We urge an unfavorable report. Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Erin Seegears, and I'm a youth defender here in Anne Arundel County. And we do urge an unfavorable report for SB 744, in part because portions of it undercuts one of the most effective tools that we have to help children, which in turn helps the public, and that is diversion. Diversion is when a kid gets in trouble and the system requires that they participate in services. These services include things like restitution, things like restorative circles, mental health, family support. And these services are highly effective. And if the children don't participate in it, their case can go to court. As opposed to probation, which takes months within the formal process, and that's only if the case is actually proven beyond a reasonable doubt. Diversion allows kids to get services quickly, and we know it is effective because that is what the data has shown us. Diversion gets kids and family services quickly, it's effective, and it needs to be more highly funded, and so we request an unfavorable report on SB 744.
Good afternoon, Mr. Chair and members of the committee. My name is Sarah Wendell. I'm also an assistant juvenile public defender in Anne Arundel County. And today I want to address the amendment proposed by Senate Bill 744 and why we oppose any amendment to Section 38A15B3, which specifically allows a court to detain a child who is accused of a new misdemeanor if they are already placed on a period of probation. The Office of the Public Defender opposes this amendment because it will disproportionately harm youth of color, youth with disabilities, and poor families. It's important for the committee to note that the majority of the misdemeanors that we see come into our juvenile court system come in the form of simple assaults, which are often school-based fights, as well as petty thefts like stolen AirPods, as well as trespasses. These are the charges that we're talking about. And like much of life, it takes youth and their families time to adjust to being under supervision and to acclimate to the services they're on. And for these reasons, we urge an unfavorable report.
All right, thank you very much. Questions? Senator Sidner has a question. Well, actually, let's do this panel first, and then we'll swap and do the round of questions. So we go ahead and if you want to ask the question now. Yeah, go for it. Yeah.
Thank you. And I asked the state's attorneys this same question earlier about data and these crimes. I think the last witness spoke about petty theft and some other things. Do you all have information or any data that could be shared about these particular offenses that we're looking to bring into law?
So I believe that information can be found. The Department of Juvenile Services, though not here today, do publish a data resource guide online. They just released a new one for fiscal year 2023, and it does break down offenses, repeat offenses, as well as the number of youth on probation when they commit a new offense, as long as that offense has been adjudicated, I think is the data they're looking at. But that's all published online and does give a breakdown in percentage based on offenses.
Those are, I guess if we're looking at last year's book, which is right here, these types of new offenses wouldn't be in there. So I guess I'm just trying to figure out if you have an idea of how many young people you all represented that may have been engaged in this type of criminal activity.
Do you mean from this prior year into the coming fiscal year?
Right.
Like currently?
Or recent data? I mean, it could be over the past few years.
At this point, I don't have any data for the committee, but I know the Public Defender's Office would be happy to provide that.
I'm sorry, Senator Sidner, are you asking for data for children that are 13 and over that we represented?
I wouldn't mind having disaggregated data to talk about 10, 11, 12-year-olds as well as the 13 and over, but disaggregated from, so those who would fall under this would be the 10, 11, 12-year-olds. But then there are also, I'm assuming you all have represented juveniles 13 through 18 who may have committed these. I would be interested in seeing all of that if you have it.
So in terms of individuals that we represented ages 13 and over from the cases that we've received, we were able to ascertain those numbers.
Okay.
So this is DJS's number from 2022, 10 to 13. Last year they collected it.
From 10 to 13, and I'm sorry, I'm going to ask you to report the number.
I'm sorry. This is in answer to part of your question, because I remember this from my testimony yesterday. DJS, the last time that many of these crimes were being put before the court, DJS was tracking them in 2022.
Mm-hmm.
That year, from 10 to 13, many of the crimes that they tracked was 1,081. Of the crimes that we believe are in this bill, and again, I'm referencing my research from another bill, it was about 46% of those crimes would be covered by this. That's a rough estimate, and we can follow that up. So it's about 600 crimes or 600 children potentially.
Thank you.
So that was my actually line question, because it was the fiscal impact, because it sounds like a lot for the fiscal impact. And I was wondering, so does that mean that you're expecting this series of if the expanded jurisdiction goes into place that's in this bill, how many children are committing those crimes if you're able to evaluate the fiscal impact for you to, represent them adequately?
So when we did our fiscal impact, we took that number.
Yeah.
And we actually did not say that we took 46% of that number. And then we took about 25% of that number and suggested they would be petitioned, and we would actually be representing them, and they'd go forward in more serious cases. And that's the number we used to come up with part of our fiscal impact. Because remember, this bill has multiple facets: extended probation, increased timelines, and other parts. But for just the raw numbers,
yeah, it
comes down to I think we came up with about 125 cases, and how many hours we thought attorneys dealing with 10, 11, and 12-year-olds, which again are the most resource intensive by far of juvenile cases, because one of the first things you're dealing with, and you're going to hear about, is competency. And then you're talking about, I mean, there's so many implications there, and bringing children up to the point where we can even bring them into court takes so long that once you talk about 125, 150 cases, that's a lot of attorney hours. And quite frankly, we just don't have those.
So the bottom line upfront number is around 120, 150 cases you're thinking.
That's an anticipated.
What's happening now? So those are cases that are getting diverted now, right? Or what's happening with them now?
I would let my juvenile defenders answer that question, because they'll be more accurately.
Yeah, that's what I think we want to know. Like, what's happening to them now, and where's the disconnect?
So essentially, until they come to the state's attorney's office, we are not engaged. And essentially, I would say that our advocacy is so that these 10 to 12-year-olds do not become our clients, especially when we know by the data and the research that diversion and services in the community works.
So they're getting diversion, they're getting community services now?
Yes, I do have defenders that can speak to diversion. Yeah.
Sure, yeah. If you have.
The population, I want to be correct to talk about the population of 10 to 12-year-olds who are not being charged under the current jurisdiction. So those are the kids who, since petitions can be filed for them, and anyone can refer them to services within the community.
That's the problem. I mean, that's a whole nother kettle of fish, which is a significant problem, which is why the since petitions are not being filed. I think there's like 2 jurisdictions in Maryland are doing this, maybe. I'm not sure, but the majority do not. And so that's another thing that, I'd love to talk about. If you could opine on that for a little bit.
I would just refer to comments that were made by the secretary at a previous hearing, and that part of it was education, and part of it was just not being intentional and using that service, because it was reported in jurisdictions that did use the service that it was successful, but we have jurisdictions throughout the state that are not availing themselves of the sins.
And that's good. I mean, that's good to understand. And then the other thing is just when I was talking about this in the interim, and you hear the practitioners are here before us, but so then what is the fundamental flaw for the sins process? Because you always hear, oh, there's no enforceability, this, that, and the other. And so can you help us understand that? And I mean, you've got a contempt of court thing maybe you could do, but what else can you do if some kid just wants to blow it? What happens?
So essentially, if the child is referred to sins and fails to cooperate or does not satisfactorily complete it, then DJS does have the authority at that point to forward it to the state's attorney's office. So it's not a situation where if the child does not participate, that's the end of the line. If they don't participate, then the DJS can forward it.
But not if it's for delinquency, yes, but not for anything else. They can forward that. Is that right?
The state's attorney's office would only deal with matters that were
under the current law. They wouldn't get forwarded that petition unless it's for delinquency.
Yes, under the current law, I would say the fundamental flaw of sins is that it's not being utilized. And I feel what the secretary did testify to earlier at a briefing in terms of when it when there was education on how to utilize it, that's when it started getting utilized. And that is pretty recently that the SINS process has just started to pick up. So I would say I don't believe we have the data yet to say that once it's being utilized by law enforcement, by people making referrals, that people are participating or not.
I'm just trying to highlight the pattern. I mean, they actually follow it to its logical conclusion. If someone blows it off, and then you can only send the petition if it's to the state's attorneys, if it's for delinquency, then there are a myriad of other offenses or things that are happening, that are non-compliance that are happening that are not referable to the state's attorneys, that DJS cannot do anything for, that there is no enforceability. And that's, so SINS is great to an extent. And that's why I'm trying to flush that out, because maybe there's something we can do with, I'm just trying to think creatively, but I think we have to be intellectually honest about that process and the flaws in that process.
And what I'll say to that in terms of the enforceability, so we'll talk about SINS for that small age group that can't be referred to DJS, that can't be charged through the delinquency process. And so that small age group, we're talking about, again, 10-year-olds, 11-year-olds, 12-year-olds. And a 10-year-old, blowing something off, really, that's when we have to look at, it's not just on the 10-year-old, looking at the family, was the support that we could put in the family and the community and in the schools to support this 10-year-old. For the kids who are 13 above, that is when we're talking about diversion that's within the juvenile system. And so that enforceability comes through, okay, you're in the diversion process. We are saying you need to participate in these services and these different things. And if you don't, then your case is going to court. And so that's where the enforceability comes in when we come to the 13 and above who are a part of DJS diversion.
Thank you all very much. Further questions from the committee? Thank you all. This has been great. So then we'll have the next round come up.
Good afternoon, Mr. Chair, members. My name is Alicia Capizzello. I'm Deputy Public Defender for Baltimore City. I'll speak about auto theft because we understand that harm is done when children participate in auto theft. There is a way to respond that is right for the victim and the child, and it's pre-charging diversion, also called informal adjustment. Studies show that diversion has high rates of victim satisfaction, including high rates of restitution recovery, which understandably is what most victims are interested in this situation. In fact, for auto theft, victims are more likely to receive restitution than if the case goes through the formal court process, and it all occurs much faster. Some of the best diversion is restorative circles where the child and the victim can come together and talk about the harm that's been done and how to repair it. It's important to note that when multiple children are in a stolen car, which is often the case, and SAO, the state's attorney's office, receives that case, all of the children will be charged with felony auto theft, no matter their involvement, even if they're mere passengers, days later. So just to close, that's why it is so important that 10 to 12-year-olds not be pulled into the delinquency system for auto theft, and that DJS retains its full power to informally adjust those cases. Thank you.
I'm going to speak to you. My name is Kimber Watts. I am the supervising attorney for our forensic mental health division, and I've been doing juvenile work for about 25 years now. I'm speaking specifically about the 10, 11, and 12-year-olds. One of the biggest problems that we have is that 2/3 of them are not going to be competent to stand trial. When that happens, they cannot get services because the the juvenile court does not have jurisdiction over them. That means that they get no services. Of those kids, most of them do not attain competency. Some do, but approximately 46% of the cases that the state's attorney that were forwarded to the state's attorney were either withdrawn, denied, or dismissed. A good number of those dismissals will have happened because the child did not attain competency within the constitutional timeframes. So they don't get the services they need. That being said, they can get those services when DJS handles them informally through a more robust SINS process. And I'm happy to answer any other questions along those lines. Thank you.
That was potentially the most important thing I've heard tonight.
Well, I have more if you have questions.
I gotta follow that.
I'm sorry.
No disrespect for anyone else. I'm just saying. Good
Good evening. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. Senate Bill 744 represents a step backwards. It is a relapse into the failed methods of our past. The bill will result in increased detention for youth, overly lengthy periods of probation, and unnecessary removal of children from their home to be placed at remote youth facilities. This bill will be uniquely detrimental to 10 to 12-year-olds, and the changes will disproportionately affect Black youth in marginalized communities. This bill is reactionary. The bill is not grounded in the science of adolescent development or best practices. And there seem to be questions about the data that is being presented in the media and to the legislature today. Before we lurch forward on this bill, the legislature might consider reconvening the Juvenile Justice Reform Council to analyze the concerns presented, have the JJRC issue a report, and then return to the table with well-reasoned recommendations so we can move forward together to improve the outcomes for Maryland's youth. I want to mention animal cruelty is not a predictor of future criminal behavior, and I do have some solutions on how to get kids to go to their services. Thank you.
Awesome. Well, I'm sure we'll be speaking in the days ahead. So I assume you're basing the incompetency numbers on pre-JJRA information?
That is correct.
Okay.
Because post JJRA passing, we
in,
had
yeah.
fewer 12-year-olds charged. There were still some, but fewer.
So it's 2/3.
Yeah, before the JJRA, it was 2/3 were found incompetent because they're little. You know, competency requires people to not just understand this is the state's attorney, this is my lawyer, this is the judge, but to understand that rationally and to be able to participate in their own defense. The concepts, to give you a very concrete example, just the other day, I was talking to a 13-year-old and it took me, I kid you not, an hour to explain to him that I was a lawyer, what a lawyer is, that I was his lawyer. And that was before we even got to the issues of what trials are, the right to remain silent, and that your silence really can't be held against you. An hour just to explain what a lawyer is and how that relates to him. So you can attain competency, and that doesn't include the lack of maturation of thinking that will happen sooner or later for many of our children. They also have mental health and intellectual disability issues. And so that complicates matters.
I appreciate that. Thank you. It's very helpful. Senator Sidner.
We were just having a sidebar conversation. How does one attain competency?
Sure. Well, it depends on why you're incompetent. There are a few different things that happen. So if you think about competency as like a two paths, right? You'll have some kids for whom they were found dangerous, they were detained, they go to what's called a facility for children. We have very few of those beds. What happens for those kids is that they go to that facility, think of mental hospitals as the best correlate. They get education where they're just told repeatedly, this is what a lawyer is, this is what the judge is, this is how the process works. That being said, for most of those children, they're at those facilities because they have intensive mental health or intellectual disabilities. So they are also getting medication for those issues. The problem, however, is that if the child needs individual therapy just because that's what they need, that does not necessarily relate to their ability to be competent to stand trial. So the Department of Health does not give them that treatment. There are a lot of reasons for that. I can tell you that the person to speak to about that is the Department of Behavioral Health Administration. Dr. Gilbalt is the chief of that particular forensic division.
Dr. who?
Michael Gilbalt.
Gilbalt.
Yep. Guilbault.
All right.
I email him from time to time, as you can see. But as I understand it, there are a lot of reasons that they can't do that. Not the least of which is that by policy, they don't want to encourage people to hospitalize kids as incompetent when really what they need is just treatment and services.
Right.
They don't want there to be an end run around. They don't want to overutilize it, I think is the issue.
Gotcha.
That being said, you've got the second subset of kids who are not dangerous, who are in the community living with their families, They get an attainment services provider who again talks to them about this is who the judge is, this is who the prosecutor is, et cetera. Those kids, again, are not going to get the whatever treatment is needed to properly rehabilitate them. They're just going to get services related to competency. Many of our clients come from disadvantaged neighborhoods and from families that are really struggling with a variety of issues. They're struggling with housing instability, food insecurity, lack of transportation. Nothing gets solved when they're incompetent along those lines. There are programs that do work with that. The SINS program, there are family preservation programs. There are SINA programs, depending on whether abuse or neglect is the issue. As you can see, I'm not a spring chicken anymore. So I can say back in the day, right? And I'm not a chicken either. Back in the day, we had a much more robust set of services for these kids. I think you're going to hear from Ann Geddes, who I'm shouting out to later. She, I should say, in my proper person, just as a citizen, not as a public defender, I'm also the co-chair for the Children, Youth, and Families Committee of the Behavioral Health Advisory Commission, as a parent of a child with mental illness. So what I can say, having done that work, is that we used to have a robust system where local management boards were really good at engaging families, and those services, like budgets, got slashed. They just really, over the last 15 years, have been gutted. And so we need to build those back. One thing along that topic that I noticed, I think it was Senator West, I apologize if I'm not thinking of the right person, who talked about the commission, that is lacking in this is that it doesn't include an evaluation of DHS, so Department of Human Services, which includes the Department of Social Services, the Behavioral Health Administration, or MSDE services. These are all organizations that touch on the lives of our children and families. And I think if we really want to improve the lives of Marylanders, and we do, that we have to look at all of that collectively and not just focus on DJS. Somebody was talking about the lack of drug treatment earlier. And drug treatment is something that DJS directs our children to, but DJS is not a drug treatment provider. We have to have those services. BHA does have drug treatment facilities, or did, at least for kids, but we don't anymore. A lot of those are contracted out to private businesses.
Yeah.
I'm sorry, what?
And out of state.
And out of state, right, because we don't have them anymore. And that has been it's not a new problem, that's for certain. And I think I got a little off topic.
No, Senator, I want to make sure you have a chance to answer your question, but I do want to move the conversation along. We have a lot of work to do this tonight, but Senator, I want to make you have a chance.
The only other question I have, and I'll try to make, and it's for the gentleman, and I'll try to make this as, you said you have a solution. What is your solution to having juveniles?
Well, it's not a perfect solution, but the solution lies in best practices. Best practices says that incentives work for youth better than sanctions, better than court orders. And when I mean incentives, I mean give the kids stuff. Give them little prizes, give them sports equipment and Xbox Game Pass, just like your children who would do things for little prizes and little rewards. These kids will too, and make it easy for them to get to the programs. Give them an Uber, give them transportation, and give them the prize. And what best practices says is that will get them there.
And you're talking youth of what age?
Any age.
Okay, thank you.
I wish that worked in my household, though. I tell you that. All right. No, in all seriousness, though, I mean, the conversation, that's why the creation of the Office of Children, working with the, $43 million has gone into that effort. And it's an attempt to rebuild some of those structures. And that's why that's important. So thank you for highlighting that. But again, the comprehensive nature of our approach this session. All right. Seeing no further questions, thank you all very much. We'll be in touch. Now we'll head off to, so now we can move on to, is Marlon Tilghman and Geeds. Mr. Little, and Mr. Love.
Senator Smith, you must not be from Maryland. That's Tillman.
Tillman.
Tillman Island.
No, hey, I'm from Silver Spring. So, hey, you know.
Good afternoon.
Part of that middle passage, though, so I know that.
There you go. Good afternoon, Senate Judicial Proceedings Committee, Reverend Dr. Marlon Tillman with Bridge, Maryland. We are an interfaith organization that strengthens congregations and faith leaders to demonstrate and advance justice in Maryland. We are unfavorable to SB 744 as it is written. We understand the fear that is real and perceived. We understand the urgency to calm your constituents by doing something. However, expediency and righteousness are rarely achieved at the same pace. We urge you to convene the commission now and assemble work groups of advocates and opponents of this bill so that our children will be less eligible to enter the legal system and receive services instead. Adding 10, 11, and 12-year-olds is contrary to the sacred text that says children are a gift to God. They are a reward for them. How do you treat your gifts? You do them with passion. I ask that you work with us in making this bill better.
Thank you. Hi, I'm Ann Geddes with the Mental Health Association of Maryland. Kimber said some of the things I wanted to talk about, but I do want to focus on mental health. 2/3 of the youth, maybe 70% of youth involved with DJS have a diagnosable mental health problem. About 60% of those also have a substance use disorder. Diversion and the provision of behavioral health services is critical to these kids. In the last decade, Maryland has failed youth with behavioral health conditions, leading many to come into contact with the juvenile justice system because they haven't gotten the services they need. The system of care for youth with behavioral health needs was dismantled during the last administration. Programs delivering intensive community-based services were terminated. There was a dramatic reduction in the number of therapeutic residential placements, including substance use residential placements, which there are none. We cannot ignore the impact that this has had on children's mental health and children's juvenile crime behavior. So the system needs to be fixed. These kids need help before they come in contact with the system. So we ask for an unfavorable report.
Thank you very much.
Right. What is on the table is not whether or not young people who commit heinous acts should be held accountable. And unfortunately, Fox 45, Southern Care Broadcasting, BAL Radio have made it so the public thinks that what's on the table is what, and they amplify individual instances of extreme violence and brutality to make the public believe that that's what's on the table. What's on the table is that this bill undermines the important efforts at diversion from young people who should not be in the system, that any contact with the system, folks that work with young people understand that that contact is going to be detrimental. And so part of the problem is that this bill widens the net. And that one of the things that when we talk about the need for services, that there's a gap in the services and the systems that are supposed to deal with young people. When we talk about victims, too often the victims that we don't talk about are those for whom contact with the criminal justice system is life-altering in ways that are irreparable. And so it's important that we're clear that when you widen the net, you widen the net and the relation or the contact that young people have to the system, you create the opportunity for more victims in that regard. And unfortunately, that doesn't resonate in the way that it should.
President, Mr. Chairman, members of the committee, senators, I'm the Reverend Kobe Little. I'm president of the Maryland NAACP. We are opposed to this legislation and we urge the committee to bring an unfavorable report. This legislation identifies a very real problem, but it comes up with the wrong solution. Are there exceptions for 10-year-olds to vote? Are there exceptions for 10-year-olds to drive? Are there exceptions for 10-year-olds to open a bank account? No. But this legislation holds children responsible for problems created by adults. Children are the most vulnerable in our society. Why is our response to a problem involving children one that involves prosecution and penalty? Why is that the first response? The law already says that 10-year-olds can be charged for violent crimes. That has not stopped violent crime. What we would like to see, Mr. President, in this legislation is resources that put youth workers on the street, resources that address the insecurity that young people feel in their communities and that allow guns to be in those communities for young people to access.
Going to cut you. Last time I cut a reverend off, I heard about it for about a week. So hey, you know. Heard about it on Sunday. I tell you that. All right. Is Ms. Kessler, are you coming up to testify?
No.
Okay, great. Questions from the committee? All right, thank you all very much. Thank you. All right, is Miss Emanuel here? Keith, are you here? Is Keith, you coming? Are you coming? Can you, while you coming? Kimberly Watts. Oh no, we already had Kimberly Watts. Emily Virgin. Kenneth Starks. Is Jeremy Zacher still here? Jeremy came up the last time. Josh Rovner. Saw Josh earlier. Is Miss Wilkerson, are you here to testify? Alice Wilkerson? I will start off with that.
Good evening, Chair Smith, members of the committee. For the record, my name is Yanette Emanuel, Public Policy Director for the ACLU of Maryland, here in opposition to SB 744, which as drafted is eerily reminiscent of the kinds of legislation that were influenced by the super predator myth and media propaganda, which perpetuate harmful stereotypes that Black people, especially Black children, are inherently criminal and warrant excessive punishment. As you've heard, SB 744 does not increase supports or services for kids, nor does it provide real solutions for the majority of concerns raised during the last year, such as carjackings, which is already covered under our crimes of violence statute. The fact is that crime rate is the lowest overall for the last 50 years, no matter the sensationalism that we increasingly see from some media outlets. We must correct past mistakes and say no to policies that exacerbate racial disparities, ignore evidence-based best practices for improving public safety, and do not provide real policy solutions or services that help our children succeed. While addressing violent crime in our community is important, attributing it to the wrong causes can lead us astray to effective solutions. For the foregoing reasons and those mentioned by my colleagues, we urge unfavorable report on SB 744. Thank you.
Good afternoon. I'm Josh Rovner, Director of Youth Justice at the Sentencing Project. Today's early conversation repeatedly referred to carjacking, but it's important for the committee to understand that this bill does not address that offense. The JJRA raised the minimum age of arrest to 13 for most offenses. However, carjacking is a crime of violence. Carjacking is one of 43 separate crimes of violence for which a 10-year-old can be arrested. This bill doesn't change that. Moreover, Maryland pretends that 16 and 17-year-olds are adults if they're arrested on that charge. This bill doesn't change that. Now, the JJRA also sensibly limited most initial terms of probation, but the JJRA did not limit probation for any of the 43 crimes of violence, including probation. This bill doesn't change that either. Please, let's debate the facts and not move this bill forward on things it does not do.
Good afternoon. I'm Alice Wilkerson, testifying in opposition to SB 744 on behalf of the Maryland Youth Justice Coalition. My JC opposes this bill because it ignores everything that 20 years of experience, data, and research tells us, that when it comes to public safety, what's best for kids is best for everyone. We want the same thing: safe communities, age-appropriate accountability for kids, and accountability for the systems that serve our kids and communities. As the committee contemplates this bill, ask yourself, how will this improve safety? Is this an evidence-based solution? What is the racial impact? Will this lead to positive behavioral change? My JC is especially concerned that this legislation will shift DJS expenditures to detention and will lead to more cuts to services. We can improve public safety and do what's best for kids, but we should not punish children for the failures of government systems. We ask that you read our written testimony, which has the support of 29 organizations. Thank you. I do want to say this has been a really good conversation. Thank you, Senate President, for being here for the duration of this conversation. We really appreciate it. It's been very good. So thank you.
"19 years ago, I stood here and I asked for residential treatment centers for children who are now adults. I asked for programs and services for children who are now dead. And now I'm embalming children. I adopted 5 boys who are now adults, and I'm a grandfather, 3 little girls. And I've had children in my house who I've been foster parents to. And I've raised a lot of hell, and you just asked me to be quiet because I'm passionate about this issue. And I've condemned the state's attorney. And I came up the other day and I didn't testify. I came just to talk to Ivan Bates, who's a good friend of mine. And the biggest issue, the biggest problem is programs and services for children who are in need of services. And that's our problem. Senate President and I have had this conversation 5 years ago. And I'm gonna sit down, but I want to read this to you because this is the problem. I want to read this and I'm gonna sit down. If you just give me a little latitude, I'm gonna read this.
You got a couple seconds here.
I totally agree. And I got to take my glasses off because I can't see. I totally agree. It's out of control. The bigger problem right now is that there's not enough clinicians outright, even less who are willing to work in the city. And you know who wrote me this? Bill Ferguson.
Appreciate you. Thank you very much.
I'm tired. Jill, God bless you.
All right.
We gotta do something, man.
Hey.
We need residential treatment centers for our kids. You wanna know who to talk to about the problem? Not those.
We're good. We're good.
state's
He's fine.
attorneys.
He's fine. He's fine. He's
No,
fine.
no,
Fine.
no, not the state's attorney. That guy.
I appreciate, listen,
We
so
got to talk to our child service agencies.
Appreciate-
Talk to AC why they got the numbers. We've been talking about it for 20+ years.
I appreciate your participation tonight. Thank you. All right. Look, this is part of the process, right? All right. All right. Do we have any questions from the committee for folks? Sure, Senator Sidnor.
That's a quick question. Gentlemen, I'm sorry. Could you give me your name again and
Sure, Josh Roper, ROV.
and you're with?
I'm with the Sentencing Project. We're a research and advocacy organization.
Thank you. Appreciate it.
How's your leg doing?
My leg?
Yeah, how's your leg doing?
Fully healed.
Good. Good to hear. All right. All right. Thank you all very much. Thank you. All right. Is Kenneth Starks here? Was that Kenneth?
KG Scott.
KG Scott? Kenji Scott, sorry. Yeah, that's right. Yeah.
Fred Chavis.
Who?
Fred Chavis.
Fred Chavis. And, okay, so is anyone, okay. I think that concludes the testimony. Once you're done, sir. Yep. For the in-person, we've got a couple folks joining us virtually.
All right. Peace and love, Senate. I'm Fred Chavis, Chairman of Liberation, Inc., nonprofit that services Black youth across the state of Maryland. One of our biggest focuses that we do is redefining the Black self-image. So I'm going to speak directly to Black youth that are growing up with a negative self-image of themselves. Because when we tell a child they're bad, they begin to believe that they're bad. When we tell them they're criminal, they begin to act as if they are criminal. Bills like this only punish our youth instead of addressing the root cause. We tell our youth to grow up and be somebody, but we don't address the conditions in our communities, such as poverty, food deserts, lack of housing, and poor education. So we redline off the Black community and we cut us off of resources. And then we say, we need you to do better. So I'm looking at approaches that service more of the community organizations. We know that there is a bridge, a huge broken bridge between government and community. We service our youth in our communities, and we need to support that more with community initiatives and programs. I'm a middle school science teacher. I work with kids precisely at this age, and my classroom has been a safe haven for our youth. And so I ask that we not pass bills that punish our youth, but instead address the root causes that causes them to misbehave and act out. Thank you.
Hey, thank you for hanging in there with us tonight, and thank you for your service as a teacher. Is questions from the committee? All right, thank you very much. All right, we're now going to switch to the witnesses joining us virtually. Before we unmute you, though, could you both, if you're streaming on YouTube, if you could shut down the browser or mute the browser before you come off of mute through Zoom, so we don't get the feedback loop. All right, we're going to go with Miss McKinney. Welcome. All right, I think Ms. McKinney, you're not unmuted yet. There you go.
You can hear me now?
We can. Welcome.
Good evening. Thank you. For the sake of time, I'm going to say thank you to Senator Signor for his comment about media not influencing his decision. I'd like to thank Senator Carter for her recognizing that we're putting adult behavior on the weight of children. There was a comment earlier about ensuring police could make proper arrests. But what I'd like to say is that how about we ensure police can engage with our youth in a proper manner? They have community divisions that are not properly funded. I've been trying to engage with officers in my community to bring a positive relationship. And I think that's an enhancement that needs to be made. And unless we're going to address preventive measures, we need to stop focusing on punishment and for our youth. I just think it's mind-boggling that we're holding children that can't even drive to be responsible for making appointments that were made for them to address their needs and issues. Thank you.
Excellent. Thank you for hanging in there with us. All right, Miss Melissa, Miss Goldman, you're up. Good to see you.
Thank you. I'm testifying on behalf of the National Youth Justice Network. We are deeply concerned with this bill's inappropriate expansion of charges for 10 to 12-year-olds. As several of you have mentioned, we have not seen any data to indicate a marked increase in offending by this age group of children. Rather, we have seen fear that's been whipped up by some media outlets. Incarcerated children are at the highest risk of becoming victims of physical or sexual abuse and experiencing psychological issues. And even if they're not locked up, merely experiencing arrest, handcuffing, and involvement in the justice system at such a young age is a very traumatic experience that can leave lasting scars, both emotionally and in terms of the collateral consequences of a juvenile justice record. A commission to help further successfully implement the JJRA is a great idea that we support. But this bill as currently written would lead to more criminalization of young, primarily Black and Brown children, and we urge an unfavorable report.
Excellent. Thank you very much. Good to see you.
Thank you.
Is that all right? Mr. Dole, James, you're up. Welcome back.
Thank you so much, Mr. Chairman, and thank you, President Ferguson, as well, for being present during this hearing. James Dole, to register our opposition to this bill. Our concerns really stem around the provisions on page 7, subsection 5. Back in 2022, we recognized Maryland as one of the most improved states in our national state ratings report. That was due in part to the fact that the state had created through the JJRA a provision that established a minimum age of juvenile court jurisdiction. Our concern with the language as it currently reads on page 7 is that it creates a conflict in the law where we believe courts could interpret the language as allowing children under the age of 10 to be adjudicated delinquent. We would encourage an amendment to clarify that children under the age of 10 cannot be adjudicated delinquent, but rather can only have a sins process filed against them. And Mr. Chairman, to your point earlier, I just want to flag that I think one of the issues that's coming up in Maryland, one of the problems that with the confusion around the process is that it's not clear entirely in the statutes how the courts can go about using their power under child in need of services adjudication to then require the child and their family to participate in certain types of services. I would strongly encourage the committee to look to neighboring Virginia, where this process is very clearly laid out of what the courts are allowed to do when a child is designated either a child in need of the services or a child in need of supervision, because it's very clear what the process is for the court and how they can maintain jurisdiction over those children and their families to make sure that the kids are getting the proper supports and services. I really think that the big issue that's coming up is that there needs to be greater clarity in the law about what the authorizations are to the court when kids come into the system. And so with that, Mr. Chairman, I'd be happy to answer any questions and I will yield my testimony. Thank you.
Excellent. Mr. Dold, as always, sage advice. We will follow up with you. Thank you very much for that. Further questions from the committee? All right, seeing none, then that will finally conclude the hearing for Senate Bill 744. Thank you all. All right, we're now going to move on to Senate Bill 471.
Good afternoon, Mr. Chairman, members of the committee. Good evening. Thank you for hanging in here with us today. My name is Dorothy Lenig. I'm the Executive Director of the Governor's Office of Crime Prevention and Policy. And yes, you can call it GOCAP again. Yay. The Criminal Injuries Compensation Board is housed at GOCAP, and that's why I'm here today on behalf of Governor Moore to urge a favorable report on Senate Bill 471. The Criminal Injuries Compensation Fund provides aid to victims of crime in Maryland, and for those who qualify, it can be a really extremely helpful remedy. It provides really reimbursement for all kinds of injuries that occur. Unfortunately, the law as it's currently laid out is difficult for victims to access and difficult to get reimbursement. It has requirements like the crime has to be reported within 48 hours. The victim has to fully cooperate with law enforcement. It limits who can be compensated and for what. This bill amends much of that, and my colleagues will lay out some of the differences. Senate Bill 471 does not change that the claimant still has to show that they've been the victim of a crime, and it still, in most cases, limits the payments to be the payer of last resort. I will focus on the changes that would actually occur under GOCAP's responsibility. The first big change that this bill makes is it really aligns the law to how it works now. What the law says is that the board, the Criminal Injuries Compensation Board, makes the decisions when they receive the claims, but in fact, the staff is really laying it out, making the decision and referring it to the board. I asked the staff, how many times has the board rejected your recommendation? Everybody said they could only remember one time that it ever happened. So this bill would make it so that the staff makes the decision and the board would be the first level of appeal, which would be good because currently the appeals go to the circuit court, which is really hard for the average claimant to work their way through. The second big change that it makes is that it would change the amount of time that the board, that the staff has to respond to claims. So currently, when we get the claims, the applications, they have 30 days to let the claimant know what's missing from the application, and they get 90 days to actually make a decision. This would reduce the amount of time that our staff has to make the award to 30 days. And that's part of the reason there's a big fiscal note attached to it, because we would need a lot more staff. It also expands the board from 5 members to 7 members, and it requires the board to be much more diverse, including racial and ethnic diversity, geographic, gender, includes people from the survivor community. It also orders GOCAP to create an online portal so applicants can apply that way. Not everybody can get to Reisterstown Road. That can be really complicated. The US mail can be difficult, so this would allow people to apply online. And finally, it orders GOCAP to report to the General Assembly on 7 data points with respect to the claimants. And so for these reasons and the reasons my colleagues will discuss, the governor's office is asking for a favorable report. Thank you.
Good evening, distinguished members of the committee. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. I have worked on issues of equity and access to victim compensation across the country for over a decade, including in my previous role at the U.S. Department of Justice. In 2023, I co-authored a national publication laying out the research and policy case behind needed reforms. SB 471 is a model policy. In addition to extensive research supplied in my written testimony, I want to draw the committee's attention to the fact that just this week, DOJ released new guidance for states for the first time in a generation, which also make clear this is a model policy. The Victim Compensation Reform Act is not just about the healing and dignity of victims. It is about public safety. By assisting with the destabilizing expenses in the aftermath of trauma, compensation helps reduce the risk of future victimization and cost of violence to the state. Compensation programs give government agencies a different way to respond to victimization outside of the criminal legal framework, providing the opportunity for government and community to work together to build trusting relationships needed to interrupt cycles of violence and solve crime. Currently, there are numerous factors undermining program effectiveness, including unreasonable attempts to promote victim, quote, cooperation and reporting to police, and operating on a flawed model of only supporting, quote, innocent victims, leading to determinations of worthiness often influenced by race and other discriminatory factors. SB 471 is the product of collaboration by a diverse coalition designed to address these barriers and build systemic legitimacy. And lastly, I will note that in addition to removing the discriminatory aspects of the process, it adds critical forms of support, including relocation and childcare, and raises outdated payment amounts for benefits, including funeral and burial and mental health support. We urge a favorable report. Thank you.
Thank you very much. Busy week for DOJ.
Good evening, everyone. Thank you. My name is Kyle Fisher. I know many of you in the past from my role as an emergency room doctor at the University of Maryland, but today I'm here speaking on behalf of the Health Alliance for Violence Intervention, the HAVI. The HAVI is a national network of hostile-based violence intervention programs. We have about 50 member programs around the country and a half dozen here in Maryland, and we are victim service providers that focus on the survivors of community violence. Our collective experience is that Maryland's victims compensation system really exists in name only for our patients. So despite the fact that the folks that I take care of are survivors of attempted homicide, the reimbursement rate in our victims compensation system approaches 0%. It's not an exaggeration, it's roughly 0%. This leaves survivors in financial crisis, and it really impedes our ability to build public safety, especially when individuals find themselves suddenly using the underground economy to keep themselves afloat. So this bill makes significant improvements to our state system to both increase access and improve public safety. The main way that it does this is by streamlining processes and fixing unintended consequences from bureaucratic bloat. Helpful areas include removing requirements for a police report within 48 hours, which most survivors don't even know exists until they go to apply. Increases the options for evidence that victims can use, such as medical records or documentation from qualified victims assistance providers. And most importantly, it removes this vague language that requires law enforcement cooperation that our clients regularly say that I spoke to the law enforcement, I told them what I know, I thought I cooperated, and then later on down the line, they were told that they did not meet the criteria. So with that, I respectfully ask this committee to vote favorably on this legislation. Thank you.
Good afternoon, Chair and Vice Chair and legislators, thank you for all that you're doing. Thank you, Governor Moore, for your commitment to reforming this bill. My name is Dr. Deborah G. Haskins. I'm a lifelong resident of Baltimore City. Today, I'm here representing our son, Joseph, Jojo, and my nephew, Reuben Haskins. They are not homicide numbers. They are loved. They have families. They had dreams. I also represent all families that are impacted and affected by criminal injuries. I thought homicide happened to other people until it happened to us. In the state of Maryland, there's a lack of coordinated services and assistance and advocacy for criminal injuries. Assistance, people don't even know it exists. How do I know? We were not contacted by the state until 5 years later. The proposed bill will overhaul needed changes. First, we must change who qualifies. Jojo's fiance, his stepson, and Jojo and Reuben's siblings did not qualify. Jojo's daughter was only 2 months old at the time. She will never know her father or hear his voice or feel his touch. She's now 10. My husband's heart was murdered, and he died of the collateral damage of the homicidal injuries of both our son and nephew in 2016. Second, the current law provides up to 3 years of counseling, and it's capped. It's a reimbursement model. This is unacceptable. The current law discriminates against people who don't have material resources. We did, and I do. I'm concerned about the vast many, particularly communities of color and people who live and are challenged by poverty who don't. So I'm asking that you please give favorable reports so that every victim in the state of Maryland gets compassionate care right from the start, allowing them to breathe with the support so that they can learn to live and love again. Thank you so much.
Thank you very much. I say, as you held the picture up, it brought back so many memories. Her husband, who was in that picture, we were roommates in seminary together. He was the best man in my wedding, and we served together for many years in the United Methodist Church. The family and all, I've known them, I love them. My heart was broken when he went home to be with the Lord. But holding up that picture brought back so many memories of us as roommates running around trying to be preachers and in seminary. I love you, I love the family, and always shall. Thank you for letting me say that.
No, of course, Senator. And Doctor, thank you. I mean, look, the subject matter in this committee is such that we hear these stories far too often, and it never gets any easier, but it's always remarkable to us to see the courage of people willing to step up and come up and engage in the process and to affect change. And so just want to honor that and say thank you for that.
Thank you, Mr. Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence, here in support of Senate Bill 471. We're incredibly grateful that the administration has taken this on this session. This has been a work several years in the making. Just want to cover some of the very specifics of what this piece of legislation will do. Removes the requirement that you must report the crime within 48 hours. It removes the requirement that you cooperate with law enforcement. It removes the requirement or the concept that you could have contributed to your own victimization. You need to have a crime and you need to have a victim, but you don't need to go through law enforcement to prove that. There's alternate documentation. The qualified third party language is existing in Maryland law. This General Assembly first passed that language in 2022, and it's then been repeated in other areas of the law. And especially for victims of gender-based violence, they overwhelmingly don't report cases to law enforcement. So they therefore are not eligible for victim compensation. So this would open up the door for victims of gender-based violence to actually receive victim compensation. It updates our law to reflect how families look. So domestic partners, other dependent children, and other adults that might be under some sort of guardianship would now be eligible. It increases the amount. One of the other critical pieces is that it expands and improves the emergency process so that if there's need for funeral expenses, that there's a presumption that those would be awarded, and crime scene cleanup and relocation, transportation costs and childcare costs for a victim who needs that childcare coverage so that they can seek the services that they are very much in need of.
And so for all of those reasons, we are urging a favorable report on Senate Bill 471.
Excellent. Thank you all very much. Questions from the committee? Oh, come on up. I haven't forgotten you. The questions for the committee from this panel. All right.
Good. Okay, I'm gonna keep this short. No
Please.
worry.
Take your time.
Okay, dear chairman and committee members, my name is Janae Elder and I'm a violence prevention specialist at the R. Adams Cowley Shock Trauma Center located in Baltimore, Maryland. I'm writing today in support of Senate Bill 471. This bill is a reminder that making alterations to bills for crime victims is not just about legal statutes. It's about affirming their dignity, restoring their sense of security, and empowering them on their journey toward healing. Victims of crimes are not just statistics. They are individuals whose lives have been changed. The alterations to Senate Bill 471 prioritize their needs and sends a powerful message. You are seen, you are heard, and you matter. The Violence Prevention Program at the R. Adams Cowley Shock Trauma Center is determined to reduce the frequency and severity of recidivism for violent injury and criminal activity among persons living in and around Baltimore City. Victims of violent crime are often face numerous barriers that can impede their ability to recover and seek justice. These barriers can vary depending on the nature of crime, the social and cultural context, and the resources available to the victim. The revisions to the bill are indeed promising, particularly in their enhancement of funding for mental health services. The increase from $10,000 to $45,000 for each claimant underscores the recognition of the critical role mental health support plays in the recovery process for victims of crime. These adjustments demonstrate a commitment to providing comprehensive assistance to individuals affected by crime, addressing both their emotional well-being and practical needs resulting from such incidents. The scars left by crime may be visible, but their pain is real. Let us be agents of healing and hope for those who carry these burdens and support Senate Bill 471. Thank you.
All right. Thank you all. I think we're going to bring up the next panel. Thank you. Thanks for hanging in there with us. Keith, you coming up? Is Mark Mason still here? Okay, got it. And then what about Lisa Sloyer? Oh, yeah. Judge. I guess I don't know if it's appropriate to say that, but okay. And then Melanie Shapiro said, and then we've got a couple of people joining us virtually, but let's finish up with the panel first. Keith.
Thank you so much, Mr. Chair, for having me and for this hearing on this important bill. One that is very near and dear to me. I'm here today to discuss my experience to help understand from a practical perspective why this policy change is needed and hopefully help move the needle forward and towards passage. I grew up in a household of two very hardworking parents. Both of my parents worked factory jobs. My dad, in 30 years, never had a sick day. My mom worked 6 days a week. They both made about $22,000 a year for a house of six. So when my brother was shot and killed, we obviously did not have the resources for what came next. I was actually in college at the time, my twin brother and I, and it was my basketball coach and teammates had to organize to get us home so we can be there for the services. So we had to, quote, beg, borrow, and steal to get money for the funeral and services, even for clothes. Family donated, family and friends bought clothes for my brother and I to wear. And then it was a while after he was buried before he even was able to put a tombstone on his grave. That wasn't great. This bill will address funeral expenses and help folks in situations like that. And losing my brother was the catalyst to losing my mother. My mother never recovered from that. She never moved forward. And she was very healthy before my brother was killed. But she never moved forward afterwards, and she ended up passing. She never got the counseling that she needed. One of the things I appreciate about this bill is it does help folks. It does help by supporting counseling and allowing folks to move forward and heal. So I ask for a favorable judgment on behalf of me and the Justice Policy Institute in support of this bill to help others move forward and heal after such events. Thank you so much for your time.
Good evening, Chairperson, Vice Chairperson, and members of the committee. My name is Lisa Sloyer, and I'm the Advocacy and Resources Program Manager at Turnaround Inc., a Baltimore-based organization that has been working with victims of intimate partner violence, sexual violence, and human trafficking for more than 40 years. We see firsthand the emotional, physical, and financial trauma that survivors of these crimes experience. I know it's been a long day, so I will just stick to, as Turnaround, we urge for a favorable report on Senate Bill 471.
Good evening. My name is Stanley Mitchell. I'm a community activist and also an advocate for criminal justice issues. I'm here on behalf of this bill from personal experience. I have a nephew that's 6'10" that had a serious jump shot. He was on his way to University of Maryland College as to be on the basketball team. They had to pick up basketball game, and there was a shootout on the basketball court. It left him paralyzed from the left side for a long time. Otherwise, his basketball career was over. When he went to go to the board to try to get some assistance, they want him to solve the crime. Who shot you? Why they shot you? He was playing basketball to the shootout. So I'm hoping that this bill will be passed and people will not have to be agents of law enforcement just to get compensated. Thank you.
Good evening again, Mr. Chairman and committee members. I'm Katie Curran O'Malley, and I'm here on behalf of the Women's Law Center. Our center provides direct legal services for thousands of victims of domestic violence, and this bill really will help change things that's been affecting a lot of the victims in domestic violence cases. This past year in Maryland, zero monies in FY 2023 were given to victims of domestic violence. One of the key components of this new act will take away the requirement that a victim has to report the crime within 48 hours. That's just not realistic when we're dealing with domestic violence cases. Victims choose to stay in situations for so many reasons. It's difficult for them even to identify whether or not there's been a pattern of abuse. And once they do, sometimes it's way beyond 48 hours. There's also the requirement that they cooperate with law enforcement, and that can be very subjective. And so, as I stated, in FY 2023, there was zero monies given to victims of domestic violence. Maryland also has one of the lowest rates of victim compensation in our country. Over 60% of all claims were denied victim compensation in just the last year. So this bill, again, everyone's been here so long, so I thank you for all your patience and all the hard work that you do for Marylanders. So I won't belabor it, but the Women's Law Center strongly supports Senate Bill 471, and thank you for your indulgence.
Thank you all very much. Thank you for hanging in there with us. Questions from the committee? All right, thank you all. We're going to switch to actually, Ms. King, did you want to testify?
Me too.
Excellent testimony. All right. All right. All right, so we're gonna, Ms. Kane, you're up. Welcome. And just before we unmute you, if you're streaming through YouTube, if you could just shut down the browser or mute the browser and then come on in.
Am I on?
Yes.
Can you hear me?
We can hear you, yes.
Oh, good evening, everyone. And thank you so much for allowing me to speak today. My name is Darlene Kane. I strongly support SB 471. It will help families with the support they need for counseling, medical bills, and emergency moving expenses. The reason the bill is so important to me is because I'm an impacted mother myself. My son, Dale Graham, was killed by a Baltimore City police officer in 2008. I had temporary custody of my two granddaughters. We could have benefited from counseling and help towards moving. I was very depressed, could barely work. My full-time job caring for patients. I needed help my own self. I had to go back to work in an environment, taking care of people, and was not able to take care of myself. I had a hard time filling out the application due to the working questions asked to the best of my knowledge. I was denied twice and applied for a waiver. Being denied, I felt hopeless for my grandchildren to get the help that we needed. They were only 3 and 6 and wasn't able to explain to them how their father had died or what had happened to them. That's why the counseling was so important for us to have. I strongly urge you to pass SB 471 so families don't suffer like me to be denied when it's a time that we really need to have the help. I'm here to say today to ask families like me who were denied for years to grandfather us to receive this assistance. Their daughters are now 19 and 21. They pay their own way to school for their education to further themselves. And this is the tuition that they pay on their own at a very young age. It has been 15 years for me, and we still deserve assistance. Thank you for allowing me to speak in this opportunity. I truly appreciate it all. Thank you.
Thank you very much. Are there any questions for our witness? All right, then I believe that closes or ends our testimony for Senate Bill 471. 471. Thank you all very much. All right, so next we'll hear there's the task force bill. 617.
Answer your own question.
Yes, please. I know Ms. King's here, and then Heather, Ms. Workin.
All right. Let's see. Senate Bill 617, Charles Sidnor for the record. Good evening, everyone. Senate Bill 617 incorporates recommendations contained, or at least some of the recommendations contained in the final report from the task force to study transparency standards for state's attorneys. Within your testimony, not only will you see mine, but you also see the task force's final report. Just for your information, I was the co-chair of the task force representing the Senate. Senator McKay also served on that same task force with us. The task force recommended 1, all state's attorneys' offices should adopt and use an automated case management system. 2, a statewide uniform data collection procedure should be adopted within the CMS. 3, the state should provide state's attorneys' offices with the funding needed to assist a CMS, and that's the case management system, set up as well as data sharing. 4, that there should be some form of data publication. And 5, that the task force should be extended for 3 years and its membership should be expanded. First, Senate Bill 617 creates a special non-lapsing CMS grant fund. The fund will provide state's attorneys' offices with funds only to establish or improve CMSs. The fund will consist of money appropriated in the state budget, interest earnings on the fund, and money from any other sources accepted to benefit the fund. The executive director for the governor's office of crime prevention and policy will administer that fund. The executive director would also establish procedures to apply for and receive fund grants and solicit proposals from state's attorneys' offices. When state's attorneys' offices apply for the grant from the fund, they would have to provide a description of the CMS they seek to establish and improve, and other information that the executive director considers necessary. Once an office receives a grant, the office must submit proof of the expenditures of the funds of the to the executive director. And one of the things that would be expected, and if you were to look at the task force's list or recommendations, there's a list of certain data that would be kind of contingent upon receipt of that funding, or at least that would be the expectation. Let's see what else. Additionally, the task force, there were some members on it that looked for an expansion of membership. So there'll be an expansion to include the executive director of GOCAP, the attorney general or their designee, and the public defender or their designee. Finally, it also would prolong the length of the task force, which is supposed to, I believe, expire this year for a period of 5 years, so that we could serve and kind of oversee the implementation of this through June 30th, 2027. I will tell you that if you had an opportunity to look at any of the hearings we had, things didn't always turn quite out like I expected. We found out that there were three state's attorney's offices, Garrett and Queen Anne's, who both don't have case management systems. And Talbot, at the time, they didn't have one, but it was our understanding that they were moving towards purchasing one. We went in with the expectation that everyone had already had these CMS systems. Come to find out, they don't. So whereas we went in here looking to bring some clarity and some transparency to the office, you can't really get the transparency until you make certain everybody has a system and that systems can speak with one another. Thankfully, I had also had some conversations with some others who used to be state's attorneys, and they said that they had attempted some efforts in the past where they looked at this as more of a public safety type of an issue, so that state's attorneys could share data across across counties. So again, that's essentially what the bill does. It creates a funding mechanism to begin making certain that our state's attorneys have CMS systems. So that's really the bulk of it. You probably hear from the Maryland State's Attorneys Association, who I believe they oppose this. If you were to listen to their testimony, the president of that organization was in opposition because he didn't want people to take this information and use it in a political manner, or people to work towards what did he say? To work towards a certain test grade or something. Anyway, to be honest with you, I think if we're going to be having a good system in place, there are a number of state's attorneys' offices that collect this kind of data. In fact, they have data dashboards. That includes Montgomery County, who worked with an organization to do this. It includes Frederick County, your county. It includes Baltimore City, and I'm not certain if Prince George's County is one of them. So they're putting the information out so you understand what's going on. And that's simply what we wanted to initially do. But again, until we make certain that our systems are collecting similar data and that everybody has these systems, we have this bill so that we can walk before we run. So with that, I want to hand it over to my able panelists who are all, Ms. Warnken was a member on the task force. So I'm going to be quiet right there. Okay. Thank you.
Thank you. Good evening again. Heather Warnken, Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. I was honored in 2023 to be appointed by Governor Moore to serve on the task force. So I'm here in strong support of SB 617. I'll tell you a little bit about why we view this bill as so important. So prosecutors are widely understood to be among the most powerful actors in the criminal justice system, wielding tremendous authority and discretion to pursue or decline criminal cases. They decide what charges to bring, when and what pleas to offer, and numerous other decision points that impact the lives of not just people accused of crimes, but their loved ones, their communities, victims of crime, and society writ large. So again, these reasons about why we view this bill are important are directly informed by my experience on the task force thus far. And number one, I'll start with the fact that advancing both the infrastructure and the culture change needed for quality, consistent data collection at both the county and state level is a long road, and this work has just begun. SB 617, as Senator Sidnor noted, extends the life of the task force to continue examining these important issues surrounding transparency and accountability, and help steward an effective path forward that's designed to promote equity and systemic legitimacy and support states' attorneys' offices in allocating their limited resources in effective and efficient ways. Number two, it expands and diversifies the task force membership to include needed perspectives, including OPD. So it was my experience in the task force thus far that this omission impeded our work. And lastly, moving from anecdote to evidence. So urgent, complex public safety issues like the ones this committee wrestles with deserve to be informed by data. I think the last hearing made that very clear. We urge a favorable report. Thank you.
Good evening. My name is Joyce King, Chief Counsel of the Frederick County State's Attorney's Office. I am here in my capacity representing Frederick County and not the MSAA's position. The Frederick County State's Attorney's Office supports SB 617. I do want to thank Senator Sidnor and the task force for their diligent work championing this important topic. I can attest as a National District Attorneys Association board member that data dashboards and the collection of data is an important initiative nationwide. As we've heard in hearings today, we need to have data-informed policy decisions. With regards to the bill specifically, we do agree with the expansion of the task force as well as this needing to be a funded mandate. I can speak for the jurisdictions the 5 jurisdictions that are participating with PPI in this initiative is that it is cost prohibitive. It will be cost prohibitive for many jurisdictions. So the funding is absolutely necessary. And I can elaborate if there are any other questions with regards to the importance of data with our efficiency and effectiveness as prosecutors. I know from the questions today that you all understand that already. So we ask for a favorable report.
Good afternoon, good evening, I guess. My name's Mona Sahaf. I'm a Maryland resident and work at the Vera Institute of Justice, directing the Reshaping Prosecution Program. We help prosecutors increase public safety by using data and evidence to drive policy and practice change. Before joining the Vera Institute, I was a federal prosecutor for over 12 years, working on domestic violence cases, violent crime cases, national security cases. I appreciate the opportunity to testify in support of this bill, which will help prosecutors operate more efficiently, measure their progress in delivering safety and justice, and increase transparency with their communities. When I was a prosecutor, I had many unanswered questions about whether we were fulfilling our mission. Were we prioritizing the most serious cases? Were we making our communities safer? Stakeholders and community members, judges, folks in the community, survivors, they had questions I could not answer, such as how many domestic violence cases were being dismissed because victims did not want to participate in a prosecution. Had we increased or decreased prosecutions in priority areas? And most prosecutors in Maryland are in the exact same boat that I was. Without an ability to analyze data, you're making decisions that are vital about resources based on gut feelings or the traditions of the office or the latest news headlines. Meanwhile, stakeholders and communities are left with many questions unanswered. For too long, prosecutors' offices have really been black boxes and communities have not understood what is happening inside them. So this bill is an important step forward, increasing that transparency. I've worked with prosecutors across the country to put data transparency into place. They've eagerly embraced it. They've used it to allocate resources, increase efficiency, and measure their outcomes. And this includes in much more conservative jurisdictions, including Florida, Arizona, and Utah. Finally, I just want to say, to put this bill into context, this bill represents a lot of compromise. It is not particularly adventurous or, advancing the ball too quickly. This is a very cautious step forward, and it's doing what we need to do, which is get the state's attorneys the money they need and give them some time to build the data culture so that they can ultimately then use that data, make much better decisions, answer questions at hearings like these and in their community. Thank you.
Questions from the committee? I love the bill. I'm just, it's baffling me. Sorry, that the fiscal note is just baffling me. I don't know. It just seems, yeah. All right, Senator McKay.
So, thank you, Mr. Chairman, and thank you, Senator, for bringing the bill. I guess my first question, Madam State's Attorney, may I ask you a question? So in Frederick County, who brings the charges?
What do you mean?
There was a statement by the young lady about overwhelmingly that the state's attorneys bring the charges.
No, the police department bring the charges and we indict.
Right. And I had heard that about 90% of the charges are from the police department.
That's correct.
Okay. I just think that that's from DC or from federal, that is different. Maryland's a little bit different when it comes to where those charges come from. A couple of the members that I'm done. Thank you
Oh,
very
okay.
much. I appreciate that.
It's an easy one.
Yeah. So, Senator.
Yes, sir.
So, a couple of the members on there, thank you for allowing us to be favorable for this task force and take in consideration some of the things. And so, while I was one that was not exactly sure of the expansion of the committee was the direction that we needed to go, but we thought that the overall getting the funding and getting everybody on the quote unquote same song sheet was important, and then we can make those decisions of the expansion later. I just didn't want to miss that opportunity to put that on the record.
Yes, sir.
And I don't believe that the fiscal note is going to be as high as that. We've talked to some of the other different vendors and different things like that, you know, obviously this software is not, can't get this at Staples, but there is some of that that's going to be really bring it down.
There are about three different
It's really
vendors.
based upon how many users you're going to be using in your particular county and that kind of
Correct.
stuff. And I tend to believe that I'm not sure everybody has to have access. If most of the people are the data entry, then that can cut down on a lot of the costs. So I think it's a work in progress, which has my support.
All right.
Seeing no further questions, thank you all very much. Thanks for hanging in there with us. All right, we do have a couple people signed up as well. Is Mr. Love here, Davon Love? Melba Pearson, or oh, hey, there you are. Keith Lotridge, there, yeah, I see you, Keith, right there. And that's it.
So good evening, everyone. Thank you, Mr. Chair and the senators for allowing me to speak in favor of Senate Bill 617. My name is Melba Pearson, and I am the Director of Prosecution Projects at Florida International University and one of the co-managers of the Prosecutorial Performance Indicators Project, also known as the PPIs. Previous to this role, I was a prosecutor handling homicides for 16 years. As part of the PPIs, we work with prosecutors' offices around the country using their case management systems to create public-facing dashboards so that anyone can know what justice looks like in their communities. Nationally, since 2017, we have worked with over 30 prosecutors' offices. In Maryland, we released a dashboard in Montgomery County last year, 2023, and we anticipate releasing 4 more dashboards this coming May for Prince George's County, Frederick, Charles, and Baltimore City. Data collection is important in answering questions around crime. For instance, much like the discussion we had today around the number of juveniles involved in violent crimes, types of crimes, age ranges, length of time to file or resolve cases, as well as recidivism rates. It can shed light on what policies and programs are working and what are not. Data allows offices to track trends to make data-informed decisions. This bill will allow for financially strapped prosecutors' offices to improve their data collection methods. It is so critical to allot funds towards transparency. Unfunded mandates do not work, and the goal is not to burden prosecutors, especially when hiring and retention has been a struggle in recent years. We at the PPIs, in collaboration with our local partners, University of Maryland, Bowie State University, and Morgan State University, held listening sessions. And one thing is clear: the community wants to know more about the work of our prosecutors and how it impacts their lives. In developing the PPIs, we spoke to a wide number of stakeholders to understand what was most important to them, which greatly informed the final tool we use today. The expansion of the task force to include more voices will lead to a measured, balanced, and attainable metrics that will speak to the needs of all Maryland residents. Justice by its nature is transparent. More transparency allows for even greater justice. Thank you for this time, and I ask for a favorable report.
Good evening, Mr. Chair, members. I'm Keith Lotridge. I'm the Deputy Public Defender for the state of Maryland. We are urging a favorable report on SB 617. First, OPD fully understands and supports the need for funding of effective case management systems. This will help the individual offices of the state attorneys across the state. And more importantly, from my perspective, it will aid in their ability to communicate with opposing counsel and to provide discovery in a timely manner and allow for substantive data collection. Second, this bill adds the Office of the Public Defender to the task force. OPD represents nearly 90% of the criminal defendants in this state. Our work gives us an insight like few others and a responsibility to match. We most assuredly have both the knowledge and experience that would be critical to any discussion of the transparency, data collection, and the process for sharing that information. And while it may surprise some, there are many instances where the Office of Public Defender would have the same concerns about transparency as other members on the task force. However, we also understand the need for a reasoned policy on transparency, examining what's prosecuted and how it moves forward. We urge your favorable report. Thank you.
All right, questions from the committee? Seeing none, have a great weekend. Get started before we will. All right. We do have one, so that'll conclude the testimony for the proponents of the bill. We have Steve Kroll signed up in opposition.
Chairman, members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator, Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases for 39 years. Senator Sidner, I was part of that committee you were on, and I welcome talking to you at that time and all times. I thought it was very insightful. I truly did. Learned a lot from being part of it from there. However, putting the Public Defender's Office on this committee is like watching season 2 of The Bear, episode 6, titled Fishes on Apple TV. So for those of you who haven't seen that, I welcome you to see that. That will be a train wreck, a bus wreck, and a plane wreck altogether. So please remove the public defender to avoid any future confrontation. I urge you to do that. And I also urge you to watch The Bear. Second, I looked at Senator Smith, the fiscal note. I just want to tell the committee, I put down unknown because I don't know what the cost is going to be. So I don't know where that came from, but $1 million is $1 million. I mean, that was not from me doing the fiscal note. So I can't explain how or why, but it's there. And that's a lot of money at this time the state can afford or not afford. I don't know where it came from, so I can't answer the question, but it's there. A lot of the state's attorney's offices have contracts with vendors. Those contracts are from 5 to 10 years. So they're very expensive and very long-term. So in order to break those contracts or get more of those contracts will cost a lot of money, which is what I think the fiscal note will be all about from there. So that's where I think the money comes from there. A lot of the small jurisdictions don't have the money. So to answer Senator Sidner's question, what Mr. Gibson said is two things. First, it'll tend for prosecutors to, one, decide cases based on statistics. And we want to keep statistics that are irrelevant, i.e. judges going to statistics, prosecutors going to statistics, and defense attorneys going to statistics out of the system from there. When you put a statistic out there, people get all paranoid and get upset about it from there. So it can be looked at one way, but Mr. Gibson's comment was we don't want to prosecute cases to make statistics better or worse. Second, Mr. Gibson said he was worried about the small jurisdictions. It is a lot of money for a general fund to come forward, and these are local funds that are going to this particular instance. They don't have the money. We welcome if they get the money, but again, it's a long road to hoe when it comes to fiscal note of $1 million. I'm happy to answer any questions. But ask for unfavorable report as to Senate Bill 617. Thank you.
I know it's long, so I'm just going to ask one question of you. I want to make certain, was I clear that if the state had the money, would you all still be unfavorable?
As Mr. Gibson told you, he's still unfavorable.
Okay, I just wanted to put it on record.
Okay.
Thank you.
But I did enjoy the conversation you and I had. So I just want to tell you, we did have a good conversation. You and I had a good conversation about it.
Well, glad you guys had a good conversation about it. I always thought it'd be like, if you're a state's attorney, it would be great to know, just so you could do trend analysis, you could diagnose problems or bad negative trends so that you could go after them and fix them. But so, I mean, I know it kind of exposes you to a political liability, but if you have the open mind of saying, hey, look, I'm open, I'm putting this stuff out there. This is a problem in our department. I'm going to move to fix that. I always thought that'd be a great thing, but yeah. But hey, all right, we'll continue the conversation. Let's go find $1 million. I don't know. All right, with that, that'll end the hearing for Senate Bill 617. We're now going to move on to Senator Sidnor with Senate Bill 551.
All right. Good afternoon. Is everybody up here? Okay, very good. All right, Senator Sitnoff, Senate Bill 551. When an individual is found not criminally responsible, courts commit that individual to the Department of Health for the care and treatment for their mental illnesses. Conditional release is the release of these individuals from psychiatric hospitals while requiring continuing treatment. Under current law, following judicial commitment, these individuals may request conditional release. At a hearing, the individual must show by preponderance of the evidence that if released, they would not be dangerous to themselves or others due to mental illness. Senate Bill 551 enhances judicial procedures involving conditional release for committed persons in a multitude of ways. First, regarding conditional release and discharge hearings, Senate Bill 551 applies the Maryland rules governing discovery in the circuit court regardless of venue. This ensures that individuals found not criminally responsible and petitioning for conditional release have discovery tools to fully exercise their constitutional rights. Second, Senate Bill 551 explicitly states that courts have discretion to extend conditional release for up to 5 years. This clarification is intended to benefit the courts interpreting the law. Third, when a committed person requests a hearing regarding conditional release, Senate Bill 551 requires a hearing. Some courts have noted that in the current law, there is no explicit right to a hearing. Senate Bill 551 ensures that these individuals, their rights will be heard. Fourth, Senate Bill 551 requires courts to notify a committed person's counsel of record if a warrant is issued for the person on conditional release. Providing notice of an alleged conditional release violation grants the individual's counsel the opportunity to investigate the accusations and advocate for their clients. Finally, Senate Bill 551 clarifies that the Maryland Department of Health must provide certain records relating to treatment or conditional release upon request of any party. This modification recognizes that all parties need access to treatment information to foster more productive negotiations and informed decisions. I know there are some amendments that are being worked on or that have been worked on. And it's my understanding that we have a bill where we have defense as well as the state all on the same page. So with that, I would like to okay, I'm about to say, all right. With that, I would like to respectfully request a favorable report for Senate Bill 551. Thank you.
Good evening. Tracy Varder from Baltimore City State's Attorney's Office testifying on behalf of the Maryland State's Attorneys Association in favor of Senate Bill 551 with the amendment specifically requiring the Health Department to provide certain records. As we heard, when a defendant is found not criminally responsible, they're committed to a state psychiatric hospital for inpatient care and treatment until the doctors determine they're no longer a danger to themselves or others. At that point, the court signs a conditional release order which allows a defendant to reside in the community, but he must participate in court-ordered treatment until the court determines that he no longer needs the structure of conditional release to be safe in the community. So while on conditional release, a defendant's compliance is monitored by the Health Department. The NCR statute allows the state and the defense to petition the court if they believe a modification of that conditional release order is warranted. However, in order to adequately file such petitions, all parties require Health Department records. Until recently, we were able to get those records just upon request. Suddenly, without any legal justification, the Health Department began to refuse to provide us with records unless we had a subpoena issued. There's nothing in the statute that requires the parties to subpoena the records. In fact, under courts and judicial proceedings, if a defendant makes his mental condition a defense to his crime, he waives any privilege to the records. So when a defendant pleads NCR, that's an affirmative defense to his crime, claiming that his mental condition precluded him from being held legally responsible. So because he's offering his mental condition as a defense, the state and the defense are entitled to the Health Department records related to that not criminally responsible offense. And these records include records from the defendant's commitment and on his conditional release. So therefore, we support Senate Bill 551 and urge a favorable report with the amendments, specifically the ones requiring the records. Thank you.
Hello again. Good evening, Mr. Chairman, members of the committee. Scott Messersmith from the Wacomico County State's Attorney's Office. I agree with my colleague's testimony, and I'll try to avoid repeating what she said. I will provide maybe some further information and an example. When someone is on conditional release, and as I think the senator said, can be as long as 5 years. When that conditional release is approaching expiration, it can be through the courts renewed for as much as 5 years again. When that person is approaching expiration, we, the state's attorneys, get a letter from the Department of Health advising us as much and stating their position. And frequently we get those letters, and the Department of Health announces to us that they will not seek to extend the conditional release. Please call us if you have questions, which we do, and we ask the questions you might anticipate. We ask, could you please tell us how you reached that decision, why you reached that decision, and the documents that you used, evaluation reports and so forth, that led you to that decision? Can we have them so that we can evaluate, because we are able to file, if we think it's appropriate, to extend the conditional release. And as my colleague said recently, it's been much more difficult to obtain those records, which we need to make the decision about what to do, and if we choose to seek to extend the conditional release, to present a full story to the court so that the court can make a ruling. So we are in support of the bill, and we would ask the committee respectfully for a favorable report. Thank you.
Good evening, Chair, Committee. I'm Sanjeev Varghese with the Public Defender's Office. I'm an attorney in the Mental Health Division. In my role as the attorney at Spring Grove Hospital Center, I represent patients who have been involuntarily admitted, as well as those who have been found not criminally responsible. We urge a favorable report on this bill, Senate Bill 551. When an individual is found NCR, they are committed to the Department of Health for an indeterminate period of time. It could be something from trespass, which would have a 30-day sentence, and they would still be in the hospital a decade later, until the point that they're able to prove by preponderance of the evidence that they are no longer a danger to self, others, or the property of others. So that's a difference between a normal charge, whether it's a district court or the circuit court. Here, this commitment is completely indeterminate. This bill would afford us the rights, my clients, the rights to have full discovery that they're entitled to in a circuit court proceeding, as they have that right to a jury trial once every year if they request that. This would allow that full discovery rights in a proceeding that would go forward before an administrative law judge, which is the majority of our hearings. Additionally, this bill would also provide for, as is testified already, that if it's an extension of 5 years, the current law under criminal procedure 3-122 states that the application for change in conditional release could be extended for up to 5 years. It doesn't say up to 5 years, it has 5 years. This bill clarifies the language that allows the court to say it's needed for up to 1 year, 2 years, or a 5 year as that extension. We urge a favorable recommendation. Thank you.
All right, we're coming to the end of folks. Good evening, everyone on the committee. I would urge you to issue a favorable recommendation for Bill 551. Section 3 is requiring a hearing upon request on any extension or modification of conditional release. I am an attorney with the Public Defender's Mental Health Division. I was in private practice before that. Unusually in this field, there are many sort of strange vicissitudes, including that many judges, when you're opposing an extension of conditional release, or when you are sort of actively requesting a change in conditional release, may deny your right to a hearing and say, in fact, you have no right to a hearing on this issue. It's not clear, it's not clearly in the statute, it's discretionary. And while it seems unusual, there are a vast number of people who, for whatever reason, pled NCR to what you and I might consider quite small crimes, and have been on and off conditional release for decades as a result. This is a significant liberty interest for individuals with disabilities. And the next section, section 4, that I'd ask you to consider, is a balance between safety and advocacy, and really is going to increase the level of notice when it comes to allegations of violations. MDEC exists across the state. Not all jurisdictions are on MDEC. I think we have one left. Even then, I'm still getting sort of these petitions to revoke by US mail, which, you know, by the time I have received that petition to revoke, the person is there. They are there. And in fact, I have on many occasions, based on misunderstandings or inaccurate information, been able to quash warrants in a way that involves a hearing in front of the committing court, involves the state's attorney, involves my client, and, you know, saves a finite and critical resource of inpatient state hospital beds. And for all those reasons, I'd ask you to move this bill forward, and happy to take any questions. Thank you.
Thank you, Mr. Chair. Haven't spoken in about 2 hours. This is my second to last question of the day. Next one will be in the next bill. I can understand why the state's attorneys would want to get the health records and therefore would need some limited discovery in order to accomplish that. But this says discovery in general is permitted. That would include, say, depositions. Do you all really want, on both sides, want to the considerable delay that would result if you wanted to schedule depositions? For example, I've never heard of a state's attorney taking a deposition of a committed person. Is that something, a power that you want under this bill? Or do you think there should be a more limited right just to get healthcare records rather than fully opening up all the civil rules relating to discovery?
I don't anticipate, apologies. I don't anticipate the state's attorney's office asking for depositions. I think that was a piece that the public defender's office requested. But honestly, I don't have strong feelings either way, because I almost feel like that's something we don't have a dog in, or a fight, right? We have no dog in, because if somebody's in the hospital, honestly, our goal is public safety. So if they are sitting in the hospital while their attorney wants to get all these depositions, honestly, that, you know, still satisfies what our agenda is to make sure that people are in the hospital and off the streets that are not criminally responsible. So as far as the state's attorney's office, I think that's just something we're kind of neutral on.
And how about on the other side? You obviously want to get the committed person out as quickly as you can. Suppose the state's attorney decides to take a battery of depositions.
And Senator West, thank you for the question. It's not that we're trying to get somebody out as quickly as we can. The goal is that when we're able to demonstrate that they are not a danger, and we're able to have that court judicial proceeding that establishes they're not a danger due to their mental illness. And right now we have the rights to do depositions. We have the right to, these are civil proceedings that go forward in the circuit court. If we're requesting a jury trial, we have the right to that full discovery through the circuit court. This is changing it to allow that with administrative hearings as well, as opposed to tying it up in a circuit court proceeding. The administrative hearings we have at each of these state hospitals, we have 1 day a week where we have assigned hearings on that day.
Okay.
This would help facilitate those hearings and the exchange of information, because discovery doesn't benefit one party or another.
Okay,
It provides
what
that
I'm
package.
hearing is that both sides are happy with the deposition rule. And if you're happy, I'm happy. Thanks.
Thank you.
No more questions. Sorry, additional questions from the community? All right, seeing none, thank you very much, Senator. Thank you. So that'll conclude the testimony for the proponents of the bill. We have one person signed up in opposition. Is Kimberly Watts. Okay. With that, that'll conclude the hearing for Senate Bill 551. We'll now move on to Senator Carter, Senate Bill 454. Senator Carter, you're up.
I'm gonna get right to it. Thank you for your patience. Don't hold it against me. I didn't make the order. But let's hope we save the best for last. This is a pretty simple and straightforward bill, lacking a lot of the heavy lift and substantive of some of the other bills. It's really a technical fix. It changes simple wording within our criminal procedure statute around expungement law. We passed the Redeem Act, fully believing that after our allotted amount of time, when someone had completed their sentence, they would then be able to get an expungement based on our statute. And that is what we believed would happen. We did not anticipate the issue arising, I believe, of whether a violation of probation had been filed. And so based on a recent appellate court case in Maryland, Abhishek case, which I'm sure some of the other panelists will talk about in more detail, it's been made clear that we have to take further action to ensure that a conviction that was intended to be expunged under our prior bill, would be able to be expunged whether or not there was a subsequent violation of probation. The way that the law operates is that whether the violation of probation was actually determined to be valid or not, just the mere filing of the violation of probation, the existence of it, even if the person, whether it was valid or not valid, even if the person already satisfied it and then finished the sentence, it still serves as a bar to their being able to achieve an expungement. So simply, in sum, we just want to change the language from a satisfied sentence to a completion of the sentence. And so throughout the very simple bill, that's all you'll see. Changing satisfied sentence to completion of a sentence. Thank you.
Christopher Dews, representing the Center for Urban Families, and here in support of Senate Bill 454. Of course, for us, expungements is very important. We work in the workforce development space. And just to flesh out a little bit more for those of you who are not already familiar with the Abhishek case, this is an individual in 2008 who had a theft misdemeanor under $500 and was put on probation for, I believe it was 1 year. And his violation was for cannabis possession, which, as many of you know, is currently legal. And so after that happened, about 10 years later, he then tries to go for the expungement, but he was informed 10 years later, well, technically 12 years if you include the hearing and the appeals, that he was not eligible for expungement. So, you also know that we passed the unit rule we passed, hopefully for the unit rule repeal, but we passed the Redeem Act last year, which cut the expungement waiting periods in half. And so October the 1st came along. Many of our individuals, our clients, were trying to get their records expunged, having charges from 20-something years ago, and they cannot get it expunged because they had a violation. The purpose of this piece of legislation is simply to say that once you have served your entire time, once you've done, even if you've had to do a second sentence because of the violation, if the charge is eligible for expungement as has been deemed worthy eligible by the Maryland General Assembly, then we should allow that individual to get the expungement. We already have a check and balance system, and that is in Criminal Procedure 10-110 F1, which still leaves, this bill does not touch at all the state's attorney's ability to object, the victim's ability to object, and then leaving it in the court's hands to simply say whether or not it's in the interest of justice and if it should be allowed. So with that, we just ask that you do this slight technical fix so that we can increase access to expungement for those who deserve it. Thank you. Excellent. Thank you very much, Mr. Dews. Whoever like stand up. You can go, Meg.
Good evening, everyone. My name is Megan McDermott. I'm a chief attorney at Maryland Legal Aid, and we urge a favorable report on Senate Bill 454. I'd like to reiterate a bit of what Chris Dews just said. This bill simply clarifies that a person's criminal sentence ends when their contact with the courts, correctional facility, or parole and probation ends. It does not limit prosecutorial or judicial discretion. The expungement statute allows the state to object and the court to set in a hearing where the court may order or deny an expungement based on the nature of the crime, the history and character of the person, the person's success at rehabilitation, whether the person is a risk to public safety, and whether the expungement would be in the interest of justice. Legal aid is an expungement court several times a month across the state, and the state can and does object to expungements for probation violations and many other reasons. Sometimes the judge grants the expungement for our client, and sometimes they don't. The expungement statute also already addresses recidivism. Individuals who have been convicted cannot apply for expungement in most cases for 5 to 10 years. If during that time they are convicted of another offense, the clock restarts, and they cannot apply for expungement for the first offense until that second offense becomes eligible. These provisions mean that serial recidivists are not ever going to be eligible for expungement. That said, happily, most individuals with therapy and time and determination are able to change. Often the last step in that change is an expungement. With Senate Bill 454, we are simply asking this body to recognize that individuals may not be ready to change 1 year after a criminal charge, but they shouldn't be punished 10 and 20 and 30 years on. Thank you.
Good evening. My name is Harold Coleman, and I'm a resident of District 10. I support Bill 454, House Bill 73, an expungement for someone like me, myself, have served the time, but has a probation violation. In 2022, the Court of Appeals ruled that any probation violation means a conviction is indefinitely ineligible for expungement under legal interpretation, that violations that the individual has not satisfactorily completed the sentence, regardless of the nature of the violation. This impacts me because I've had violations from 1988, 1997, and after I served 10 years, my violation, for urinalysis test was a sentence for a 2-year probation for car theft. I also was homeless for some time in my younger years, and I was placed on 5 years probation for 4th-degree burglary because I was arrested for sleeping in an empty garage. I received a violation during this probationary period because I defended myself, and defended myself for a fight I received a 2nd-degree assault for. As you can see, my violations vary by individual case, and preventing expungements purely on basis is unwise. My life was never easy, but I've been working for the Maryland Transportation Authority for 16 years at the Bay Bridge here in Annapolis. And on many occasions to testify on criminal expungement bills in the past, so that people with my similar history can move on from their past and obtain relief. I served my time to do not believe that my violation of probations in the 1980s and 90s should bar me from getting my expungement in 2024. Please, favorable on this bill.
Thank you, Mr. Coleman. Are there any questions for? All right, I see. Okay, go right in. I'm sorry.
It's been a long day. Hi, my name is Mary Denise Davis, and I am with the Office of the Public Defender, and we are in support of Senate Bill 454. Senate Bill 454 will change the language of the expungement statute to what I believe we all believe, that everyone deserves a second chance when they have rehabilitated themselves. I like to think of expungement as a form of legal redemption, and when I have clients at the expungement hearings, I think that is what they are telling the judge. They are a changed person and they deserve this second chance. The change in the language is needed, and we have all talked about the Abhishek decision, and that's why it's so important that we change that language. That case basically has said there are no second chances for individuals who have violated their probation, no matter how minor that violation may be. You're never going to get the otherwise eligible case expunged.
We all know and have family, friends, neighbors, and some of us are part of the court system. And we know that rehabilitation is not quick and it's not easy. And sometimes it takes much longer than a period of probation that's been imposed by the courts. I don't think we should let the language stand in Abhishek. We do not want to slam the door on individuals who have rehabilitated themselves and do so outside sometimes the short period of probation. We should always keep that door open, no matter how long it takes. I would ask that everyone consider and recommend a favorable report. I think this expungement bill is a very, very important expungement bill for all of our clients, everyone's clients, and also for every impacted individual in Maryland. So thank you very much.
Thank you, Mr. Chair, and this will be my last question of the day. So I'm not sure this works when a condition of probation is restitution. So let me read a paragraph from the opposition filed by Rich Gibson, the state's attorney for Howard County, and ask the sponsor of the bill if she could respond to it. So here's what Mr. Gibson says. He says, a person could be convicted of theft and placed on probation. The judge may order the defendant to pay restitution to the victim. That individual, despite the ability to do so, could then just choose to pay nothing. With the restrictions now placed on judges by the Justice Reinvestment Act, the most a judge could do is put the person in jail for 15 days. For that reason, there are many judges who therefore don't bother with violations of probation. They may choose to close out the case unsatisfactorily and enter a judgment of restitution and possibly refer the judgment and costs to central collection. Now, after the set time period, the defendant can file for expungement and wipe the record clean of the PBJ or conviction along with any obligation to the victim. So it appears that this bill could provide a route for a person who's been convicted of a crime in order to pay restitution to avoid paying the restitution by vamping during the course of the probation period and then getting expungement, which would wipe out everything, including the obligation to pay restitution. So how do you respond to that?
Thank you. I disagree with that analysis, and I'm happy to hear from the experts that do this every day, the expungement work every day, as I do not, but I do it. So in a situation where someone has an underlying offense and then they have a violation of probation, even if the cause of the violation of probation is restitution, they can be violated and ordered in that violation of probation hearing or situation to serve whatever the underlying offense is. So in a situation where someone has a violation of probation and restitution is a part of it, the remedy, even if it's a PBJ, is often to simply honor the violation of probation and give them the full time they would have had under the underlying offense because they violated the probation. In a situation where there's a violation of probation and the person does not pay restitution and the judge makes the decision to close it out because they don't have to, that would still be a permanent debt on that person. So it's not as if they're ever going to skate out of the restitution. So the purpose of the bill is to really give honor to the intent, which is that a person has a conviction. We believe after a certain amount of time, they ought to be able to overcome the conviction and be restored to full citizenship. The bill simply says that the existence of the violation of probation should not serve as a bar. And once the violation of probation is satisfied, once the underlying offense is satisfied, that's considered completion of the sentence. Thus, the person would be eligible for expungement 3 years later, at least.
Here we go. This is not my area of law, but according to Mr. Gibson, with the
I understand what he said because you already read it, and I thought I responded to it.
Well, you said the judge could put the person back in jail for the rest of the probationary period. Mr. Gibson says because of the Justice Reinvestment Act, the most a judge could do is put the person in jail for 15 days. So I don't know what the answer to this is. It seems to be you and Mr. Gibson disagree on this. And I guess we're going to hear Mr. Kroll in a minute or two, so maybe he could answer this.
Well, I don't know that you want to go jump to Mr. Kroll because I already said, I think the public defenders that do the expungements all the time are probably in a better position to answer it.
Okay, maybe somebody who does this could answer the question.
So I'm pretty good at my job, but I can say that I've never successfully gotten an expungement for a client who owed restitution. The state does regularly object if someone owes restitution, and every time we've had a hearing like that, the expungement is denied.
Okay, so you're saying that when the expungement is requested, the court would have the opportunity to take a look and see whether the restitution had been paid, and if not, deny the expungement.
That's right.
Okay, thanks. That helps.
To say, as a public defender, I wish every time I went into a violation probation hearing for my clients that I knew they could only get 15 days. That's just not the case. So it's the JRA, I think what is being referred to is the technical violations, which is vastly different than a violation. Yeah, or violation because of a subsequent conviction and all those things. And so my clients generally are backing up the entire time that was suspended.
Okay.
It's not just 15 days.
Thank you. Thank you.
Thank you.
Oh,
What?
okay.
What?
No, nothing. That's just,
Oh,
yeah.
oh,
No other question? Okay. Thank you.
Thank you.
All right. Is Steve Kroll signed up? You're in support of the bill, or you're in opposition? Yeah, okay. That's what I thought, but it says favorable. I was like, all right, all right.
Was it though?
Well, let's hold on before we get to the
I'm sorry. We do have.
yeah, I guess I'm saying before we get to the opposition, let's get to the favorables. So is Allison Stillingham, George Townsend? Who else is here? It's Carlos Battle.
Yes.
Oh, there you go. Betty, oh, that's virtual. All right. All right.
Good evening, Mr. Chair and members of the committee. My name is Allison Stillinghagen. I am a staff attorney with the Human Trafficking Prevention Project, which seeks to reduce the collateral consequences of criminal legal involvement for sex workers and survivors of human trafficking. At the HTPP, we work with clients who have histories of human trafficking and survival sex work, almost always fueled by a lifetime of complex trauma, homelessness, poverty, and substance use. All too often, these experiences lead to convictions for the types of low-level crimes that are eligible for expungement under our current law. Healing from trauma and recovery from addiction is rarely, if ever, a linear process, and we know that struggling and relapsing in the face of life obstacles is both common and expected. Unfortunately, for a person who is on probation, the difficult road to recovery from both trauma and substance use disorder often results in probation violations. These happen in the form of a failed drug test, failure to complete mandatory rehab, or a missed meeting with a probation officer. And under current law, following the Abhishek ruling, these common and expected challenges permanently bar a person from criminal record relief when a charge would otherwise be eligible for expungement. Healing from trauma requires not only great personal strength, but also the ability to utilize our systems in this state to move onward and upward in life. Blocking criminal record relief due to a mistake that may have taken place years, if not decades ago, restricts healing. For these reasons, the Human Trafficking Prevention Project supports Senate Bill 454, and we urge a favorable report. Thank you.
Good evening, Senate. My name is Carlos Battle, and I'm a reverend at New Shiloh Baptist Church in the District 40 in West Baltimore. And I support Senate Bill 454, House Bill 73, to allow for expunged charges that may be involved in probation, violation of probation. About 24 years ago, I received possession with intent to distribute charge and took a plea deal because I was addicted to drugs and did not want to spend time in jail. I was sentenced to 3 years probation, 10 years suspended sentence. I violated while on probation for missing a meeting and served the suspended sentence 10 years, making my charge permanently ineligible for expungement. While incarcerated, I became pastor of the Sykesville Correctional Institution and attended Anne Arundel Community College. I also took classes in digital literacy to keep up my skills and worked in the library. Upon release, I came home but struggled to find employment. After years of searching, I found a job at Walmart, worked my way up to manager, while earning a CERB safe certification allowed me to become a chef. I then moved on to Sinai Hospital as a chef for 10 years and currently work at Johns Hopkins University. Today, I'm a minister at the New Shiloh Baptist Church, attended by my friend and representative, Kwaisi Mfumwe. I lead the prison ministry, substance abuse ministry, and on the evangelist team for 6 years. I have been a member of the We Our Us movement, distributing resources to the community, aiding drug addiction, employing the youth with jobs, and giving hope to the streets of Baltimore. I also just opened a deliverance housing for guys coming home from prison. God has done wonders in my life. I wish I could help the other brothers. And that's what I'm here for. Amen.
Chair Smith and members of the committee, thank you for the opportunity to testify tonight. My name is George Townsend. I'm a workforce development attorney at Maryland Volunteer Lawyer Service. I'm here today to urge the committee to issue a favorable report to Senate Bill 454. This bill corrects wording in the state code that the appellate court recently determined it disqualifies a case from expungement eligibility when the petitioner did not satisfy probation. All it does is adjust the language in the expungement statute so that when a person has been convicted of a charge that is on the list of eligible charges and they have completed the time period required by that statute, they are not prohibited from expunging the charge simply because the probation was closed as unsatisfied. In our written testimony, we cite an example of an MVLS client who has struggled to access senior housing because of a criminal charge on her record from the 1990s. The charges were for offenses that are listed as eligible in the expungement statute. However, she was sentenced to probation, and due to substance abuse issues she was experiencing at that time in the 1990s, her probation was closed as unsatisfied. She's therefore ineligible to expunge that case or those cases. In fact, if she had instead been sentenced to incarceration rather than probation, she would have satisfied her sentence years ago and would be eligible for expungement today. MVLS clients frequently report being told by employers or professional licensing bodies that they will become eligible for specific opportunities if they can expunge certain specific cases off their record. These are often opportunities that would help the individual to turn their lives around and contribute to their communities. Denying them a clean slate because they have a notation of unsatisfied in their record harms the individual while doing nothing to further the ends of justice. MVLS urges a favorable report on this bill. Thank you for the opportunity to testify.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you all very much.
Thank you.
Mr. Battle, thank you very much for your testimony. That's great. All right, do we have Antonin Quarles? Is he here? Anthony? Oh, he's not here? Okay, I got it. All right. And we don't have anyone else. Anyone else? No one virtually? Harold Coleman? Oh, he does. That's right. All right, so then that'll conclude the hearing for the proponents of the bill. We'll now hear from the opposition panel, Mr. Schellenberger. Sorry, Mr. Steve Kroll. Kroll is here, not Schellenberger. You know, it's funny. And David Russell. We had you signed up in the proponents first, and then anyway.
I'm going to make it clear I am an opponent with testimony. And good evening, Mr. Chairman, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator, the Executive Director of the Maryland State's Attorneys Association. And when I was a assistant state's attorney in Baltimore County for 26.5 years, I did expungements. That was my job. So this is a field I'm very familiar with. So let me answer Senator West's question when reading Mr. Gibson's statement. Mr. Gibson is 101% correct, and I stand by it. If there is restitution under this statute, and if the satisfactory word is eliminated, that victim will not get their restitution. Will not get their restitution. Correctional Services Article 6-101 is a technical violation section, and that's what I would encourage everyone to look at. And it specifically says what Mr. Gibson said about the 15-day jail sentence from there. So I stand by Mr. Gibson's statement 101%. Not sure where the public defender got their information from, but I welcome a conversation with them, you, or anybody else about what Mr. Gibson said, which I stand by from there. And I did expungements. Let me explain a little bit of brief history about the expungements. When someone's placed on probation, which is about 90% of the cases that I dealt with, I can't say it's a statewide, but when I did the pre-jury trial docket, a lot of people got probation before judgment or just general straight probation. And they were put on probation. In today's world, in today's society, judges do not like to put people in jail for violations of probation unless it's a subsequent offense called a Rule 4 violation. So the small technical violations, didn't go to a hearing, didn't do this, didn't do that. Most judges that I've experienced across the state in my 12 years as been coordinator do not like to violate people and send them to jail for it because of the consequences, direct and indirect, about what happens when you violate somebody for probation. So unless it's a Rule 4, which is a subsequent violation, they get an extended chance. They got a chance for probation. They got a chance on probation. So the only reason we're saying that this law should not change, and we are asking for an unfavorable report, is because they've gotten really 2 or 3 bites of the apple. The 4th time is for a subsequent violation and conviction from there. So it's not really a first or second time. And it's for a violation, as I said before, for Rule 4. So what we're suggesting in conclusion is as follows. Keep the satisfactory on the record. If you satisfy probation, you deserve an expungement. I'm looking at this committee and saying, I agree on a second chance. If you satisfy it, you deserve a second chance. But keep the word satisfied so restitution is the same, and people that are satisfactory deserves that effort.
All right, we're going to go to Senator West because you have a follow-up question.
Well,
you're right.
We're gonna deduct 10 questions from next week for that.
well, I wasn't expecting that quite forthright response. So, but let me ask you to respond directly to what the public defender told me, which was that at the time that the judge rules on the expungement, if the restitution had not been paid, the judge would not grant the expungement until the restitution were to be paid.
If satisfactory is removed.
What's your response to that?
If satisfactory is removed, the judge could do it. Could do it. There's nothing preventing he or she, that judge, from doing it. With the word satisfactory staying in there, they could not do it. Could not do it. And that's what I'm suggesting. Keep the word satisfactory in the bill. And I have no problem about people who get an expungement that are eligible for it, that successfully completes it. Don't cheapen it for those that do it right. People make mistakes. They deserve a second chance, and they deserve an expungement if they successfully and satisfactorily complete their probation.
Right.
But take the word out, judge could easily do it.
Sorry about the extra question, but I think it was worth it.
No, you're not.
Thank you.
You're not sorry. All right. All right. With that, that'll conclude the hearing for Senate Bill 424 and our hearings for the day and the week. Just real quick, we are not going to vote on Monday, so we're going to vote on Tuesday after the floor. The members just want to say it's been a long week, so thank you all for hanging in there. This has been great. Have a good weekend. See you on Monday.